1. Historical background. 1. Evolution of Indian Constitution, a journey through key acts and reforms. 1. Constituent Assembly of India. 2. Critiques of the Indian Constitution. 2. Constitutional amendments in India. 4 types of amendments. For informal amendments. For the necessity of constitutional amendments. For issues with constitutional amendments. 5. Criticism of the amendment procedure. 5. Way forward. 5. 106th Constitutional Amendment, 2023. 6. Basic structure of the Constitution. 6. 3. Significant provisions in the Indian Constitution. 8. Significant provisions, an in-depth analysis. 8. Preamble. 9. Significance of preamble. 9. Amendability of preamble. 9. 4. Fundamental rights, Part 3, Article 1, 2, 3, 5. 12. Classification of fundamental rights. 12. Distinctive features of fundamental rights. 12. Article 12. 12. Article 13. 12. Right to equality, Article 14 to 18. 13. Right to freedom, Articles 19-22. 15. Right against exploitation, Article 23-24. 17. Right to freedom of religion, Article 25 to 28. 18. Cultural and educational rights, Article 29-30. 18. Remedies for enforcement of rights, Article 32. 19. Writs. 19. Armed forces and fundamental rights. 20. Martial laws and fundamental rights. 20. Right to property. 20. Exceptions to fundamental rights. 21. Issues and challenges pertaining to fundamental rights. 21. Issues in news. 22. Conclusion. 23. 5. Directive Principles of State Policy, DPSBs, Part 4, Article 3, 6-51. 24. Conflict between DPSB and FR. 24. Uniform Civil Code. Quest for a Uniform Civil Code, a path towards a unified nation. 25. Right to health. 26. 6. Fundamental Duties, Part 4A, Article 5(1)A. 27. Rights and Duties. 27. 7. Citizenship, Part 2, Article 5-11. 29. Citizenship Act 1955. 29. 8. Scheduled and Tribal Areas, Part 10, Article 244-244A. 31. Fifth Schedule. 31. Key features of Scheduled Areas Administration. 31. Sixth Schedule. 32. Unit 2. Issues and challenges pertaining to the federal structure. 9. Exploring issues and challenges in India's federal structure. 34. Indian Federalism, a unique model. 34. Features of Indian Federalism. 34. Unitary features of Indian Constitution. 34. Challenges to Indian Federalism. 35. Asymmetric Federalism in India. 35. Center-state relationship. 36. Ways and means to better manage center-state relationship. 36. Niti Aayog, a tool to promote cooperative federalism. 37. Inter-state river water dispute. 37. Demand for smaller states. 38. Article 370. 39. Government of National Capital Territory of Delhi, Amendment, Act 2023. 40. Unit 3. Separation of powers between various organs. 10. Separation of power and functional overlapping. 42. Constitutional provisions and the separation of powers. 42. Different models of separation of powers. 42. Functional overlap between executive and legislature. 42. Functional overlap between judiciary and legislature. 43. Functional overlap between judiciary and executive. 43. Doctrine of checks and balances. 45. Unit 4. Parliament and state legislatures, structure, functioning, conduct of business, powers and privileges and issues arising out of these. 1. Parliament and state legislatures, structure, functioning, conduct of business, powers and privileges, and issues arising out of these. 46. Features of parliamentary form of government. 46. Functions of the parliament. 46. Issues faced by Indian legislature. 46. Productivity in the parliament. 47. Suggested parliamentary reforms. 47. Parliamentary privileges. 48. Role of opposition. 49. Low participation of women in politics. 49. Anti-defection law. 51. Role of the presiding officer. 52. Parliamentary scrutiny. 54. Unit V. Structure, organization, and functioning of the judiciary. 1-2. Judicial system in India. 56. Comparison of Indian and other judicial systems. 56. Various significant roles that judiciary plays. 58. Important judicial concepts. 58. Judicial pendency. 59. Judicial appointments. 60. Removal of judges. 61. Judicial accountability. 61. Judicial activism and judicial overreach. 62. Contempt of court. 64 Women in Judiciary. 65. Fast-track courts. 66 Regional Bench of Supreme Court. 67 NALSA. 68 Judicial infrastructure in India. 69. 1.3. Dispute redressal mechanism. 71 Alternative Dispute Resolution, ADR. 71 Lok Adalat. 72 Gram Nihilaeus. 72 Tribunals, Part 14. Article 323A, 323B. 73 Tribunal Reforms, Act, 2021. 74 Online Dispute Resolution. 75. Unit 6. Devolution of powers and finances up to local levels and challenges therein. 1.4. Local Self-Government, Part 9, Part 9A. 77. The Panchayats. 77 Issues and challenges faced by Panchayati Raj government. 77. Government efforts for empowering PRI. 78 Steps to be taken. 78 Role of women in Panchayati Raj institution. 78 The municipalities. 79. Unit 7. Appointment to various constitutional posts, powers, functions, and responsibilities of various constitutional bodies, statutory, regulatory, and various quasi-judicial bodies. 1.5. Comptroller and Auditor General of India. 82. Duties and power of CAG. 82. 1.6. NCSC, NCST, and NCBC. 84 Composition. 84 1.7. UPSC and SPSC. 86. Constitutional Provisions. 86 UPSC Viz A, Viz SPSC. 86 Independence of Commission. 86 Functions and Limitations. 86. 1.8. Election Commission of India. 88. Introduction. 88 Powers and Functions. 88 Independence. 89 Concerns with Election Commissioners. 89 Way Forward. 90. Political parties in the Election Commission of India. 90 Simultaneous elections, one nation, one election. 91 EVM and associated issues. 92 NOTA. 94 Model Code of Conduct, MCC. 95 Election funding. 96 Criminalization of politics. 98 Politics of freebie. 101 AI and elections. 102. 19. Delimitation Commission. 104 Background. 104 Constitutional Provisions. 104 Delimitation Commission. 104 Functions of the Delimitation Commission. 104 Criticism of the Delimitation Commission. 105. 20. Attorney General of India. 106. Introduction. 106 About AGI. 106. 21. National and State Human Rights Commission. 107. Introduction. 107 Way Forward. 108 Conclusion. 108. 22. Central and State Information Commission. 109. Unit 8. Structure, Organization, and Function. OF the Gov. 24. Union Executive and State Executive. ILL. Introduction. ILL The President of India. ILL Criticism of the Office of the President. 112 The Vice President of India. 112 Constitutional Provisions. 112 Powers and Functions of Vice President. 113 Elections of President and Vice President. 113 Term, Qualification and Removal of the President and the Vice President. 114 The Governor of State. 114 Term of Governor, Article 156. 114 Qualification, Article 157. 114 Nominated vs. Elected Governor. 114 Powers of President and Governor. 115 Privileges and Immunities enjoyed by President and Governor, Article 361. 117 Comparison of veto power of President and Governor. 117 Ordinance making power of the President and Governor. 117 Pardoning power of the President and Governor. 119 Discretionary powers of the President and Governor. 120. Unit 9. Salient features of the 30. Representation of People's Act. 131. Introduction. 131 Key features of the Act. 131 Provisions regarding disqualifications in RPA, 1951. 131 Registration of political parties. 132. Unit X. Comparison of the Indian Constitution. 31. Comparison of the Indian constitutional scheme with other countries. 137. India and USA. 137. Introduction. 109 Conclusion. 109. 2.3. Central Vigilance Commission, CVC. 110 Independence of CVC. 110 Way Forward. 110 Conclusion. 110. of the Executive, Minister IES and Departements Remit. Issues related to Governor. 121 Recommendations of Sarkaria Commission. 121. 25. Prime Minister and Chief Minister. 123. Constitutional Provisions. 123 Powers and Functions of PM and CM. 123. 26. Council of Minister. 125. Constitutional Provisions. 125 Responsibility of Ministers. 126-27. Cabinet System in India. 127. Role of Cabinet. 127 Cabinet Committees. 127. 28. Ministries of Government. 129. Constitutional Provisions. 129 Hierarchy of Ministers in India. 129 Parliamentary Secretaries. 129 Conclusion. 129. 29. Parliamentary Committees. 130. Introduction. 130. Representation of People's Act. Right to Know. 133 Corrupt Practices. 134 Electoral Offences. 134 Paid News. 135 Voting Rights to Non-Resident Indians through Postal Ballot. 136. Tynal Skim EW with that of other countries. India and Britain. 140 India and France. 141 India and Japan. 142 India and South Africa. 143 Wallah. IROAI Foundation Euro UI courses. Live recorded GS classes. CSE classes. Daily MCQs plus KM mains question. Our regular doubt sessions. Songkalp 2026. English F-A-T. Titan 2025. English. Starts from 29 for 99. Prahaar 2025. English FT-T. For extra discount. UPSC OPTONALCURC 2025 English FT-4T. Sociology. Anthropology. Mathematics. At just 58, $9.99. For extra discount. 992-061-3613 PW. Live 1 Historical background. The Indian Constitution serves as a lasting testament to India's successful transformation from a colony to a sovereign republic. This dynamic document guides the democratic operation of the world's most populous nation. It embodies an inclusive vision that has steered India's immense diversity towards a unified national identity. Evolution of Indian Constitution, a journey through key acts and reforms. Government of India ACT, 1919 Montague, Chelmsford Reforms, Indian Members and Executive Council. The Act mandated the inclusion of 3 Indians in the Viceroy's Executive Council. Bicameral Legislature, a 2-house legislature was established, the Legislative Assembly and the Council of State. Decentralization, the Act relaxed the central control over the provinces by demarcating and separating central and provincial subjects. Diarchy at provinces, a diarchy was introduced at the provincial level, dividing provincial subjects into transferred and reserved ones. Central Public Service Commission, the Act provided for the establishment of a Public Service Commission, leading to the establishment of the Central Public Service Commission in 1926. Significance O increased Indian participation. It aimed to expand Indian involvement in governing the country. This marked a shift towards eventual self-rule. O legislative reforms. It introduced bicameral legislatures and expanded voting rights, sparking political awareness and engagement. O role of diarchy. The Act implemented a partial system of self-government in provinces, giving Indians some administrative control. Government of India ACT of 1935. The Government of India Act of 1935 was an important step towards establishing a constitutional mechanism in India. It was mainly influenced by significant political developments at that time such as Simon Commission Report, Nehru Report, Roundtable Conferences, etc. Salient features of the Act. All India Federation established a framework for a federal system with division of powers, but princely states didn't join, preventing its formation. Provincial autonomy, 1937 to 1939 granted limited self-governance to provinces with ministers advising the governor. Diarchy at center, not implemented, divided central subjects into reserved and transferable categories, but never implemented. Bicameral legislatures, limited, introduced upper houses in some provinces with restrictions. Expanded representation, increased voting rights, around 10% of population, and separate electorates for specific groups. Restructured administration, abolished Council of India, established advisors for the Secretary of State, and created public service commissions, federal, provincial, joint. Federal court. The Act provided for the establishment of a federal court with both original and appellate jurisdictions. Significance of the Act. This Act was the most comprehensive and extensive legislation enacted by the British Parliament for the governance of India. Despite its limitations, it marked a milestone towards a completely responsible government in India and provided Indians with practical experience of running the government. Indian Independence ACT of 1947. Salient features of the Act. End of British rule. The Act declared India and Pakistan as two independent dominions from August 15, 1947. Power to the Constituent Assemblies. The Act gave the Constituent Assemblies of India and Pakistan the power to frame their respective constitutions. Partition of India. The Act provided for the partition of British India into India and Pakistan. Significance. The Indian Independence Act of 1947 marked the end of British rule in India and declared India and Pakistan as two separate dominions. Keywords: dual government, centralization of power, limited governance, indirect representation, communal electorate, All India Federation, diarchy, provincial autonomy. Constituent Assembly of India. The British government's Cabinet Mission Plan of 1946 included the acceptance, in principle, of a constituent assembly. The Constituent Assembly consisted of representatives who were indirectly elected and members nominated from the princely states. It met for nearly 3 years, deliberating and debating the framework for an independent India. Key figures like B.R. Ambedkar played a crucial role in shaping the document. The Assembly ultimately adopted the Constitution on November 26, 1949, paving the way for India becoming a republic on January 26, 1950. Criticism of the Constituent Assembly: lack of representativeness. Critics argue the Assembly wasn't truly representative as members weren't directly elected by the people through universal adult suffrage. Not a sovereign body. Some claim the Assembly wasn't fully sovereign because it was established by British proposals and functioned with their permission. Lawyer-dominated. Critics point out a high number of lawyers in the Assembly, potentially influencing the Constitution's complexity and legalistic language. Hindu dominance. Some critics, like Winston Churchill, argued the Assembly primarily represented the Hindu majority, neglecting other communities. Time-consuming process. The drafting process took nearly 3 years, leading some to criticize its length. However, these criticisms were countered by the fact that the Assembly represented a wide range of social, political, and economic viewpoints, and its prolonged deliberations were a necessary result of its efforts to accommodate and reconcile these divergent views. Critiques of the Indian Constitution. Carbon copy of the 1935 Act. Critique. British constitutional expert Sir Ivor Jennings argued that the Indian Constitution heavily borrows from the Government of India Act, 1935, with many provisions copied directly. Counterargument. Dr. B.R. Ambedkar countered this claim, clarifying that borrowed elements primarily dealt with administrative details. The Constitution embodies the vision of an independent India, including fundamental rights, directive principles, and other features distinct from the 1935 Act. Bag of borrowings. Critique. Critics often label the Indian Constitution as a borrowed constitution or a bag of borrowings, lacking originality. Counterargument. While the Constitution incorporates concepts and provisions from various world constitutions, the framers cleverly adapted them to India's unique context and needs. As Dr. B.R. Ambedkar pointed out, this criticism stems from a superficial understanding of the Constitution's essence. Lawyer's paradise. Critique. Sir Ivor Jennings criticized the Constitution's legal language and phraseology as complex, calling it a lawyer's paradise. Counterargument. Precise legal language is essential to prevent misinterpretations and misuse. The Constitution serves the people but must also function effectively within the legal system. Excessive length and detail. Critique. Critics argue that the Indian Constitution is excessively lengthy and detailed, making it cumbersome. Counterargument. The extensive detail is intentional, creating a comprehensive document that guides every aspect of governance and minimizes ambiguity. This length reflects the Constitution's inclusiveness and thoroughness. Federalism with a unitarian bias. Critique. Critics argue that the Indian Constitution leans towards a unitary system, giving the central government more power than states. This undermines the true spirit of federalism. Counterargument. Proponents argue that a strong central government is necessary for national unity and to address issues like national security and economic development. Additionally, the Constitution provides mechanisms for cooperative federalism, where the center and states work together. Too rigid or too flexible. Critique. Some argue the Constitution is too rigid, making it difficult to adapt to changing social and economic realities. Amending it is a complex process. Counterargument. Others believe the Constitution's flexibility allows for necessary modifications through amendments. It strikes a balance between stability and responsiveness to change. Keywords: carbon copy, lawyer's paradise, bag of borrowings, excessive length. Recent developments. 106th Amendment, 2023, introduced reservation for women in Lok Sabha, state legislative assemblies, and Delhi Assembly. 1/3 of all seats will be reserved for women, including those reserved for scheduled castes and scheduled tribes. 105th Amendment, 2021, restored the power of state governments to identify and classify socially and educationally backward classes, SEBCs, for affirmative action programs. Fix Andy's SH Course 20. GW June 24, 2024. Copyright 60 hours. Essay. Price. Ethics 15,000 yen. Offline. 10,000 yen. Online. Ethics discussion in question-answer format underscore per 7. Coverage of 150-plus ethics and 50-plus essay questions. Theme-wise essay coverage. 2 ethics and 2 essay full-length tests with evaluation. Evaluation by faculty. 1 sessions with faculty for personal doubts. Special focus on time management, tackling philosophical essays. Case studies. The Indian Constitution serves as a lasting testament to India's successful transformation from a colony to a sovereign republic. Pundit Jawaharlal Nehru once highlighted the dynamic nature of a constitution, stating that while we strive to make our constitution as permanent and solid as possible, it should also allow for flexibility to adapt to the nation's growth and changing conditions. The Indian Constitution, while a robust framework, allows for necessary changes through an amendment process. This ensures the Constitution adapts to evolving needs and circumstances. Until now, the Constitution has been amended 106 times. The process of amendment is defined in Article 368 of the Constitution. Types of amendments. The Indian Constitution can be amended in 3 ways. Amendment by simple majority of Parliament. This includes amendments related to admission or establishment of new states, alteration of boundaries of existing states, abolition or creation of legislative councils and states, etc. Amendment by special majority of Parliament. Under Article 368, this includes amendments to fundamental rights, directive principles of state policy, and all other provisions not covered by the first and third categories. Amendment by special majority of Parliament and ratification by state legislatures. Under Article 368, this includes amendments related to the election of the President, the extent of the executive power of the Union and the states, Supreme Court and High Courts, distribution of legislative powers between the Union and the states, representation of states in Parliament, power of Parliament to amend the Constitution and its procedure. Informal amendments, judicial interpretation. The Supreme Court of India plays a crucial role in interpreting the Constitution. Over time, their judgments can effectively change how the Constitution is applied, even if the written text remains the same. For instance, the concept of the basic structure of the Constitution, which cannot be amended, was established through judicial interpretation. Constitutional conventions. These are uncodified practices that, though not strictly part of the Constitution, are followed due to tradition or precedent. An example is the convention of the Prime Minister being the leader of the majority party in the Lok Sabha, lower house of Parliament. These conventions can evolve over time, shaping how the government functions. Keywords: judicial interpretation, conventions, basic structure. The necessity of constitutional amendments, evolving social order. With evolution of society, weaker sections need to be protected with adequate safeguards to maintain robust social order. For instance, a 106th Amendment, 2023, introduced reservation for women in Lok Sabha, state legislative assemblies, and Delhi Assembly. Strengthening institutions. Amendments can improve the functioning of government. Anti-defection law. The 52nd Amendment introduced the anti-defection law to curb political instability caused by defections from parties. Technological advancements. New technologies can necessitate legal frameworks. For instance, privacy in the digital age. A debate exists on amending the Constitution to explicitly include the right to privacy in the digital age, considering the rise of data collection and surveillance. Fulfilling social contracts. For example, the 73rd and 74th Amendments, which were introduced to realize the dream of Gram Swaraj, as envisaged by Mahatma Gandhi. Structural adjustments. Amendments like the abolition of the right to property from fundamental rights were required for economic considerations. Addressing practical difficulties. Sometimes, amendments streamline processes. GST, Goods and Services Tax. The 101st Amendment introduced GST, a unified tax system aimed at simplifying indirect taxation across India. Issues with constitutional amendments. Frequency of amendments. India's constitution has been amended frequently compared to other democracies, raising questions about stability and respect for the original document. Some argue the frequent amendments indicate a lack of foresight in the initial drafting or a tendency for political expediency over long-term vision. Shift of power. Excessive amendments might alter the balance of power between various institutions, such as the parliament and judiciary, center, and states, leading to instability. Lack of public deliberation. The current process relies on parliament and state legislatures, with limited public involvement. Recent amendments haven't had extensive public discussions or consultations with stakeholders, raising concerns about democratic legitimacy. Potential for majoritarianism. A strong central government with a large majority could push through amendments without considering minority viewpoints. Concerns exist that amendments impacting the federal balance or fundamental rights might be passed based on the ruling party's majority alone. The basic structure doctrine debate. There's ongoing debate about the extent to which Parliament can amend the Constitution's basic structure, unchangeable principles. Landmark Supreme Court judgments established the basic structure doctrine, but its precise scope remains debated, creating uncertainty around the amendment process. Criticism of amendment procedure, centralized control. Critics argue that the power to amend the Constitution rests heavily with Parliament, potentially neglecting the federal balance by giving less weight to the voice of individual states. Limited public participation. The current amendment process lacks provisions for direct public involvement, such as referendums. This could enhance the democratic legitimacy of amendments by incorporating public opinion. Absence of a dedicated body. Unlike some nations, India doesn't have a designated body like a constitutional convention specifically tasked with proposing amendments. This could potentially streamline the process and ensure a more comprehensive review. Similar to ordinary bills, except for the special majority requirement, the amendment process is quite similar to passing ordinary bills. Critics argue for a more rigorous procedure for fundamental changes. State ratification ambiguity. The Constitution doesn't specify a time frame for state legislatures to ratify amendments, leading to potential delays and uncertainties. Silent on withdrawal. There's no clarity on whether states can withdraw their approval after initially ratifying an amendment. No deadlock resolution. The process lacks a mechanism for resolving deadlocks if both houses of Parliament disagree on an amendment. Way forward. Dedicated committee body. Establish a separate committee or body specifically tasked with analyzing proposed amendments to the Constitution. This could provide a more rigorous review process and prevent hasty changes. Setting up a joint parliamentary committee. Create a joint parliamentary committee, JPC, for in-depth deliberation on proposed amendments. This JPC would involve representatives from both houses of Parliament and different political parties, fostering consensus building and ensuring broader consideration of the proposed changes. Deadlock resolution mechanism. Create a framework for resolving disagreements between houses of Parliament on amendments. This could involve mediation, joint committees, or a temporary supermajority requirement. Involve state legislatures. Their active participation in the amendment process could ensure a balanced federal structure is maintained. Defining amendment procedure. Clearer procedural guidelines could help reduce confusion and potential misuse of the amendment provision. Time-bound ratification. Set a time limit for state legislatures to ratify amendments, preventing indefinite delays. Constitutional amendments are a vital mechanism to keep the Constitution relevant and adaptable in a dynamic world. However, exercising this power judiciously and sparingly is essential to safeguard the integrity and stability of our foundational law. Keywords: majoritarianism, public deliberation, dedicated committee, deadlock resolution mechanism. 106th Constitutional Amendment, 2023 provisions. The 106th Amendment, also known as the Women's Reservation Act, 2023, Nari Shakti Vundan Adhiniam, 2023, reserves one-third of all seats in the Lok Sabha lower house of Parliament, state legislative assemblies, and the National Capital Territory of Delhi Legislative Assembly for women. This reservation includes seats already reserved for scheduled castes, SCs, and scheduled tribes, STs. Significance: aims to increase WOM's political participation, promoting gender equality in government. Can potentially lead to better representation of women's issues and perspectives in policymaking. May inspire more women to enter politics, breaking down traditional gender barriers. Criticisms: rotational system concerns. The Act mandates rotation of reserved seats, which some argue might disadvantage women with long-term political aspirations. Impact on existing reservations. Critics argue it might dilute the existing reservations for SCs and STs. Quota within quota. The implementation of reservation within reservation for SC/ST women raises questions about further complexities and potential challenges. Focus on numbers versus capability. Some argue that reservation alone might not guarantee capable women representatives. The amendment was a significant step towards women's empowerment in India. However, debates continue on the effectiveness of reservations and the need for broader societal changes to achieve true gender equality in politics. Basic structure of the Constitution. The basic structure doctrine is a principle established by the Indian judiciary that certain fundamental features of the Constitution are essential and unalterable, even through the Parliament's amendment power under Article 368. The concept didn't exist explicitly in the written Constitution. It emerged through a series of landmark court cases in the 1960s and 1970s, culminating in the landmark Kesavananda Bharati v. State of Kerala, 1973 case. The Supreme Court has yet to define or clarify what constitutes the basic structure of the Constitution. Kesavananda Bharati judgment. The Supreme Court ruled in the Kesavananda Bharati v. State of Kerala case that the basic structure of the Constitution is inviolable and cannot be amended by Parliament. This was the largest ever bench in the history of the Supreme Court, composed of 13 members. Kesavananda Bharati, the petitioner in the Supreme Court case that resulted in the landmark verdict of 1973 outlining the basic structure doctrine of the Constitution, passed away in 2020. Elements of basic structure. Over the years, the Supreme Court has through various judgments recognized many features as part of the Constitution's basic structure. Some of the examples include: the supremacy of the Constitution. Secular and federal character of the Constitution. The sovereignty of India. The unity and integrity of the nation. Judicial review. Balance between fundamental rights and directive principle, etc. Fig. Basic structure of the Constitution of India. Equality. T. Independent. Judiciary. Constitutional. Supremacy. Welfare. L. State. Basic. L. Structure. Balance between ER and DPSP. Judicial. P. Separation. I. Review. Sovereign. Secular of power. 1. Democratic and Republic. Y. Significance of basic structure protects the core identity. The basic structure doctrine safeguards the fundamental principles envisioned by the Constitution's framers, ensuring India remains a democratic, socialist, secular, and republic nation. Limits arbitrary amendments. It prevents the Parliament from making radical changes that could destroy the Constitution's essence. For example, Parliament can't abolish judicial review power or introduce a theocratic state. Maintains supremacy of the Constitution. By placing limitations on amendments, the basic structure doctrine upholds the Constitution as the supreme law, preventing its erosion by a temporary majority in Parliament. Promotes judicial review. It empowers the judiciary to review amendments and strike down those violating the basic structure. This was crucial in the Kesavananda Bharati case, 1973, where the Supreme Court protected fundamental rights from absolute parliamentary control. Independence of judiciary. Basic structure doctrine ensures independence of judiciary by preventing encroachment of Parliament in the judicial sphere. For instance, the 99th Constitutional Amendment Act 2014, which proposed the National Judicial Appointments Commission, NJC, was struck down due to violating the basic structure of the Constitution. Criticism of basic structure. Judicial activism. Critics argue it grants excessive power to the judiciary, allowing them to subjectively define the basic structure and potentially overstep their role. Vagueness. The concept of basic structure is itself unclear, lacking clear definition, and potentially leading to inconsistent application. Legislative supremacy challenged. The doctrine weakens the principle of Parliament's supremacy in lawmaking. Amending power curtailed. Critics argue it restricts Parliament's power to amend the Constitution, even for potentially beneficial changes. No textual basis. The doctrine isn't explicitly mentioned in the Constitution, raising questions about its legal legitimacy. These issues surrounding the doctrine's subjectivity must be addressed, potentially through codification of basic features by judicial and parliamentary cooperation to ensure that doctrine truly acts as a safeguard against majoritarianism and authoritarianism, thus protecting the Constitution and democracy in India. L.R. Qualo case, strengthening the basic structure doctrine. The I.R. Qualo case is a landmark judgment that further cemented the concept of the basic structure doctrine in Indian constitutional law. The main aspects of the case are as follows. Ninth Schedule limited. The court ruled that laws added to the Ninth Schedule, offering extra protection from challenge, after 1973 can be struck down if they violate the Constitution's basic structure. Judicial review upheld. The case reaffirmed judicial review as a fundamental aspect of the basic structure, ensuring all laws, even those in the Ninth Schedule, can be reviewed for constitutionality. Safeguard against overreach. This judgment solidified the principle that no power, including amendment power, is above judicial review. This protects against arbitrary actions by the legislature or executive. Preserving core values. The court reiterated that amendments breaching the Constitution's core principles would be void, safeguarding its essential values. Keywords: constitutional machinery, constitutionality, majoritarianism, authoritarianism, third chamber, judicial overreach, majoritarianism, authoritarianism. Previous year questions. 1. Parliament's power to amend the Constitution is a limited power and it cannot be enlarged into absolute power. In the light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. 2019. 2. What was held in the Qualo case? In this context, can you say that judicial review is of key importance amongst the basic features of the Constitution? 2016. 3 significant provisions in the Indian Constitution. India, also known as Bharat, is a sovereign, socialist, secular, democratic republic with a parliamentary system of government. It is a union of states that is governed according to the Constitution of India. Significant provisions of the Indian Constitution. The provisions encapsulate the fundamental elements of the Constitution, which are preamble, fundamental rights, fundamental duties, directive principles of state policy, universal adult franchise, single citizenship, separation of powers. Significant provisions, an in-depth analysis. Preamble, philosophical, American and Irish Constitution. The term refers to the introductory part of a document. India's features of Indian Constitution's preamble summarizes its core principles. Based on Pandit Nehru's Objectives Resolution, the preamble outlines the Constitution's fundamental values, political, moral, and religious. It captures the vision of the Constituent Assembly and the aspirations of India's founders. It has come under scrutiny from various quarters, with debates on whether the terms socialist and secular should be removed or retained. Universal adult franchise. It embodies the democratic principle of one person, one vote, ensuring political equality. Single citizenship. This unique feature grants all citizens the same rights and privileges regardless of their state of residence. In the context of increasing interstate migration and discussions surrounding the National Register of Citizens, NRC, this provision holds significant relevance. Fundamental rights. The Indian Constitution enshrines a set of fundamental rights, legally enforceable by courts, covering civil liberties, political rights, and fair trial procedures. These rights act as a shield against arbitrary state power, safeguarding citizens from government overreach. The recent Citizenship Amendment Act, CAA, sparked debates about how it might affect the right to equality and the principle of secularism. Directive principles of state policy. These are non-justiciable guidelines for the government, aiming to establish a just and equitable society. While not directly enforceable in court, they guide the state in formulating laws that promote social welfare. The ongoing discourse around implementing a uniform civil code, envisioned in Article 44, exemplifies the dynamic interpretation of directive principles. Fundamental duties. Core values of preamble. Liberty, equality, and fraternity. 1. Sovereignty. 1 to the power of T. Democracy. 1. Justice. 14. Core values of preamble are Republic. 1. Secularism. 1 to the power of S. Socialism. 1. Unity and integrity. Fundamental duties, a concept inspired by the USSR, are an essential aspect of Indian citizenship. They emphasize responsibilities alongside rights, promoting civic morality and social cohesion. However, their non-justiciable nature means enforcement relies on individual conscience. Discussions about mandatory voting often highlight the importance of citizens fulfilling their fundamental duties. Separation of powers. The separation of powers is a fundamental principle that divides government authority among the legislature, executive, and judiciary. This distribution of power ensures that no single branch becomes too powerful and prevents abuse of authority. The judiciary's role as the guardian of the Constitution, particularly during debates about judicial activism, exemplifies the significance of this principle. Preamble. The Constitution's preamble outlines its core principles and purpose. Drafted by Vengalal Krishna Menon, it establishes that we the people's source of authority and defines India's character along with the Constitution's objectives. Removal of socialist and secular words from preamble. Context. The Supreme Court was hearing a pair of petitions that sought deletion of words secular and socialist from the preamble. Recently, the Supreme Court, SC, agreed to examine whether the words socialist and secular could have been inserted in the preamble of the Indian Constitution in 1976 even though the date of the adoption of the Constitution remained unaltered, i.e. November 26, 1949. Arguments in favor of retaining socialist and secular in the preamble reinforces core values. These words explicitly emphasize the commitment to social and economic justice, reducing inequality, and protecting the rights of all citizens. Continuity and stability. Removing them could be seen as tampering with the Constitution's original intent and potentially creating uncertainty. Addresses historical context. These words were added post-independence to address concerns about minorities and economic disparity, reflecting India's unique situation. Flexibility in interpretation. The terms socialist and secular don't prescribe a rigid economic model or religious policy. They allow for adaptation and interpretation based on evolving needs. Secular identity. Removing secular might raise concerns about India's commitment to religious tolerance and equal treatment for all faiths. This could embolden religious nationalism and create anxieties among minority communities. Arguments against retaining socialist and secular in the preamble. Historical imposition. Critics argue these words were inserted during the emergency, 1975, a period of authoritarian rule, and don't reflect the original democratic spirit. Redundancy. The core principles of justice, equality, and liberty are already enshrined in the preamble. These words might be seen as unnecessary repetition. Economic model debate. The term socialist could be seen as outdated or hindering economic growth in a globalized world. Secular misinterpretation. Some argue it creates a false sense of secularism, while India is inherently a multi-religious society. Political agenda. The push for removal might be driven by a political agenda to change the character of the Indian state. Secular nature of the Constitution and establishment of the egalitarian social order through the rule of law are part of the basic structure of the Indian Constitution. Hence, as stated in the Kesavananda Bharti case, the Parliament can amend any part of the Constitution including the preamble without compromising the basic structure and constitutional values. Significance of preamble. Source of authority. It declares the source of the Constitution's authority as we, the people of India, establishing a democratic foundation. Defines the nation. It defines India as a sovereign, socialist, secular, democratic republic, outlining the core principles of the nation. Sets goals. It lays out the fundamental goals of securing justice, social, economic, and political, liberty, and equality for all citizens. Guiding light for interpretation. Courts use the preamble to interpret the Constitution's provisions during legal disputes. Reflection of ideals. It reflects the idealistic vision of the Constitution's framers for a just and equitable society. Amendability of preamble. The question of whether the preamble can be amended has been discussed in several landmark cases. Limited amendment view. Barabari case, 1960. Initially, the Supreme Court, in the Barabari case, 1960, held that the preamble wasn't part of the Constitution and therefore couldn't be amended. Preamble as amendable. Kesavananda Bharati case, 1973. However, a landmark shift occurred in the Kesavananda Bharati case, 1973. The court reversed its position, declaring the preamble to be part of the Constitution and amendable, provided the amendment doesn't violate the basic structure of the Constitution. Recent proposals. In light of this, recent proposals have included one to replace the word socialist with equitable in the preamble, sparking debate about the potential exercise of this amendability. The preamble embodies the values that guided India's freedom struggle and serves as the foundation for the country's democratic structure. These values are crucial to the nation's progress in the pursuit of justice, liberty, equality, and fraternity. Keywords: source of authority, identity card, guiding light, reflection of ideals. Issues in news. Laïcité. French principle of secularism context. France recently banned the wearing of abayas, similar to burqas, in state schools, citing a violation of their laïcité principle. France interprets secularism as freedom to emancipate oneself through school, where religion shouldn't be identifiable solely by appearance. About laïcité. Established in the 19th century, laïcité signifies a strict separation of state and church. It's enshrined in the French Constitution, promoting a public sphere free from religious influence and emphasizing secular values like liberty, equality, and fraternity. Differences between Indian and French secularism. Both India and France promote a secular state with several key principles in common. Religious freedom. Citizens have the right to practice their faith without discrimination. Equality for all. Religion cannot be a basis for legal distinction. State neutrality. The government avoids favoring any particular religion. Minority rights. Both nations are committed to protecting the rights of religious minorities. Freedom of expression. Criticism and discussion of religious beliefs are permitted. Differences between Indian and French secularism. Basis: India, France. Core principle: Sarva Dharma Samabhava, equal respect for all religions. This fosters a more inclusive approach to religion in public life. Laïcité emphasizes a strict separation of religion from the state and public sphere. Religious expression generally permits religious symbols in public spaces. Sikhs, for instance, are exempt from wearing helmets while riding two-wheelers due to their turbans. Has stricter policies regarding religious symbols, such as banning conspicuous ones in public schools, sparking controversy. State funding allows state funding for religious institutions, prohibits state funding for religious institutions. As part of laïcité, personal laws recognizes separate personal laws for different religious communities governing marriage, divorce, and inheritance, e.g., Hindu Succession Act. Maintains a unified civil code that applies to all citizens regardless of religion. State involvement. The state frequently interacts with and supports various religious communities and their institutions. Public institutions must remain entirely secular, avoiding any religious endorsement or involvement. It's important to note that each country's secularism is shaped by its unique historical, cultural, and social context, and there is no one-size-fits-all approach. France can adapt and incorporate elements from India's secularism that align with its own values and objectives while respecting its historical and legal framework. Previous year questions. 1. Explain the constitutional perspectives of gender justice with the help of relevant constitutional provisions and case laws. 2023. 2. What can France learn from the Indian Constitution's approach to secularism? 2019. 3. Discuss each adjective attached to the word republic in the preamble. Are they defendable in the present circumstances? 2016. Prahaar Mains Wallah. Ethics. IL and app latest data and facts enrichment. Keyword focus for quality answers. Set of 14 booklets. Integrated PYQs. Economy economic. Development. Z. Interlinking of current and static topics. Concise. E. Mains-oriented notes. RLHIUOC 3 TMC *XM. Are offline centers. Lucknow. Carol Bog Mukherjee Nagar. I-992-061-3613. Putna. OnlyIAS. Com 4 Fundamental Rights, Part 3, Article 12 to 35. Fundamental rights are enshrined in Part 3, Articles 12 to 35 of the Indian Constitution. These are basic human rights guaranteed to all Indian citizens, essential for a life of dignity and freedom. They act as limitations on the power of the government, ensuring it cannot arbitrarily deny these rights to individuals. These rights are guaranteed to all Indian citizens, irrespective of caste, religion, gender, or social status. Classification of fundamental rights. The Constitution of India provides 6 fundamental rights, which are I. Right to equality, Article 14 to 18, 2. Right to freedom, Article 19 to 22, 3. Right against exploitation, Article 23 to 24, 4. Right to freedom of religion, Article 25 to 28, v. Cultural and educational rights, Article 29 to 36. Right to constitutional remedies, Article 32. Distinctive features of fundamental rights justiciable. Unlike directive principles, Part 4, fundamental rights are enforceable by courts. Citizens can approach the Supreme Court or high courts through writs, legal remedies, to protect their violated rights. Not absolute. These rights can be reasonably restricted by the government in the interest of the state, public order, morality, etc. This balance is achieved through judicial review. Can be expanded. Unlike some constitutions with a fixed list of rights, the Indian Constitution allows the judiciary to expand the scope of fundamental rights through interpretations and pronouncements. This ensures adaptability to evolving needs. Positive rights. In addition to classic negative rights, freedom from state interference, the Indian Constitution includes some positive rights like the right to education, Article 21A. Suspension during emergencies. During a national emergency, some rights can be suspended by the President, except Articles 20 and 21. However, this power is subject to judicial review. Article 12, definition of state. Article 12 defines state, broadly, including O. The central government, parliament, and executive, O. State governments, legislature, and executive, O. All local authorities, e.g., municipalities, O. All other authorities, both established by law, and those not requiring a formal statute. Judiciary and definition of state. The definition excludes the judiciary when it functions in its judicial capacity, e.g., interpreting laws. However, the judiciary's administrative actions, e.g., employee hiring, are subject to legal challenges through writs, Article 226. Exceptions. This definition of state does not apply to international organizations. The United Nations, for example, is not considered a state under Article 12. Its actions cannot be challenged using Article 226. Article 13. Article 13. Article 13 establishes that any law contradicting or weakening fundamental rights is invalid. This explicitly lays the foundation for judicial review. Power of judicial review. The Supreme Court, Article 32, and High Courts, Article 226, hold the power of judicial review. They can declare any law unconstitutional and void if it violates fundamental rights. What can be challenged? The term law has a broad interpretation. Here's what can be challenged in court for infringing upon fundamental rights and potentially declared null and void. O. Permanent laws passed by Parliament or state legislatures. O. Temporary laws like ordinances issued by the President or state governors. O. Secondary legislation, delegated legislation, by the executive, including orders, bylaws, rules, regulations, or notifications. O. Non-legislative sources of law such as established customs or practices with legal force. Exceptions to judicial review. Constitutional amendments are not considered laws and cannot be directly challenged. However, a landmark Supreme Court ruling in the Kesavananda Burdi case, 1973, established that a constitutional amendment can be challenged if it violates a fundamental right deemed part of the Constitution's basic structure. Inclusion of personal laws under Article 13. The question of whether personal laws fall under the ambit of Article 13, which prohibits laws inconsistent with fundamental rights, is a complex and debated issue in India. Here are some key points outlining the arguments. Arguments against inclusion. Not law and force. A landmark judgment in State of Bombay versus Naresu Appamali, 1952, held that personal laws, derived from religious texts and customs, are not laws and force as envisaged in Article 13. They argue these weren't enacted by a legislature. Preserving religious identity. Supporters of this view argue that including personal laws under Article 13 would infringe on religious freedom and cultural practices enshrined in Articles 25 and 26. Arguments for inclusion. Discrimination and inequality. Critics argue that personal laws, particularly those pertaining to inheritance, marriage, and adoption, can be discriminatory, especially towards women. For example, some religious personal laws allow polygamy for men only and some allow for women only. This allegedly violates the right to equality, Article 14. Fundamental rights supremacy. Proponents believe that fundamental rights should be supreme, and personal laws that violate them, like discriminatory inheritance rights, should be invalidated. Court judgments. The Supreme Court has reiterated that personal laws are outside the scope of Article 13. It emphasized legislative reform, uniform civil code, as the solution. Some High Court judgments have tried to bring personal laws under Article 13, but these were overruled by the Supreme Court. The Indian Parliament has not enacted a uniform civil code, UCC, that would apply a common set of laws to all citizens across religions. This inaction is seen by some as a missed opportunity to ensure equality. Keywords: Magna Carta of India, political democracy, limited rights, not absolute but qualified, reasonable restrictions, justiciable, doctrine of judicial review. Right to equality, Article 14-18. Right to equality, enshrined from Article 14 to 18 in the Constitution of India, forms the cornerstone of our democratic nation, championing the principle of equality among all citizens. This fundamental right guarantees equal treatment before the law, prohibits discrimination based on factors like religion, caste, or sex, and ensures equal access to public spaces and government jobs. Article 14. Equality before law. Article 14 asserts that no person will be denied equality before law or equal protection of law within Indian territory. Equality before laws. Equal protection of laws. Equality before law, an idea of British origin. It negates any special privileges in favor of any person, subjects all persons to ordinary law, and affirms that no person is above the law. Example: a law against theft applies to everyone, regardless of wealth or social status. If a politician and a commoner are caught stealing, both go through the same legal process. Equal protection of laws, an American concept. It calls for equal treatment under identical circumstances and consistent application of the same laws to all persons in similar situations. Example: a law offering tax benefits to small businesses must be available to all qualifying businesses, not just ones in a specific industry or location. Denying tax benefits to specific groups based on irrelevant factors would violate equal protection. Exceptions under Article 14, affirmative action. The Constitution allows the state to make special provisions for disadvantaged groups like women, children, scheduled castes, SCs, scheduled tribes, STs, and socially and economically backward classes, SEBs, in public educational institutions. First Constitutional Amendment Act, 1951. Reservations in education. The state can reserve seats in educational institutions, including private ones, except for minority institutions, for backward classes, SCs, and STs to promote their educational advancement. 93rd Constitutional Amendment Act, 2005. Economically weaker sections, EWS. The state can make special provisions, including reservations in educational institutions, for economically weaker sections, EWS, of society to ensure equal opportunity. 103rd Constitutional Amendment Act, 2019. Immunities of high offices. Article 361 grants certain immunities from legal proceedings to the President and governors to ensure they can perform their duties without undue pressure. Parliamentary privileges. Members of Parliament, MPs, and state legislative assemblies enjoy certain privileges and immunities, Articles 105 and 194 respectively, to allow for free and independent discharge of their legislative responsibilities. Article 15. Prohibition of discrimination. Prohibition of discrimination. Article 15 prohibits the state, government, from discriminating against any citizen on grounds of religion, race, caste, sex, or place of birth. Access to public places and amenities. It ensures citizens can access shops, restaurants, hotels, places of public entertainment, wells, tanks, bathing ghats, roads, and places of public resort without discrimination. Exception for women and children. The article allows the state to make special provisions for women and children to promote their welfare and upliftment. This is because they may face specific disadvantages requiring affirmative action. Article 16. Equality of opportunity in public employment. Equality of opportunity in public employment. It guarantees equal opportunity for all citizens in matters relating to government jobs and appointments. Non-discrimination. No citizen can be discriminated against based on religion, race, caste, sex, descent, place of birth, residence, or any of them for government jobs. Exceptions. The article allows some exceptions. Residential requirements. Parliament can make laws requiring citizens to have a residency period within a state for government jobs there. Reservation policy. The government can reserve appointments for backward classes, scheduled castes, scheduled tribes, and other backward classes to promote social equality. Reservation for economically weaker sections. A 10% reservation for economically weaker sections of society has been added through a recent amendment. Significance. Article 16 promotes meritocracy and aims to eliminate social inequalities in government employment. Challenges. Despite the article, issues like caste-based discrimination in recruitment persist. Demand for local reservation in private sector jobs. The demand for local reservation in private jobs has sparked debate in India. Proponents argue it empowers locals and addresses unemployment, while opponents raise concerns about constitutionality and hindering meritocracy. In favor, empowering locals. Local youth often have a better understanding of the region's needs and can contribute more effectively. Addressing unemployment. Reservation can create opportunities for locals facing high unemployment rates. Social cohesion. It can foster a sense of ownership and reduce resentment towards outsiders. Against constitutionality. Article 19. LG guarantees the right to practice any profession throughout India. Reservations based solely on residence might violate this. Meritocracy, companies may struggle to find the most qualified candidates if restricted to a local pool. Investment discouragement, strict reservation policies could deter businesses from investing in certain regions. Examples: Haryana, the state passed a law in 2020 reserving 75% of private jobs for locals, but it was struck down by the High Court due to constitutional concerns. Maharashtra proposed a similar policy reserving 80% of private jobs, raising similar legal questions. Finding a balance between local aspirations and national economic freedom is crucial. Skill development programs alongside relaxed residency requirements could be a more effective approach. Article 17. Abolition of untouchability abolishes untouchability. Article 17 explicitly outlaws the practice of untouchability in any form. Discrimination forbidden. It prohibits any discrimination arising from untouchability. This includes denying access to public spaces, temples, or professions based on caste. Punishable offense. The enforcement of untouchability is a criminal offense. The Protection of Civil Rights Act, 1955, later renamed, lays out specific penalties. Significance. Article 17 is crucial in promoting social justice and equal rights in India. Ongoing challenge. Despite Article 17, untouchability continues to be a social evil in India. However, the article remains a crucial legal tool to combat this practice. Article 18. Abolition of titles. The state is prohibited from conferring any titles except military and academic distinctions, e.g., Padma Awards, Paramveer Chakra. This aimed to create a society based on equality and merit, not inherited titles. Abolition of hereditary titles of nobility conferred by colonial states. Keywords: equality before law and equal protection of law, prohibition of discrimination, equality of opportunity, untouchability, civil rights right to freedom, Articles 19 to 22, Article 19. Protection of certain rights regarding freedom of speech, etc. Article 19 of the Indian Constitution guarantees 6 fundamental freedoms to all citizens. These freedoms are crucial for a functioning democracy. These are protected against state action and are available to citizens and shareholders of a company, but not to foreigners or legal persons such as companies or corporations. These freedoms under Article 19 are not absolute. Reasonable restrictions can be imposed in the interest of public order, national security, and other legitimate concerns. Rights under Article 19. 1. Freedom of speech and expression. Fundamental right to articulate one's opinions and ideas without fear of retaliation, censorship, or legal sanction. Right to assemble peaceably and without arms. The right to come together and collectively express, promote, pursue, and defend common interests. Right to form associations or unions or cooperative societies. The right to join with others to collectively express, promote, pursue, and defend common interests. Right to move freely throughout the territory of India. Allows citizens to move freely within the territory of India, though this right can be restricted in the interests of the general public or scheduled tribes. Right to reside and settle in any part of the territory of India. The right to live and settle in any part of the territory of India. Right to practice any profession or to carry on any occupation, trade, or business. The right to conduct any lawful profession or to carry on any occupation, trade, or business. Article 19, 2. Permits the state to impose reasonable restrictions on these rights based on the grounds such as sovereignty, integrity of India, public order or morality, etc. As mentioned in the article. Article 19 strives for a balance between individual freedoms and the need for a well-functioning society. Landmark Supreme Court cases and free speech in India. Shreya Singhal case, 2015. This case challenged Section 66A of the Information Technology Act, 2000. This section penalized sending grossly offensive or menacing information online. The Supreme Court struck down Section 66A, recognizing it as a crucial victory for online free speech in India. Kedarnath Singh case, 1962. This case addressed the interpretation of sedition under Indian law. The Supreme Court upheld the constitutional validity of the sedition law, clarifying that criticism of the government does not constitute sedition unless it incites or advocates for violence. Article 20. Protection in respect of conviction for offenses. Article 20 of the Indian Constitution is a crucial safeguard against arbitrary punishments and unfair trials. It guarantees certain rights to individuals accused of crimes. Protection from retrospective punishment. This principle ensures a person cannot be convicted for an act that wasn't illegal when he committed it. Laws cannot be applied retroactively. Double jeopardy prohibition. Person cannot be prosecuted and punished for the same offense more than once. No self-incrimination. No person accused of a crime can be forced to be a witness against themselves. This protects individuals from being compelled to provide evidence that could incriminate them. Article 20 lays the foundation for fair trials by ensuring these safeguards. It restricts the government's ability to arbitrarily convict or punish citizens. These rights ensure fair treatment within the legal system and protect individuals from potential misuse of power. Article 21, Right to Life and Personal Liberty. Article 21 of the Indian Constitution is considered the cornerstone of fundamental rights. It guarantees the most basic human right. It advocates that no person can be deprived of their life or personal liberty except according to a procedure established by law. It's the foundation for a broad range of human rights, including the right to privacy and the right to live with dignity. Crucial cases. The A. K. Gopalan case, 1950, interpreted procedure established by law narrowly, ruling that protection under Article 21 is only against arbitrary executive action, not arbitrary legislative action. In Maneka Gandhi case, 1978, the Supreme Court widened the interpretation of procedure established by law to include protection against arbitrary legislative action as well, similar to the American concept of due process of law. In the Puttaswamy judgment, 2017, a landmark ruling, the Supreme Court held that privacy was intrinsic to freedom of life and personal liberty. It played a pivotal role in decriminalizing homosexuality and abolishing provisions related to adultery. These interpretations ensure that Article 21 protects not just basic survival, but also a life with dignity and essential living conditions. Article 21, Right to Privacy versus Right to Be Forgotten. A new frontier in data privacy, the right to be forgotten, allowing individuals to control the online disclosure of their personal information, limit, delink, delete, or correct, is a recent development in Indian law. Importance for data protection. The B.N. Sri Krishna Committee highlighted the right to be forgotten as a crucial aspect of data protection and individual privacy in the digital age. Balancing act with free speech. Recognizing this right necessitates a careful balancing act to ensure it doesn't restrict the fundamental right to freedom of speech and expression or the right to information of other citizens. Challenges of the digital landscape. The global nature of the internet and the variations in legal frameworks across different countries pose challenges in achieving this balance. Article 21A, Right to Education. Education is a fundamental building block for individual growth and societal development. Recognizing this importance, the Indian Constitution was amended in 2002, 86th Amendment, to include Article 21A as part of the fundamental rights. Key points of Article 21A. Free and compulsory education. The state, government, is obligated to provide free and compulsory education to all children between the ages of 6 and 14. Manner of implementation. Though the responsibility lies with the state, the article allows them to determine the specific way this right will be provided, often through legislation. Right to quality education. While not explicitly mentioned in Article 21A, subsequent legislation like the Right to Education Act, RT Act, 2009 emphasizes quality education. Impact. This article has significantly increased school enrollment rates in India, promoting greater access to education. Recent updates. The National Education Policy 2020 expanded the age bracket for compulsory education to 3 to 18 years, addressing the need for early childhood education and extending the provision of education till higher secondary school. Article 22, Protection against arrest and detention in certain cases. Article 22 of the Indian Constitution is a crucial safeguard against arbitrary arrest and detention. It guarantees certain rights to any person who is arrested, protecting them from misuse of power by the authorities. Ordinary law conditions. Protection from uninformed detention. No person can be arrested and held in custody without being informed promptly about the reasons for the arrest. Right to legal counsel. The arrested person has the fundamental right to consult and be defended by a lawyer of their choice. Magisterial production. The arrested individual must be produced before a magistrate within 24 hours after arrest, excluding travel time. Right to be released after 24 hours unless authorized by a magistrate. This continues the protection against arbitrary detention. Preventive detention conditions. Detention of a person cannot exceed 3 months without an advisory board report. Prevents prolonged detention without adequate justification. Grounds of detention should be communicated to the detainee. Ensures transparency and gives the detained person an opportunity to dispute the grounds of their detention. Keywords. Freedom of speech, sedition, protection of life and personal liberty, right to privacy, right to be forgotten. Right against exploitation. Article 23-24. Article 23, Prohibition of traffic in human beings and forced labor. Article 23 of the Indian Constitution is a fundamental right that safeguards individuals from two key forms of exploitation: trafficking in human beings and forced labor. Prohibition. The article clearly prohibits practices such as trafficking in human beings, buying and selling people as commodities. Begar. Unpaid forced labor, often associated with historical practices like bonded labor for debt repayment. Other similar forms aforesaid labor. Any situation where a person is compelled to work against their will, with threats or coercion. Offense and punishment. Violations of this article are punishable by law, ensuring legal recourse for victims. State's power. The article doesn't prevent the state from imposing compulsory service for public purposes, like national service in some countries. However, such service cannot discriminate based on religion, race, caste, or class. Aptitude versus Union of India, a landmark judgment reinforcing the right against forced labor, ruling that economic compulsion that leaves no choice for a person and compels them to provide labor or service also constitutes forced labor. This article is crucial in upholding human dignity and preventing vulnerable individuals from being exploited. Article 24, Prohibition of employment of children in factories, etc. Article 24 specifically safeguards children from hazardous work. Prohibition on child labor. It prohibits the employment of children below 14 years old in factories, mines, or any other hazardous work. Doesn't ban all work. It's important to note that Article 24 doesn't restrict children from all types of work. Non-hazardous or age-appropriate work might be permissible. Complementary laws. Several laws have been enacted by the Parliament to enforce this provision, such as the Child Labor, Prohibition and Regulation Act of 1986. Article 24 is a crucial step towards ensuring a childhood free from exploitation and promoting education. It empowers children to develop their full potential in a safe environment. Right to freedom of religion. Article 25 to 28. Article 25. Article 25 is a cornerstone of India's secular democracy, guaranteeing freedom of religion to all individuals. Freedoms guaranteed. It enshrines four freedoms. Freedom of conscience, the right to hold your own beliefs without external pressure. Freedom to profess, the right to openly declare your religion. Freedom to practice, the right to perform rituals and observe religious practices. Freedom to propagate, the right to share your religion with others, though not to forcefully convert them. Equality for all. These freedoms apply equally to all persons in India, regardless of citizenship. Reasonable restrictions. These freedoms are subject to public order, morality and health, and other provisions of the Constitution. This allows the government to impose some limitations in the interest of social harmony and well-being. State and religion. The government cannot promote any particular religion or discriminate on religious grounds. Significance. Article 25 promotes religious tolerance, pluralism, and peaceful coexistence of diverse faiths in India. Article 26. Rights granted. This article confers on every religious denomination the freedom to manage its religious affairs, own and acquire movable and immovable property, and administer it according to law. Different from Article 25, the contrast between Articles 25 and 26 is noteworthy. While Article 25 protects individual religious rights, Article 26 safeguards collective religious freedoms. Not absolute. These rights are subject to public order, morality, and health. The state can regulate activities to ensure these are not compromised. Significance. Protects religious denominations from government interference in their internal affairs. Allows religious groups to manage their institutions, finances, and practices freely. Examples. This right allows temples to appoint priests, churches to conduct religious services, and religious trusts to manage their properties. Article 27. Rights granted. Article 27 prevents an individual from being compelled to pay taxes for the promotion or maintenance of a particular religion. No bias. This provision ensures the state doesn't favor or patronize one religion over another, maintaining its secular character. Example. If the government proposed a tax specifically to fund the renovation of temples, this would violate Article 27 as it singles out a particular religion. Article 28. Rights granted. It prohibits religious instructions in any educational institution that is wholly funded by the state. Exception. This doesn't apply to educational institutions administered by the state but established under endowments or trusts requiring religious instruction. This article safeguards the right to education free from religious bias while allowing some institutions to maintain their religious character with complete transparency and freedom of choice for students. Cultural and educational rights. Article 29-30. The Constitution, appreciating India's vast cultural diversity, also protects cultural and educational rights under Articles 29 and 30, ensuring that no minority group is alienated or marginalized. Article 29. Article 29 of the Indian Constitution is a crucial safeguard for the nation's rich diversity. It guarantees the cultural and educational rights of minorities, ensuring India's unique languages, scripts, and traditions can flourish. Right to conserve culture. Any group of citizens with a distinct language, script, or culture has the right to preserve and promote it. This empowers minority communities to maintain their heritage and customs. Non-discriminatory education. No citizen can be denied admission to a state-run or state-funded educational institution solely based on religion, race, caste, language, or any of them. This ensures equal access to education regardless of background. Fostering inclusivity. Article 29 promotes national unity by celebrating diversity and guaranteeing cultural protections for minority groups. Article 30. Article 30 of safeguards the educational rights of minorities, including establishment and administration. Religious and linguistic minorities have the right to establish and manage educational institutions of their choice. Education in mother tongue. This right extends to providing education to their children in their own language. Regulation for quality. This right is not unrestricted. The government can implement regulations to ensure the educational quality and academic excellence of these institutions. Non-discrimination in funding. The state cannot discriminate against minority-run educational institutions when granting financial aid. Fair acquisition of property. Article 301A ensures fair compensation when acquiring property belonging to a minority educational institution. Keywords: secularism, state religion, minority rights, religious and linguistic minorities. Remedies for enforcement of rights. Article 32. Article 32 is a cornerstone of India's fundamental rights enshrined in Part 3 of the Constitution. It guarantees the vital right to seek judicial enforcement of these fundamental rights. Let's break down some key points about Article 32, empowering individuals. It empowers every citizen to directly approach the Supreme Court of India if they believe their fundamental rights have been violated by the government or any other authority. Fundamental rights enforcement. It provides a mechanism to ensure these fundamental rights aren't just written words, but enforceable legal guarantees. Writs for enforcement. The Supreme Court has the power to issue writs, such as habeas corpus, mandamus prohibition, certiorari, and quo warranto to rectify the violation. Parliamentary power. Parliament can authorize other courts, like high courts, to issue similar writs under Article 226. However, the Supreme Court's power to issue writs remains supreme. Significance. O strengthens rule of law. It ensures the government respects fundamental rights and acts within its legal boundaries. O provides legal recourse. It empowers individuals to fight for their rights and seek justice. O protects vulnerable citizens. It acts as a safeguard against arbitrary actions of the state. Article 32 is a basic feature of the Constitution. Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. Writs in case of the enforcement of fundamental rights. The jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. Habeas corpus. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. It can be issued against both public authorities as well as private individuals. Mandamus. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. Prohibition. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Certiorari. It is issued by a higher court to a lower court or tribunal either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. It is issued on the grounds of excessive jurisdiction or lack of jurisdiction or error of law. Quo warranto. It is issued by the court to inquire into the legality of claim of a person to a public office. Significance of writs. Protection of fundamental rights. Writs provide individuals with a powerful tool to challenge violations of their fundamental rights enshrined in Part 3 of the Constitution. Judicial review. They empower the Supreme Court to exercise judicial review, ensuring actions by the government and other authorities are lawful and within constitutional boundaries. Speedy and effective remedy. Writs offer a swift and effective way to seek judicial intervention compared to lengthy court procedures. Ensuring accountability. The threat of writs keeps authorities accountable for their actions and prevents arbitrary use of power. Maintaining rule of law. Writs are crucial for upholding the rule of law by ensuring everyone, including the government, operates within legal parameters. Armed Forces and Fundamental Rights. Purpose. Article 33 empowers the Parliament to restrict some fundamental rights for members of the armed forces, paramilitary forces, and potentially intelligence agencies, though not explicitly mentioned. Justification. The limitations are intended to ensure the proper discharge of duties and maintain discipline within these forces. Rights potentially affected. While not explicitly stated, any fundamental right could be restricted under Article 33, depending on the situation. However, this power is not absolute and courts might intervene if the restrictions are deemed excessive. Example, the right to freedom of speech and expression, Article 19, might be restricted for soldiers to maintain operational secrecy or prevent insubordination. Martial laws and fundamental rights. Martial law. Article 34 applies when martial law is imposed in any part of India. Martial law is a situation where the military takes control of civilian authority to maintain order. Restriction on rights. During martial law, Parliament can pass laws that restrict the fundamental rights guaranteed by Part 3 of the Constitution. Protection for actions. The article also allows Parliament to indemnify, protect from legal action, government officials or any other person who takes actions in connection with the maintenance or restoration of order while martial law is in force. Significance. Article 34 creates a balance between national security and individual rights. In extreme situations, some rights might need limitations to restore order. Significance of above provisions ensures discipline and effective discharge of their duties, which are crucial for national security. Protects government officials who take actions to maintain order in such situations. These articles acknowledge the need to temporarily limit some rights for the greater good of national security and public order. Right to own property. The 44th Amendment, 1978, significantly altered the status of the right to property in India. From fundamental right to legal right. Prior to the amendment, the right to property was a fundamental right under Article 31. This meant it received the highest legal protection, and any government acquisition required strict procedures and fair compensation. The amendment downgraded it to a legal right under Article 300A. Easier land acquisition. The government now has greater flexibility in acquiring land for public purposes. This can expedite infrastructure development and social welfare projects. Judicial scrutiny remains, though not a fundamental right. Article 300A still mandates following due process and fair treatment when acquiring property. Courts can intervene if these principles are violated. Further, courts can still interpret fair treatment under Article 300A to include reasonable compensation. Right to compensation. A guaranteed right to compensation when the state acquires the property of a minority educational institution, Article 30. When the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits, Article 31A. Overall, the 44th Amendment aimed to balance individual property rights with the government's need for development. While it allows for faster land acquisition, concerns about potential misuse and ensuring fair compensation remain. Keywords: writs, habeas corpus, mandamus, certiorari, quo warranto, prohibition, martial law, right to compensation. Exceptions to fundamental rights. Article 31A. This article protects 5 categories of laws related to agricultural land reforms and industry commerce from being challenged for violating the rights to equality, Article 14. And freedom, Article 19. Article 3IB. Laws and regulations listed in the 9th Schedule are shielded from challenges based on fundamental rights violations. However, the Supreme Court's 2007 ruling in the Iyer-Qualo case clarified that this immunity isn't absolute. Laws added to the 9th Schedule after April 24, 1973, can be challenged if they violate fundamental rights or core constitutional principles. Article 3IC, introduced by 25th Amendment. This article aimed to a. Protect laws implementing socialist directive principles, Article 39, b, and c, from challenges based on Articles 14, equality, and 19, freedom. b. Prevent courts from questioning whether a law claiming to implement socialist policies actually achieves that goal. The Supreme Court's landmark Kesavananda Burdi case, 1973, declared the second provision of Article 31C unconstitutional. Judicial review is a fundamental aspect of the Constitution, and Parliament cannot take it away. However, the first provision of Article 31C protecting laws implementing socialist directive principles was upheld. Significance of fundamental rights. Protection from arbitrary state power. FRs act as a shield against arbitrary actions by the government. They ensure the state respects basic human rights and freedoms. Equality and non-discrimination. FRs promote a society based on equality by prohibiting discrimination on grounds of religion, race, caste, sex, or place of birth. This fosters social inclusion and justice. Dignity and individual liberty. FRs guarantee basic freedoms like speech, assembly, and movement, allowing individuals to develop their personalities and lead fulfilling lives with dignity. Check on majoritarian rule. India's democracy is based on majority rule, but FRs prevent the tyranny of the majority by safeguarding the rights of minorities and individuals. Mechanism for judicial review. FRs empower individuals to challenge laws or government actions that violate their rights through the judiciary. This ensures the rule of law and a check on the executive and legislature. Issue sand challenges pertaining to fundamental rights. Implementation gap. Despite constitutional guarantees, there are instances where fundamental rights are not effectively enforced, leading to violations and injustices. Discrimination and inequality. Marginalized groups often face discrimination in accessing their fundamental rights, such as the right to equality and right against discrimination based on caste, gender, religion, or ethnicity. Interpretation challenges. The interpretation of fundamental rights by the judiciary can sometimes be contentious, leading to ambiguity and inconsistency in their application. Violations during emergency. During states of emergency, there have been instances where fundamental rights, particularly those related to personal liberty and freedom of speech, have been curtailed, raising concerns about government overreach. Online privacy and surveillance. With the increasing use of digital technologies, concerns have emerged regarding the protection of privacy rights and the potential for government surveillance infringing upon individual freedoms. Way forward, awareness and education. Promote awareness campaigns and educational programs to inform citizens about their fundamental rights and how to exercise them effectively. Legal reforms. Introduce reforms to streamline the judicial process, reduce backlog, and ensure timely adjudication of cases related to fundamental rights. Safeguarding during emergencies. Strengthen legal safeguards to prevent the arbitrary suspension of fundamental rights during states of emergency, ensuring that any limitations imposed are proportionate and necessary. Privacy legislation. Enact comprehensive legislation to safeguard online privacy rights and regulate government surveillance practices, balancing the need for security with individual freedoms. Judicial training and capacity building. Provide training and capacity building programs for judges and legal professionals to enhance their understanding of fundamental rights and improve consistency in their interpretation and application. Community engagement. Foster dialogue and engagement with communities, civil society organizations, and stakeholders to address specific challenges and develop tailored solutions to protect fundamental rights. Keywords: arbitrary state power, majoritarian rule, online privacy, dignity, and individual liberty issues in Maharashtra's Maratha Reservation Bill context. The Maharashtra legislature passed a bill granting 10% reservation for Marathas in government jobs and educational institutions. This reservation is intended for socially and educationally backward classes, SEBCs, within the Maratha community, excluding those deemed economically well-off, creamy layer. Reasons for reservation demands: structural challenges. Marathas face declining agricultural income and struggle to adapt to the new job market. Job market discrepancies. Lower wages and instability in the private sector make public sector jobs with reservations more desirable. Political mobilization. Caste-based political movements advocating for reservations, like Marathas, are a growing trend. Relative deprivation. Marathas perceive other communities receiving reservation benefits despite facing similar economic realities. Intra-community disparity. While some Marathas are economically dominant, others are disadvantaged, leading to demands for reservation. Arguments for caste-based reservation. Social justice. Aims to correct historical injustices and create a level playing field for disadvantaged castes. Representation. Aims to ensure fair representation of marginalized communities in government jobs. Substantive equality. Promotes true equality by addressing entrenched socioeconomic inequalities based on caste. Criticisms of caste-based reservation. Overlooking other factors. Backwardness may not solely be caste-based. Factors like residence, occupation, and economic status should be considered. Perpetuating privilege. Focusing solely on caste can lead to continued advantages for those who have already benefited. Hindering a casteless society. Reservation systems can solidify the caste system. Escalating demands. Dominant caste may seek reservation benefits, creating a cycle of demands. Ignoring intra-caste inequality. Reservation based solely on caste overlooks economic disparities within communities. The way forward: comprehensive survey. A socio-economic survey is needed to accurately assess who qualifies for reservation based on the Constitution. Economic growth. Addressing rural distress, job creation, and regional development can alleviate the root causes of reservation demands. Creamy layer exclusion. Enforcing the creamy layer criterion ensures those genuinely disadvantaged benefit from reservation. The Maratha Reservation Bill highlights the complex issue of caste-based reservation in India. While aiming for social justice, such policies require careful consideration to achieve true equality and inclusive development. Persone Lightwire JHDS context. A recent Delhi High Court ruling granted a well-known Bollywood actor protection from unauthorized use of their personality rights by third parties. This decision reflects the growing legal recognition of the importance of safeguarding an individual's public image and identity. What is personality rights? Personality rights safeguard an individual's control over their identity and how it's presented. This includes the right to control the commercial use of your name, image, likeness, or other unique identifiers. Example: a celebrity suing a company for using their image without permission in an advertisement. Significance of personality rights. Control over identity ensures individuals decide how they're portrayed publicly. Protection from exploitation prevents unauthorized commercial use of one's identity for personal gain. Preserves reputation, allows individuals to control information associated with them. Incentivizes achievements, protects the value individuals build around their name and image. Way forward: comprehensive legislation, a dedicated law to explicitly define and protect personality rights. Balancing interests. Legislation should strike a balance between individual rights and freedom of expression. Public awareness. Educating individuals on their personality rights and available remedies. International harmonization. Collaboration with other countries to address online exploitation and deepfakes. By addressing these issues, India can create a more robust system for protecting personality rights in the digital age. Conclusion: true democracy could not exist without ensuring the dignity and equality of individuals against the state as well as from social majorities. It was only with fundamental rights that an individual can rise from the status of subject to that of citizen. Previous year questions. 1. The construction of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society. Illustrate with special reference to the expanding horizons of the right to life and personal liberty. 15 marks. 2023. 2. Right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. Comment. 2022. 3. Examine the scope of fundamental rights in the light of the latest judgment of the Supreme Court on right to privacy. 2017. 4. Does the right to clean the environment entail legal regulations on burning crackers during Diwali? Discuss in the light of Article 21 of the Indian Constitution and judgments of the Apex Court in this regard. 2015. 5. What do you understand by the concept freedom of speech and expression? Does it cover hate speech also? Why do the films in India stand on a slightly different plane from other forms of expression? Discuss. 2014. 6. Discuss Section 66A of IT Act, with reference to its alleged violation of Article 19 of the Constitution. 2013 5 Directive Principles of State Policy, DPSPs, Part 4, Article 36 to 51. The Indian Constitution's Directive Principles of State Policy, DPSPs, are a set of guidelines that outline the government's vision for promoting social and economic justice for all citizens. They were inspired by similar principles found in the Irish Constitution. Unlike fundamental rights, which are justiciable and enforceable by courts, DPSPs are not legally enforceable. However, they play a crucial role in shaping government policies and legislation. Feature significance of the DPSPs: social, economic, and political justice. They aim to establish a social order where justice prevails in all spheres: social, economic, and political. Non-justiciable. Unlike fundamental rights, they cannot be directly enforced through courts. Directive in nature, they provide direction and guidance to the government in formulating policies to achieve the stated goals. Grounded in socialist ideals, they promote ideas like equitable distribution of wealth, securing a just and humane work environment, and providing opportunities for all. Framework for governance. DPSP provides a long-term vision for the Indian government, directing its efforts towards establishing an egalitarian society. Bridge the gap. The DPSP bridges the gap between fundamental rights and their practical realization. By outlining the state's responsibility to fulfill these rights, they move towards a more equitable society. Conflict between DPSP and FR. The Indian Constitution creates a potential clash between fundamental rights, FRs, and directive principles of state policy, DPSPs. FRs are enforceable by courts, while DPSPs are guidelines for the state. This conflict can be understood with key Supreme Court judgments. After the Minerva Mills case, the Supreme Court held the view that there is no conflict between the fundamental rights and the DPSP, and they were complementary of each other. There was no need to sacrifice one for the sake of the other. Champakam Derarajan Case 1951. Court's ruling. The Supreme Court acknowledged Article 37, which states that directive principles are not enforceable by courts. Fundamental rights take priority. The court declared that the chapter on fundamental rights is paramount. Directive principles must be compatible with and subordinate to the fundamental rights. Precedents established. This landmark judgment established the principle that fundamental rights take precedence over directive principles of state policy, DPSPs, in cases of conflict. Goloknath Case 1967. The court in this case laid down that fundamental rights cannot be abridged diluted to implement the directive principles. Kesavananda Bharati Case 1973. Basic Structure Doctrine. The Supreme Court ruled that Parliament can amend the Constitution, including FRs, to implement DPSPs, but the basic structure of the Constitution, including FRs, cannot be destroyed. Minerva Mills Case 1980. Balance between FR and DPSP. The Supreme Court held that the Constitution exists on the balance of Part 3 and Part 4. Giving absolute primacy to one over other will disturb the harmony of the Constitution. The Constitution bench had held that the fundamental rights and the directive principles are two wheels of the chariot in establishing the egalitarian social order. The judiciary has strived to maintain a balance between individual rights and the state's welfare goals. While FRs prevail, DPSPs can guide legislation as long as they don't unreasonably restrict fundamental rights. This ongoing dialogue ensures the Constitution remains relevant and adaptable. Uniform Civil Code. Quest for a Uniform Civil Code, a path towards a unified nation. The UCC is a directive principle in the Indian Constitution that calls for the creation of a common set of laws governing personal matters for all Indian citizens, regardless of their religion. The UCC would typically apply to matters of personal life such as marriage, divorce, inheritance, adoption. Presently, various religious communities have their own personal laws based on religious scriptures and customs. UCC will promote equality before the law and national integration by removing these religion-based discrepancies. Key developments in legislation. Pre-independence. Lex Loci Report 1840 emphasized the need for uniform codification of laws, but suggested exclusion of personal laws. Queen's 1859 Proclamation promised non-interference in religious matters. B. N. Rand Committee 1941 established to codify Hindu law due to increasing legislation on personal matters. Post-independence. Inclusion in DPSP directive principles of state policy indicated the aspiration for UCC. Hindu Succession Act 1956 codified law for intestate succession among Hindus, Buddhists, Jains, and Sikhs. Special Marriage Act 1954 provided a legal framework for civil marriages outside religious personal law. Supreme Court verdicts. Shabanu case, 1985 called for Parliament to outline the UCC. Sarla Mughal case, 1995 addressed the issue of bigamy and conflict between personal laws on matters of marriage. Sher Banu vs. Union of India case, 2017 challenged the practice of triple talaq and declared it unconstitutional. Uttarakhand makes history with Uniform Civil Code. Uttarakhand became the first state in India to pass a Uniform Civil Code, UCC, bill. This legislation aims to establish a common set of laws governing personal matters like marriage, inheritance, and property rights for all residents, except for tribal communities. Key provisions. Applicability applies to all residents except those protected under tribal laws. Registration requires compulsory registration of marriages within 60 days and live-in relationships within a month. Excludes LGBTQIA+ partnerships, marriage practices, bans polygamy, nikah halala, and triple talaq. Children's rights grants legal recognition to children born from voidable marriages and live-in relationships. Inheritance ensures equal property rights for sons and daughters, abolishing the coparcenary system and providing equal inheritance rights. The need for Uniform Civil Code, equality for all. A UCC would eliminate discriminatory practices based on religion and personal laws, guaranteeing equal rights and opportunities for all citizens. Promoting gender equity. By overriding existing personal laws, the UCC could remove gender-based biases, promoting a more just society. Strengthening secularism. A UCC aligns with India's secular principles by establishing a common set of laws applicable to all citizens, regardless of religion. Freedom of choice. A UCC based on civil law principles would provide greater freedom for individuals to choose their partners without religious or caste restrictions. Protecting vulnerable groups. A UCC could offer stronger safeguards for the rights of women and religious minorities who might be disadvantaged by existing personal laws. Mark of progressive society. Implementing a UCC can be seen as a step towards a more progressive and inclusive society, moving beyond religious and caste divisions. Challenges and issues. Religious interference. The UCC might be seen as an infringement on religious freedom, restricting personal matters traditionally governed by religious codes. Minority apprehensions. Minority communities may fear the imposition of a majority-driven code, leading to the erosion of their unique cultural and legal traditions. Threat to diversity. Enforcing uniformity through a UCC could potentially undermine India's rich tapestry of cultural and religious practices. Drafting difficulties. Creating a UCC universally acceptable to all religious communities poses a significant drafting challenge. Law Commission stance. The 2018 Law Commission report recommended codifying existing personal laws rather than implementing a complete UCC. Potential constitutional conflict. A UCC might raise concerns about balancing the right to equality, Article 14, with the freedom to practice and propagate religion, Article 25. Way forward, piecemeal approach. Consider a gradual introduction of the UCC in stages to allow for smoother adaptation and minimize disruption. Equality at forefront. Throughout the codification process, prioritize achieving equity and equal treatment for all citizens under the law. Open discussion. Encourage public debate and discussion on the proposed codified personal laws to ensure transparency and address concerns. Involving experts. Ensure the drafting process includes consultations with legal and social experts to represent the diverse perspectives of different communities. Establishing universal principles. Develop the UCC based on universal principles that promote fairness and equality for all individuals. The implementation of a Uniform Civil Code, UCC, could be a significant step towards a more inclusive, equal, and secular India. However, achieving this goal requires a sensitive approach. Widespread consultations and a commitment to respecting India's rich cultural diversity are crucial. While striving for uniformity, the process must safeguard the nation's pluralism and ensure that every citizen feels acknowledged, heard, and respected. Keywords: instrument of instructions, non-justiciable, framework for governance, welfare state. Economic democracy. Social and economic democracy. Right to health, Articles 38, 39, 42, 43, and 47 put the obligation on the state in order to ensure the effective realization of the right to health. Efforts towards right to health in recent times. Recently, the Chief Minister of Rajasthan announced the implementation of the Rajasthan model of public health that would include a right to health as well as measures for preventive, primary and curative care as envisioned by the World Health Organization, WHO. Government efforts to ensure right to health. Budget 2021-22 announced various Atmanirbhar Bharat Abhiyan packages by the Government of India, which also includes several short-term and longer-term measures to strengthen the health sector. Production-linked incentive schemes have been announced to boost domestic manufacture of pharmaceuticals and medical devices. To facilitate access to subsidized grains across the country, the One Nation One Ration Card scheme has been enabled in 32 states union territories covering 690 million beneficiaries. O. Allocations for water, sanitation, nutrition, and clean air. The National Health Policy, NHP, 2017, highlights the close links between health, water, and sanitation. O. Pneumococcal vaccine. Budget 2021 was the government's decision to expand the coverage of the pneumococcal vaccine across the country. O. Pneumococcal pneumonia is a major killer of children under the age of 5 years. Once universalist, this indigenously developed vaccine could save up to 50,000 lives annually. Previous your question. 1. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in the Directive Principles of State Policy. 2015 6 Fundamental Duties, Part IV, Article 51A, the Indian Constitution, while outlining fundamental rights for citizens, also emphasizes their corresponding duties. These duties, enshrined in Part 4A, Article 51A, are not enforceable by law but serve as moral and ethical guidelines for responsible citizenship. Features of fundamental duties. Introduced in 1976, originally not part of the Constitution, these duties were added through the 42nd Amendment Act in 1976. Promoting patriotism and social values. They aim to foster a sense of patriotism, national unity, and social responsibility among citizens. Respecting institutions. Duties include upholding the Constitution, respecting the national flag and anthem, and valuing India's rich composite culture. Social harmony and environmental protection. Promoting harmony among all communities and protecting the environment are also emphasized. Individual and collective striving. Duties encourage citizens to strive for excellence in their endeavors, contributing to the nation's progress. Conflict between fundamental duties and rights. The relationship between fundamental duties and fundamental rights was elaborated by the Supreme Court following the judgment in the Kesavananda Bharti case. The Apex Court opined that the fundamental rights and directive principles of state policy are complementary to each other, each supplementing the role of the other in establishing a welfare state. Rights and duties. The concept of interconnected rights and duties is a cornerstone of a healthy society and political system. This principle is enshrined in India's constitution, which outlines both fundamental rights, what citizens can expect from the state, and fundamental duties, the responsibilities citizens owe to the state and society. Philosophical and constitutional underpinnings. Mahatma Gandhi's vision. In his work, Hind Swaraj, Mahatma Gandhi emphasizes that real rights are a result of the performance of duty. This powerful statement underscores the inherent connection between rights and duties, suggesting they are two sides of the same coin. Harold Lasky's perspective. Political theorist Harold Lasky echoed this sentiment, proposing that one man's right is also his duty. This emphasizes that every right we enjoy comes with a corresponding responsibility. Supreme Court verdicts related to fundamental duties. The case of AIMS Students' Union v. I.M.S. affirmed that fundamental duties are equally important as fundamental rights. Rural litigation and entitlement. Kendra v. State of Uttar Pradesh expanded the concept of duties to include environmental responsibilities for both the government and individuals. The Supreme Court's Ranganat Mishra judgment, 2003, argued for the enforcement of fundamental duties through both legal and social sanctions. Benefits of synchronizing rights and duties. A healthy society relies on a strong connection between rights and duties. They function as complementary aspects of a balanced social contract. Duties as responsibility reminders. Duties serve as a vital reminder of the responsibilities that come with enjoying rights. This fosters a sense of accountability and encourages individuals to use their rights constructively. Safeguarding individual liberties. Fulfilling one's duties can actually strengthen individual liberties. By participating responsibly in society, individuals contribute to an environment where everyone's rights are respected. Promoting social capital. Duties contribute to a strong social fabric, social capital, by encouraging mutual respect and cooperation. When everyone fulfills their responsibilities, society as a whole benefits. Supporting state goals and voluntary service. Fulfilling duties helps the state achieve its goals for the common good. Additionally, duties can inspire voluntary service, promoting a sense of civic engagement. Ensuring peace and harmony. A society where individuals exercise their rights responsibly and contribute through duties is more likely to be peaceful and harmonious. Challenges in balancing rights and duties. While the link between rights and duties is crucial, achieving a perfect balance can be challenging. Justiciability versus enforcement. Rights are typically enforceable in courts, justiciable, while duties are often not. This difference in legal status can create a perception that rights are more important. Nature of rights and duties. The nature and scope of rights and duties can differ significantly. In some cases, they might even seem to conflict. Vagueness and subjectivity. Some duties can be vaguely defined or subjective, leading to clashes with religious beliefs or established societal norms. Rights as preconditions. Fulfilling certain rights might be a prerequisite for fulfilling duties. For example, one's right to education allows them to acquire the knowledge and skills needed to fulfill their civic duties. Criticisms of fundamental duties. Incomplete list. Critics argue that the list of fundamental duties is not exhaustive. It may not cover all the important duties expected of a responsible citizen. Unclear wording. Some duties are phrased vaguely, potentially leading to confusion or misinterpretation. Questionable inclusion. Some critics question the necessity of including these duties in the Constitution, arguing they are moral principles understood by most citizens. Limited weight. Since the fundamental duties are placed as an appendix to Part 4 of the Constitution, they lack the legal enforceability of fundamental rights, diminishing their perceived importance. Enforcement through legislations. The fundamental duties, while not directly enforceable by law, find echoes in various existing legislations. Here are some examples. Prevention of Insults to National Honor Act, 1971. This law aligns with the duty to uphold and protect the sovereignty and integrity of India. The Protection of Civil Rights Act, 1955. This act prohibits discrimination based on religion, race, caste, sex, or place of birth, upholding the duty to promote harmony in the spirit of common brotherhood amongst all Indians. Indian Penal Code, 1860. Several sections of the IPC, like those against theft or vandalism, indirectly reinforce the duty to respect the rights of others and the property of the public. Wildlife Protection Act, 1972. This act protects wildlife, corresponding to the duty to protect and improve the environment and to have compassion for all living creatures. Forest Conservation Act, 1980. This act safeguards forests, aligning with the duty to protect and improve the natural environment. The fundamental duties, enshrined in the Indian Constitution, serve as a moral obligation for all citizens, even though they lack direct legal enforcement. They remind us that the fundamental rights we enjoy come with corresponding responsibilities. In the face of future challenges similar to the COVID-19 pandemic, upholding these duties alongside our rights is more crucial than ever. Keywords: social and political life. Harmonious society. Judicial interpretations. Democratic society. Previous year question. 1. Indian Constitution exhibits centralizing tendencies to maintain unity and integrity of the nation. Elucidate in the perspective of the Epidemic Diseases Act, 1897. The Disaster Management Act, 2005, and recently passed Farm Acts. 2020 Citizenship, Part 2, Article 5 to 11. The concept of citizenship forms the foundation of a democratic nation. It defines the relationship between an individual and the state, outlining the rights, privileges, and duties that bind them. The Indian Constitution dedicates a significant portion to this topic, with Part 2 and Articles 5 to 11 providing detailed provisions on citizenship. These provisions initially established automatic citizenship rights, outlined methods for acquiring and relinquishing them, and empowered the Parliament to legislate further on this subject. Citizenship Act 1955. The Act consolidated the law relating to citizenship in India and outlined 5 ways for acquiring citizenship: birth, descent, registration, naturalization, and incorporation of territory. This act has been amended in 1986, 2003, and recently in 2019. The Overseas Citizenship of India, OCI, introduced by the Citizenship Amendment Act, 2005, allows foreigners of Indian origin and spouses of Indian citizens or OCI cardholders to work and live in India indefinitely. Issues in News 108. Migrants from Pakistan granted Indian citizenship in Gujarat context. A 2021 Ministry of Home Affairs order empowers district collectors in specific districts across Gujarat, Chhattisgarh, Rajasthan, Haryana, and Punjab to handle citizenship applications. Under this, few migrants from Pakistan were recently awarded citizenship. This order applies to applications from minority communities in Afghanistan, Bangladesh, and Pakistan. Acquisition of Indian citizenship. There are 4 main ways to acquire Indian citizenship. By birth. This applies if you were born in India after January 26, 1950, with some variations depending on the specific date and your parents' citizenship status. By descent. This is an option if you were born outside India on or after January 26, 1950, to a parent who was an Indian citizen at the time. By registration. This path is for people of Indian origin who have lived in India for 7 years or are married to an Indian citizen and have resided in India for 7 years before filing an application. By naturalization. This is a more general category for people who aren't covered by the above and want to become Indian citizens. There are requirements for residency, good character, intent to reside in India permanently, etc., and other qualifications outlined in the 3rd Schedule of the Citizenship Act, 1955. Citizenship Amendment Rules. 2024 context. The Ministry of Home Affairs, MHA, has taken a significant step towards implementing the Citizenship Amendment Act, CAA, of 2019. Recently, they amended the Citizenship Rules, 2009, and notified the Citizenship Amendment Rules, 2024. The CAA was passed by Parliament in December 2019 under Article 11 of the Constitution, granting the President's assent. However, the lack of implementing rules by the MHA prevented the act from being enforced. Highlights of Rules 2024. Who can apply? The Citizenship Amendment Rules 2024 offer a path to citizenship for several categories of people, including O. Individuals with Indian heritage. O. Spouses of Indian citizens. O. Children of Indian citizens. O. Individuals with historical ties to India. Additional requirements. Applicants seeking citizenship by naturalization will need to O. Submit statements verifying their application details and character references. O. Demonstrate proficiency in an Indian language mentioned in 8th Scheduled. Simplified proof. The new rules ease the burden of proving nationality. Applicants can now use various documents as entry proof, including visas, residence permits, and even Aadhaar cards. Renouncing prior citizenship. If granted Indian citizenship, applicants must renounce any existing citizenship. Application process. Applications are submitted electronically to an empowered committee via a designated district-level committee. The Citizenship Amendment Act, CAA, of 2019. Objective. The CAA amends India's Citizenship Act to offer a path to citizenship for specific religious minorities. Beneficiary. The law expedited citizenship for Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians who entered India from Pakistan, Bangladesh, or Afghanistan before December 31, 2014, if they faced religious persecution in their home country. Exemptions. These minorities are exempt from certain provisions of the Foreigners Act and Passport Act if they entered India before the cutoff date. Reduced residency requirements. The CAA reduces the residency requirement for citizenship by naturalization from 11 years to 5 years for these groups. Arguments in favor of the Act. Humanitarian relief. The CAA offers a pathway to citizenship for persecuted minorities facing religious discrimination in Pakistan, Afghanistan, and Bangladesh. Distinguishing immigrants. The Act aims to identify and provide a legal path for refugees while managing illegal immigration. Concerns and criticisms. Date of entry. The cutoff date for eligibility, December 31, 2014, seems arbitrary. Potential discrimination. The Act's focus on religion might violate India's commitment to equality and secularism. Proof of persecution. Concerns exist regarding the lack of a clear system to verify claims of religious persecution. Unequal treatment. The exclusion of persecuted minorities from other countries and religions raises questions of fairness. International relations. The Act could strain relations with neighboring countries. Way forward. While the CAA aims to help refugees, addressing the raised concerns is crucial for a just and inclusive approach. Since the CAA discriminates based on religion, it strikes at the root of the concept of secularism, which is the basic structure of the Constitution. Therefore, the CAA can be made religion-neutral by granting citizenship to all persecuted persons. However, process of such induction should be careful and gradual, keeping in mind the concerns of national security. Keywords: citizenship, friendly aliens, enemy aliens, overseas citizen, citizenship by naturalization, single citizenship. 8 Scheduled and Tribal Areas, Part 10, Article 244-244A, Part 10 of the Indian Constitution, specifically Article 244, outlines a special administrative system for designated regions known as scheduled areas and tribal areas. These areas are home to a significant tribal population and require a unique approach to administration to ensure their welfare and development. 1. Scheduled areas. These are regions with a significant tribal population. They are given special provisions for self-governance and cultural protection under the 5th Schedule of the Constitution. 2. Tribal areas. These areas, located in the states of Assam, Meghalaya, Tripura, and Mizoram, are administered by the central or state government with a focus on tribal welfare. The 6th Schedule of the Constitution deals with the administration of these tribal areas. 5th Schedule. India's 5th Scheduled areas receive special treatment due to the unique needs of their inhabitants. These areas are home to indigenous communities, who often face social and economic challenges. The government recognizes the need for additional support in these regions. As a result, the standard administrative system is adapted to provide these communities with the resources they need to thrive. This includes a greater role for the central government in ensuring their well-being. Key features of Scheduled Areas Administration. Identifying scheduled areas. The President has the authority to designate specific areas as scheduled areas based on several factors. High tribal population. The area should have a significant concentration of tribal communities. Geographical considerations. The area should be geographically compact and of a reasonable size. Administrative unit. The area should be a viable administrative unit like a district, block, or a smaller tribal unit. Economic disparity. The area should be economically disadvantaged compared to surrounding regions. Shared governance. State administration. State governments have executive power over scheduled areas within their borders. Central oversight. The governor of the state is accountable to the president for the administration and must submit annual reports. The central government can also issue directives to the state regarding the management of these areas. Tribal Advisory Council. States with scheduled areas must establish a Tribes Advisory Council. This council, with a majority of tribal representatives from the state legislature, advises the governor on matters related to the welfare and development of scheduled tribes. Legal framework. Adapting existing laws. the governor can modify or exclude the application of specific central or state laws within a scheduled area. Creating custom regulations, the governor, with the tribe's advisory council's consultation, can make regulations for maintaining peace and good governance within the scheduled area. These regulations may control land transfer among tribal members, regulate land allotment to tribal communities, oversee money lending businesses operating in the area, override existing central or state laws, subject to presidential approval. PESA, 1996. The provisions of Panchayat, Extension to Scheduled Areas, Act, 1996 is applicable in 5th Schedule areas. Appointment of Commission. The President may at any time and shall, at the expiration of 10 years from the commencement of this Constitution by order, appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states. Article 339. Amendment to 5th and 6th Schedule. Any amendment can be done without invoking Article 368 for both 5th and 6th Schedule. Challenges to PESA implementation. Limited resources. The lack of 3FS, funds, functions, and functionaries, hinders effective PESA implementation. Bureaucratic hurdles. Officials often hold final sway, undermining Gram Sabha decision-making. Public awareness gap. Limited knowledge among ordinary people about PES and Gram Sabha functions weakens participation. Ignoring tribal rights. Land acquisition happens without Gram Sabha consent, violating PESA principles. State laws in conflict. State laws for scheduled areas often contradict the spirit of the Central PESA Act. Duplication of efforts. Subsequent laws, like the Land Acquisition Act 2013, reiterate PESA provisions, creating confusion. Way forward. Empowering representatives. Training programs for elected officials will enhance their capacity to effectively lead Gram Sabhas. Building awareness. Legal education for all stakeholders, including community members and officials, is crucial for a Gram Sabha's smooth operation. Supporting tribal rights. Civil society should actively promote a rights-based approach to protect the rights of tribal communities. Implementing PESA. The central government should urge states to swiftly amend existing laws to fully comply with the provisions of the Panchayats, Extension to Scheduled Areas, Act, PESA. Resource management. Amendments to relevant acts like the Indian Forest Act and Land Acquisition Act are necessary to transfer ownership of minor forest produce, water bodies, and land resources to Gram Sabhas and PESA areas. Government initiatives. Forest Rights Act, 2006. This act aims to recognize and vest forest rights in forest-dwelling scheduled tribes. Bandikalan Yojana. This welfare scheme seeks to uplift tribal people and improve the quality of tribal students' education. Keywords. Scheduled areas. Tribes Advisory Council, PESA, self-governance rights. 6th Schedule. The 6th Schedule contains special provisions for the administration of tribal areas in the 4 northeastern states of Assam, Meghalaya, Tripura, and Mizoram. Why special arrangements for Assam, Meghalaya, Tripura, and Mizoram? Distinct cultural identity. The Constitution grants special autonomy to these 4 northeastern states, Assam, Meghalaya, Tripura, and Mizoram, due to their unique cultural identity. Different from other tribes. Unlike tribal communities in other parts of India who have assimilated with the dominant culture, the tribes in these states have largely preserved their traditional way of life, customs, and civilization. Protecting cultural roots. This distinct cultural identity necessitates special arrangements to ensure self-governance and autonomy, allowing these tribes to preserve their heritage. Features of administration in 6th Schedule areas. Governor's authority. The governor holds the power to define and modify the boundaries of autonomous districts and divide districts with diverse tribes into separate regions. Autonomous districts. The tribal areas in these states have been constituted as autonomous districts, each of which has an autonomous district council, and each autonomous region has a separate regional council consisting of 30 members. 26 elected for 5-year term and 4 nominated by governor. These districts exist within the states but have some self-governing powers. District and regional councils. Elected representatives form these councils to manage their respective areas. Legislative powers. Councils can make laws on specific matters like land management, social customs, and village administration. However, these laws require the governor's approval. Judicial powers. Councils can establish courts to handle tribal disputes within their jurisdiction, with limitations set by the governor on appeals reaching the High Court. Development initiatives. Councils can undertake activities like building schools, healthcare facilities, and infrastructure within their districts. They can also regulate business activities by non-tribals. Financial autonomy. Councils have the power to collect taxes. Limited application of laws. Central and state laws may not apply automatically to autonomous districts or may require modifications. Governor's oversight. The governor can appoint commissions to evaluate the administration and dissolve councils based on recommendations, issues, and challenges in 6th Schedule areas. Limited financial autonomy. Councils lack the financial resources to effectively implement their legislative and development plans. Governor's overshadowing authority. Extensive powers vested in the governor can hinder the autonomous functioning of autonomous district councils, ADCs. Uneven distribution of power. Significant variation exists in the level of power and departments allocated to different councils, leading to discontent among some. Uncertain governance. No set time frame for reconstituting dissolved ADCs creates uncertainty and delays elections. Departmental handover issues, delays or resistance in transferring relevant departments to the control of ADCs. Underrepresentation, the structure lacks provisions to ensure adequate participation of women and smaller tribal groups within the councils. Way forward, funding. Autonomous district councils, ADCs, need guaranteed funding from the State Finance Commission to eliminate dependence on arbitrary state government decisions. Timely elections. Ensure timely reconstitution of ADCs within 6 months after dissolution to avoid governance gaps. Traditional institutions. Formally recognize village and hamlet-level tribal political structures for inclusive decision-making. Women's empowerment. Mandate reservation of seats for women representatives in ADCs to break gender barriers in tribal politics. Representation for all. Allocate seats in ADCs and other bodies for smaller tribal communities to ensure their voices are heard. These measures are crucial to address the gap between constitutional protections and the lived realities of tribal communities. They will strengthen tribal self-governance, preserve cultural identity, and contribute to India's rich identity. Keywords: tribal areas, tribal rights, autonomous districts. Regional and district councils. 9. Exploring issues and challenges in India's federal structure. Indian federalism is often described as cooperative federalism or quasi-federalism. The Constitution divides power between the central government and the states, but the center holds some stronger cards. This unique system balances national unity with regional diversity. Exploring issues and challenges in India's federal structure entails a deep examination of Indian federalism, its comparison with global models, and consideration of its challenges and contemporary implications. Indian federalism, a unique model, federalism defined. Federalism is a system of government where power is shared between a central authority and its constituent political units, such as states or provinces. India's federal system is unique, often described as quasi-federal or federation sui generis, meaning a federation of its own kind. Indian versus American federalism. A key distinction exists between Indian and American federalism. In the United States, the federal government arose from an agreement among independent states. In contrast, India's states were created from a unified territory, with powers subsequently distributed to ensure efficient administration and governance. Features of Indian federalism. India's federal system incorporates several key features. Dual government. The system comprises 2 levels of government, the central government and state governments. Division of powers. The 7th schedule of the Constitution clearly divides legislative powers between the center and the states. Written constitution. A written constitution serves as the supreme law, outlining the structure and powers of both levels of government. Supremacy of the Constitution. The Constitution is the ultimate authority, and all laws and actions must be consistent with its provisions. Rigid Constitution. The Constitution can be amended, but the process is relatively complex, ensuring its stability. Independent Judiciary. An independent judiciary interprets the Constitution and resolves disputes between the center and states. Bicameralism. The parliament consists of 2 houses, the Lok Sabha, lower house, and the Rajya Sabha, upper house, representing both national and state interests. Unitary features of Indian Constitution. Single constitution. A single constitution applies to both the Union and all states, providing a sense of national unity. Single citizenship. There is only one Indian citizenship, promoting a sense of national identity. Integrated judiciary. Though with some federal elements, the Indian judiciary functions as a single integrated system. Division of powers. The Constitution distributes power between the central government and states through 3 lists. Union list, national matters, state list, local matters, and concurrent list, shared matters. However, the center has more control in case of conflicts. Emergency powers. During emergencies, the center gains significant power, including making laws on state subjects and taking over state administration. All India services, the IS, IPS, etc., are recruited by the center but serve in states, creating uniformity and central influence. Role of the governor. Appointed by the center, the governor can hold certain state bills, raising concerns about central bias. Parliament's power over state territories. The center can alter state boundaries or create new states without state consent. Centralized fiscal architecture. Financial resources are largely controlled by the central government, with some devolution to states. While these features lean towards a strong center, it is also true that the Indian Constitution provides for cooperative federalism, encouraging the center and states to work together for national progress. The GST Council, an example of cooperative federalism, is a constitutional body that makes recommendations on GST rates and includes representatives from the center and all states. Challenges to Indian federalism. New state formation. Central power to alter state boundaries and names raises concerns about state autonomy. Governor's role. The central government's representative, the governor, can act against state interests. Rajya Sabha representation. Population-based representation in the Rajya Sabha creates an imbalance compared to equal state representation in a true federation. All India services. While these services provide administrative uniformity, they can limit state control over their own executives, IS, IPS, etc. Emergency powers. The center's ability to impose emergencies undermines state autonomy during those periods. Central control mechanisms. Integrated control of elections, auditing, and the ability to veto state bills restricts state autonomy. Drawbacks in the existing structure. Apart from the above challenges, there are certain loopholes in the existing federal structure. Inefficient coordination. Poor collaboration between central and state governments leads to duplication of efforts and wasted resources. Conflicting jurisdictions. Overlap in areas like education and forestry leads to disputes between central and state governments. Centralized planning. Past planning methods have neglected specific needs of states, hindering their growth. Financial imbalance. The central government controls most financial resources, creating dependence on grants and uneven development across states. Political gridlock. Political differences can stall cooperation and hinder effective policy implementation. India's federal structure, balancing federal and unitary elements, despite issues like unequal representation and limited autonomy, has proven adaptable. Current trends suggest a shift towards cooperative federalism, necessitating center-state collaboration. To make this truly effective, addressing power imbalances and seeking equitable power distribution is critical. A strong, responsive federal system is essential for maintaining political stability and vibrant democracy. Keywords: Federation sway generous. Indian Federation versus American Federation. 7th Schedule. Division of powers. Cooperative federalism. Representation in Rajya Sabha. State autonomy. Financial devolution. Interstate disputes. Concurrent appointment of list governor 3 Ils reserved TT, 7 to the power of R7, T4R mutual delegation for president centralizing FEA 2 Re S to the power of OF administrative assent I. Degree C Constitution functions. Emergency All India Provisions Service. Asymmetric federalism in India. In the context of India's vast and diverse society, asymmetric federalism emerges as a concept that acknowledges the need for unequal power sharing between the center and states, and even among different states themselves. This approach deviates from the traditional federal model of uniformity, recognizing the distinct needs and historical backgrounds of various regions. Why India needs asymmetric federalism strengthens unity. Autonomy fosters a sense of ownership and reduces separatist movements, promoting national unity. Celebrates diversity. It upholds unity in diversity by protecting vulnerable groups with special rights. Promotes social justice. Special provisions help achieve social justice by addressing historical disadvantages. Strengthening democracy and representation. Asymmetric federalism ensures representation of minority areas, thereby reinforcing democracy. FIC. Centralizing features of the Indian Constitution preserves culture. Provisions like Article 371 empower northeastern states to maintain their unique customs, laws, and traditions. Empowers minorities. Asymmetrical federalism ensures representation for diverse regions, strengthening democracy. Counters radicalization. Increased regional control helps counter radicalization and integrate communities into national development. Asymmetric federalism is an integral part of India's complex and layered federal structure. It provides a unique framework to deal with India's incredible diversity and varied regional requirements. However, it's crucial to address the challenges it poses and strive for a more transparent and rules-based asymmetry. Keywords: asymmetric federalism. Constituent units. Securing rights. Ethnicity and culture protection. Social fabric. Democracy and representation. Unity and diversity. Social justice. Center-state conflicts. Anti-egalitarian nature. Constitutional provisions. Center-state relationship. India, being a federal union of states, operates on the principle of distribution of power between the center and states. This relationship is enshrined in the Indian Constitution and represents a multi-level governance framework essential for India's stability, security, and economic development. Key Supreme Court cases. S.R. Bommai v. Union of India, 1994. B.P. Singhal v. Union of India, 2010. Kuldip Nair v. Union of India, 2006. Current tensions in center-state relations, central overreach concerns. Misuse of Article 356. Concerns exist regarding the central government's potential misuse of Article 356, which allows them to impose president's rule in states. Governor's appointment and removal. Discontent surrounds the perceived central government influence in appointing and removing governors, impacting their neutrality. Encroachment on state subjects. States raise concerns about the central government's interference in areas listed under the state list of the Constitution. Resource sharing and power dynamics. Unequal financial allocation. Disagreements arise regarding the allocation of financial resources between the central government and states. Management of all India services. Issues persist in the way all India services, crucial for administration, are managed jointly by the center and states. Asymmetrical federalism. The perception of an asymmetrical federal structure, where the central government holds more power, creates tension. Policy implementation challenges. Disagreements on national education policy. Differences in perspectives exist between the center and states regarding the implementation of the National Education Policy 2020. Implementing central laws. States may find it challenging to implement certain central laws, like the Citizenship Amendment Act, due to potential conflicts with local context or priorities. India's federal structure, though not without its hurdles, is constantly adapting and progressing. It thrives on ongoing discussions, adherence to the Constitution, and a recognition of common goals. Ultimately, the objective is to nurture a robust, collaborative, and even mildly competitive federal system that embodies the essence of the Constitution and fulfills the desires of its citizens. Keywords: historical evolution, cooperative federalism, competitive federalism, asymmetric federalism, allocation of financial resources. Ways and means to better manage center-state relationship. India's federal system, enshrined in the Constitution, balances power between the central government and states. While India leans towards a unitary system, center-state relations have transformed over time, shaped by social, political, and economic changes, along with interpretations of the Constitution. Consequently, effective management of this dynamic is crucial for good governance. Numerous commissions have offered recommendations to improve center-state relations in response to the country's evolving needs. Important commissions and their recommendations. First, Administrative Reforms Commission, ARC. Establish an interstate council, Article 263. Appoint governors with strong public experience. Maximize delegation of power to states. Increase financial resources for states. Sarkaria Commission. Make the interstate council permanent. Limit use of President's Rule, Article 356. Strengthen all India's services and consider creating more. Improve communication on withheld assent to state bills. Revive zonal councils. Consult states on security deployment, concurrent list subjects, and governor appointments. Punchy Commission. Improve communication between President and states on pending bills. Grant states greater flexibility on state list subjects and concurrent list items. Limit discretionary powers of governors under Article 163. Establish guidelines for chief minister appointments and hung assemblies. Make the Finance Commission permanent with rotating membership. Create judicial councils for budget preparation and sharing. Provide equal seats in the Rajya Sabha for all states. National Commission to review the working of the Constitution, NCRWC. Establish an Interstate Trade and Commerce Commission, Article 307. Offer states a chance to address political breakdowns before invoking Article 356. In conclusion, better managing the center-state relationship is key to the overall development and progress of the nation. As Dr. B.R. Ambedkar rightly noted, though the country and the people may be divided into different states for convenience of administration, the country is one integral whole. Its people a single people living under a single imperium derived from a single source. NITI Aayog to also promote cooperative federalism. Established in 2015, the National Institution for Transforming India, NITI Aayog, plays a critical role in India's development. It fosters cooperative federalism, ensuring states have a voice in national policy-making. This promotes balanced economic and social progress across the nation. Note: this topic is covered in Prahaar Governance Booklet. Kindly refer it. State river water dispute flowing across India's varied landscapes. Numerous rivers act as vital resources for millions of people. However, these shared waterways, often crossing state borders, have become a growing source of tension. Several disputes have emerged, including those concerning the Kaveri, Mahanadi, Mahadayi, Krishna, Godavari, Ravi Bias rivers, and the Vamsadhara, further inflating the interstate tensions. Constitutional and statutory provisions related to interstate water disputes. Article 262(1). This article empowers the Parliament to enact legislation for the adjudication of interstate river waters dispute. Article 262(2). This clause grants Parliament the authority to exclude the Supreme Court or any other court from exercising jurisdiction over interstate river waters disputes. River Board Act, 1956. This act was established with the intent that the center would regulate and develop interstate rivers and valleys in the public interest. Interstate River Water Disputes Act, 1956. This act allows Parliament to establish a tribunal to settle interstate river water disputes. It also excludes the Supreme Court from jurisdiction over such cases. Reasons behind rising interstate river water disputes. Political interference. Politicians sometimes exploit public emotions during river disputes, creating obstacles to resolution, e.g., Kaveri water dispute. State bifurcation. Dividing states, like Andhra Pradesh and Telangana, leads to new water-sharing disputes over rivers like the Godavari. Water scarcity. India faces a critical water shortage, with just 4% of global water resources despite housing 18% of the world's population. Competing interests. Disputes erupt when one state's actions, such as water usage, negatively impact another. Deteriorating quality. With growing demand and pollution, water-sharing disputes are likely to intensify as competition for clean water increases. Challenges in resolving interstate water disputes. Historical and geographic confusion. Redrawn state boundaries often disregard natural water flow patterns, leading to disputes about water rights based on historical usage or geography. Constitutional legal ambiguity. The division of power creates ambiguity. While states manage water use, the central government regulates interstate river waters. This overlapping authority complicates dispute resolution. Institutional uncertainty. Article 262 restricts the Supreme Court's involvement in water disputes, but Article 136 allows them to review tribunal decisions. This inconsistency creates uncertainty about the final legal authority. Implementation hurdles. Failure to implement tribunal awards by the executive branch significantly hinders the resolution of disputes, leaving conflicts unresolved. Outdated approach. Over-reliance on traditional engineering solutions without considering technological advancements, variable rainfall, and other factors hinders effective management of water resources. Challenges with the Interstate Water Disputes Act, 1956. Inefficient dispute resolution. New tribunals for each dispute create redundancy, and undefined timeframes lead to delays. Weak enforcement. Tribunal decisions lack a mechanism for implementation. Protracted appeals. Appeals against decisions can further stall resolutions. Way forward. Robust mechanism. Establish a strong mechanism to enforce tribunal awards. Legal clarity. The Supreme Court should provide clear legal guidance on mechanisms for implementing tribunal awards. Holistic basin management. Develop comprehensive strategies for river basin issues, including long-term sustainability. Sharing during scarcity. The Supreme Court should guide states towards a workable formula for sharing water in times of shortage. Moving beyond politics, find an alternative to political negotiation for a lasting solution to water conflicts. Balancing needs. Integrate ecological restoration, aquatic biodiversity preservation, and sustainable water management practices into basin plans. Enactment of the pending bill. The Interstate River Water Disputes Amendment Bill 2019 seeks to address the issues of existing laws and regulations. Its enactment will create a robust mechanism to address river water disputes in India. Water is a vital resource, and interstate disputes can significantly impact livelihoods. A multifaceted approach is needed to achieve sustainable solutions. Including water in the concurrent list can provide greater clarity, while establishing river basin organizations can improve river management. Ultimately, a cooperative approach to water governance is essential. Demand for a Samaleli or STTS in India. Discussions about federalism often weigh the need for independent state power against maintaining a unified nation. This has led to growing calls for the creation of smaller states, like Vidarbha and Purvanchal. These demands are driven by a desire for greater control over regional affairs, preserving cultural identities, improving administrative effectiveness, and achieving fairer development across the country. Why smaller states are demanded. Underrepresented regions. Regions lacking political influence often seek statehood for greater representation. Cultural identity. Areas with distinct cultural traits may seek autonomy to preserve their heritage, e.g., Gorkhaland. Administrative neglect. If a region feels ignored by the central administration, a demand for a separate state may arise. Political manipulation. Politicians might exploit regional sentiments for electoral gains. Unequal development. Economic disparity within a state can fuel demands for separate states, e.g., Bundelkhand, Purvanchal. Potential benefits of smaller states. Efficient administration. Smaller size can streamline administration and resource allocation. Stronger fiscal management. Focused governance can lead to better financial management. Addressing regional needs. Smaller states can tailor policies to address specific regional issues. Optimal resource use. Reduced administrative costs can free up resources for development projects. Inclusive growth. Smaller states may promote balanced development across regions and empower minorities, as envisioned by Dr. B.R. Ambedkar. Challenges of creating smaller states. Mixed performance. Some newly formed states haven't shown significant improvement in development. Leadership issues. Lack of experienced leadership can hinder governance in new states. Financial strain. Setting up new administrative structures can strain financial resources. Central dependence. Smaller states may rely heavily on central financial assistance. Infrastructure gap. Developing necessary infrastructure in new states can be time-consuming and expensive. Way forward. Objective criteria. Establish a clear set of objective criteria, such as population size, economic viability, and administrative efficiency, to guide decisions on statehood demands. This could help prevent purely political considerations from driving the process. Comprehensive needs assessment. Conduct thorough needs assessments that consider the developmental goals, cultural identity, and economic realities of the region seeking statehood. Focus on decentralization. Explore alternative solutions like strengthening existing local governance structures through decentralization. This could empower regions without resorting to full statehood. Fiscal responsibility. Ensure any new state has a sound financial plan that demonstrates its ability to be self-sustaining and manage its resources effectively. Interstate cooperation. Encourage collaboration among states, especially when dealing with shared resources or regional development challenges. As India's federal system adjusts to new circumstances, it must find ways to address regional desires and streamline administration, all while keeping economic health in mind. The growing calls for creation of new, smaller states highlight the need for a fresh look at India's federal structure. Issues and news. Article 370 context. The Supreme Court's highest panel recently affirmed the central government's 2019 action to revoke Jammu and Kashmir's special status under Article 370 of the Constitution. Key observations and directions by SC. No internal sovereignty. J&K was ruled not to possess any internal sovereignty after its accession to India in 1947. This conclusion was based on historical documents in the J&K Constitution itself. Temporary provision. Article 370 was deemed a temporary and transitional provision based on its historical context and placement within the Constitution. Presidential authority upheld. The court validated the President's 2019 proclamations modifying Article 370 and dissolving the state's Constituent Assembly. Notably, consultation with the state government was deemed unnecessary for these actions. Elections. The court mandated the Election Commission to conduct elections for the J&K Legislative Assembly by September 30, 2024. Statehood restoration. The court urged the government to expedite the restoration of statehood to J&K. Truth and reconciliation. The court recommended the establishment of a Truth and Reconciliation Commission to investigate human rights violations in J&K and promote reconciliation. Abrogation of Article 370. India's constitution previously granted Jammu and Kashmir special status through Article 370. This included distinct laws, a separate flag, and broader autonomy compared to other Indian territories. On August 5, 2019, the Indian government revoked Article 370, dissolving Jammu and Kashmir's statehood. The region was subsequently divided into two centrally administered union territories, Jammu and Kashmir and Ladakh. Changes in governance, representation. J&K's 5 Lok Sabha seats, while Ladakh gets 1. Administration. J&K transitions from a governor to a lieutenant governor. Legislative power. J&K retains a legislative assembly with limitations on lawmaking. The revocation of Article 370 marks a significant shift for Jammu and Kashmir and Ladakh. While the move promises integration and development, addressing legal concerns and local anxieties remains crucial for a stable and prosperous future. Upholding democratic principles, respecting the region's cultural identity, initiating dialogues with stakeholders, and driving development can enable a peaceful and prosperous Jammu and Kashmir, reflecting Atal Bihari Vajpayee's ideals of Kashmiriyat, Insaniyat, and Jamhuriyat. Government of National Capital Territory of Delhi, Amendment, Act 2023 context. Indian Parliament recently passed GNCTD, Amendment, Act 2023. It has raised a long-standing debate about governance in Delhi. Unique status. Delhi is a National Capital Territory, NCT, with a legislative assembly but limited powers compared to full-fledged states. Supreme Court's view. A 2023 Supreme Court judgment granted Delhi control over most services, except for police, land, and public order. Key provisions of the Act. National Capital Civil Services Authority, NC say this body, appointed by the central government, advises the LG on service matters. LG's discretion. The Act expands the LG's power to approve or reject NC recommendations and act independently on certain issues. Increased central control. The central government gains control over officer transfers and postings, potentially impacting the triple chain of accountability ministers' legislature electorate. Reporting requirements. Certain matters must be routed through the LG before decisions are made. Issues raised. Central government overreach. Critics argue the Act undermines the Supreme Court's judgment and gives excessive control to the central government. Weakened accountability. The Act potentially weakens the triple chain of accountability in Delhi's governance. Unclear definitions. The Act doesn't define controversial matters that require the LG's notification. Looking ahead, learning from others, studying models of capital city governance in other countries, federal district, city-state, etc., could offer solutions. Decentralization. A two-tier system with elected municipal councils and a regional government could improve local decision-making. Domain demarcation. Central government areas could be under central administration, while the rest functions as a state. Enforcement powers. Municipalities could handle civil compliance with community police, while Delhi police focuses on criminal matters. The GNCTD Act has sparked debate about balancing the need for a strong central government in the national capital with granting Delhi greater autonomy. Exploring alternative governance models and fostering collaboration might pave the way for a more stable and efficient administrative system in Delhi. Keywords: Unitarian Constitution, Federalism, Cooperative Federalism, Financial Decentralization, Regional Autonomy. Previous year's question. 1. Explain the significance of the 101st Constitutional Amendment Act. To what extent does it reflect the accommodative spirit of federalism? 2023. 2. While the national political parties in India favor centralization, the regional parties are in favor of state autonomy. Comment. 2022. 3. How far do you think cooperation, competition, and confrontation have shaped the nature of federation in India. Cite some recent examples to validate your answer. 2020. 4. From the resolution of contentious issues regarding distribution of legislative powers by the courts, principle of federal supremacy and harmonious construction have emerged. Explain. 2019. 5. The concept of cooperative federalism has been increasingly emphasized in recent years. Highlight the drawbacks in the existing structure and the extent to which cooperative federalism would answer the shortcomings. 2015. 6. Though the federal principle is dominant in our Constitution and that principle is one of its basic features, but it is equally true that federalism under the Indian Constitution leans in favor of a strong center, a feature that militates against the concept of strong federalism. Discuss. 2014. 7. Constitutional mechanisms to resolve the interstate water disputes have failed to address and solve the problems. Is the failure due to structural or process inadequacy, or both? Discuss. 2013. 1,000 plus UPSC PYQ-based questions. Comprehensive answers W with M-Model approach. Topic-wise subject compilation S. Q and A bank. General Studies 2. Mains Wallah. ONE. S2P solution for Mains answer W writing. Examples in D case studies enriched MATE REAL. Set of 4 GS booklets. 0 OnlyIAS. Our offline centers. Carol Bogam Mukherjee NAGA RI Lucknow. INML. Q9920613613 OnlyIAS. Content separation of power and functional overlapping. India's democratic system reflects the idea of separation of powers, even without explicitly mentioning it. This principle, championed by Montesquieu, divides government into legislative, executive, and judicial branches to prevent any single group from holding too much power. While India's constitution allows some overlap between these branches, it also ensures a complex interplay with checks and balances. Constitutional provisions and the separation of powers, inherent doctrine. The Indian Constitution implicitly integrates the doctrine of separation of powers. Articles like 50,122 and 212 all contribute towards maintaining a delicate balance among the three branches. Article 50. This urges the state to strive for a distinct separation between the judiciary and the executive. Articles 122 and 212. These articles prevent courts from questioning parliamentary and legislative proceedings, effectively separating the judicial and legislative domains. Different models of separation of powers. The principle of separation of powers, dividing government functions among distinct branches, is implemented differently across countries. Strict separation. The United States exemplifies a rigid model with clear lines separating the legislative, executive, and judicial branches. Flexible model. In countries like the UK and India, the branches exhibit more overlap in functions and personnel, fostering a more collaborative approach. Functional overlap between executive and legislature. As Indian Constitution doesn't follow strict separation of powers, there are many instances where functional overlap between executive and legislature occurs. Role of President. President acts as the head of both the executive and legislature. Safeguard against despotism. Maintain efficiency in UTB administration. Q pound. Check on functions of other organs. Safeguard against dictatorship tendencies. Safeguard against arbitrariness. Fig. Significance of separation of powers. Ordinance promulgation. The President's authority to promulgate ordinances, despite it being primarily a legislative function, indicates the functional overlap between the branches. Council of Ministers. Ministers are legislators who also head executive departments, blurring the lines. Delegated legislation. Legislature empowers the executive to make rules for effective implementation of laws. Party system. Shared party affiliation between legislators and the executive can lead to the legislature rubber-stamping executive decisions. No confidence motion. A party in power may influence the legislature to avoid a no-confidence motion. Whip system. Political parties can use party whips to enforce discipline among legislators, reducing independent voting. Way forward. While complete separation of powers isn't practical in India's system, steps can be taken to minimize overlap and ensure greater accountability, strengthening independent institutions. Empowering institutions like the Lok Sabha Secretariat and Comptroller and Auditor General, CAG, can provide independent scrutiny of the executive. Parliamentary committees. Revitalizing parliamentary committees with more teeth for in-depth scrutiny of legislation and executive actions. Reduced reliance on delegated legislation. The legislature should clearly define the scope of delegated legislation and maintain oversight of its implementation. Electoral reforms. Promoting inter-party democracy and encouraging independent candidates can reduce the influence of party whips on voting behavior. Public interest groups. Pigs. Encouraging the growth of strong pigs that hold the government accountable and provide alternative viewpoints to the legislature. Judicial review. Upholding judicial independence to ensure effective checks on both the legislature and the executive. Principle of constitutional objectivity. In NCT versus UI case, Justice Chandrachud emphasized constitutional objectivity as the core principle to balance legislature and executive interactions. It helps ensure that each branch operates within its designated sphere, thereby preventing absolute power accumulation. Functional overlap between judiciary and legislature. The Indian Constitution aims for a separation of powers, but some areas show overlap between the judiciary and the legislature. Here are some instances of such overlap. Judicial review versus legislative power. The judiciary can strike down laws deemed unconstitutional, potentially limiting the legislature's power to make laws. Example: Supreme Court striking down the National Judicial Appointments Commission Act in 2015. Public interest litigation. PLPLs allow the judiciary to take on issues of social justice, sometimes venturing into policy areas traditionally reserved for the legislature. Example: PL leading to the Right to Education Act. Legislative overreach. The legislature may pass laws aimed at curbing judicial activism perceived as overstepping judicial boundaries. Example: attempts to restrict PLs or limit the judiciary's power to review laws. Judicial overreach. Certain landmark cases have seen the judiciary stepping in to create guidelines in the absence of relevant laws, further blurring the lines between legislative and judicial functions. Example: the 2G spectrum case, where the judiciary's cancellation of licenses led to policy changes by the executive, exemplifies the complex interplay between the branches. Parliamentary privileges. The legislature has the power to punish for contempt, which can create a conflict with the judiciary's authority. Minimizing overlap between judiciary and legislature. While some overlap fosters checks and balances, excessive overlap can lead to confusion and undermine the independence of both branches. Here are ways to minimize it. Judicial deference. The judiciary should exercise restraint in striking down laws, giving due respect to the legislature's lawmaking power. Evolving standards for PLs. Clearer guidelines can be established for PLs, ensuring they address genuine public interest without encroaching on legislative functions. Independent judicial appointments. A more transparent and independent process for appointing judges can strengthen judicial legitimacy. Respect for judicial review. The legislature should acknowledge the judiciary's role in upholding the Constitution and avoid attempts to undermine judicial review. Defining parliamentary privileges. Clearer definitions of parliamentary privileges can minimize conflict with the judiciary's authority. By implementing these measures, India can strive for a more balanced and effective system of checks and balances between the judiciary and the legislature. This will ensure a healthy democracy with clear boundaries and respect for each branch's role. Functional overlap between judiciary and executive. While the judiciary interprets laws and the executive implements them, there are areas where their functions overlap, raising concerns about potential influence. Here are 5 instances. Appointment of judges. The executive plays a role in appointing judges through a collegium system, raising questions about potential bias. Tribunals. The government sets up tribunals with quasi-judicial powers, blurring the lines between judicial interpretation and executive action. Presidential gubernatorial immunity. The president and governors enjoy immunity from court proceedings for official actions, limiting judicial oversight. Mercy powers. The president and governors, as executive members, wield the power to grant mercy, a typically judicial function, underlining the functional overlap. Contempt of court. The power vested in courts to punish for contempt can be misused to stifle criticism or dissent. Minimizing overlap between judiciary and executive to ensure a healthy balance. Here are some ways to minimize overlap. Independent judiciary appointments. Exploring a more transparent and independent process for appointing judges, potentially involving a citizens panel. Specialization of tribunals. Clearly define the scope of tribunals and ensure they are staffed by qualified judicial members. Judicial deference. The judiciary should exercise restraint in intervening in policy decisions, unless there's a clear violation of fundamental rights. Review of immunity provisions. Revisit the concept of presidential gubernatorial immunity to ensure accountability for actions impacting citizens' rights. Clear contempt guidelines. Establish clear and objective guidelines for contempt of court to prevent its misuse. By implementing these measures, India can strive for a more balanced system where both the judiciary and the executive function effectively within their designated roles, ultimately strengthening democratic principles. Why coordination between legislature, executive, and judiciary is necessary. While the separation of powers ensures checks and balances, effective governance requires a degree of coordination between the legislature, executive, and judiciary. Here's why. Effective lawmaking. The judiciary's interpretation of existing laws can inform the legislature when crafting new legislation to address ambiguities or unforeseen consequences. Example: landmark Supreme Court judgments on privacy rights can guide the legislature in formulating a robust data protection law. Smooth implementation. Clear communication between the judiciary and the executive on legal interpretations ensures smooth implementation of laws and minimizes disputes. Example: collaborative workshops for judges and bureaucrats on newly enacted labor laws can foster a common understanding for better enforcement. Swift action on critical issues. In times of crisis or national emergencies, coordinated action between all branches is essential for a swift and effective response. Example: During a pandemic, the judiciary can expedite legal challenges to lockdown measures while the executive enforces them, ensuring both public health and due process, maintaining public trust. A well-coordinated government where each branch respects the other's domain fosters public trust in the system and the rule of law. Example: collaborative efforts to address judicial vacancies or tackle corruption can enhance public confidence in the justice system. Globalized world. In an increasingly interconnected world, coordinated action between branches is necessary to address transnational issues like cybercrime or environmental degradation. Example: collaboration between the legislature, executive, and judiciary is crucial for framing effective extradition treaties and implementing international environmental agreements. These examples highlight that while checks and balances are essential, a healthy level of coordination between the branches is vital for effective governance in a complex world. Fostering coordination between legislature, executive, and judiciary. The Indian Constitution embodies the concept of separation of powers, but effective governance necessitates a degree of coordination between the branches. Here are some ways to achieve this. Interbranch communication channels. Establishing formal channels for communication, like regular consultative meetings between representatives of each branch, can foster better understanding and collaboration. Secondment programs. Temporary exchanges of personnel between branches can provide valuable insights into each other's functioning and challenges. Memoranda of Understanding. MOUs. Developing MOUs outlining protocols for cooperation on specific issues can promote coordinated action in areas like judicial training for civil servants or fast-track courts for specific types of cases. Joint conferences. Organizing periodic joint conferences on matters of national importance can encourage open dialogue and collaborative problem-solving. Strengthening parliamentary committees. Empowering parliamentary committees with greater oversight authority can create a platform for constructive scrutiny and interaction with the executive. Respect for judicial review. The executive should respect judicial pronouncements and make bona fide efforts to implement them within the legal framework. By implementing these measures, India can nurture a culture of mutual respect and understanding between the branches. This fosters a more collaborative approach to governance, ultimately benefiting the nation's progress and its citizens. Doctrine of checks and balances. The doctrine of checks and balances aims to prevent any one branch of government from becoming too powerful. This safeguards citizens from arbitrary or tyrannical use of state power. Indian constitutional provisions. The Indian Constitution embodies this principle through various provisions. These include judicial review. Article 13. The judiciary can review laws passed by the legislature and strike them down if found unconstitutional. Judicial limitations. Article 21. The judiciary itself is bound by established legal procedures. Executive appointments. The executive appoints judges, with the president playing a role. Parliamentary system. India follows a parliamentary form of government, where the executive is drawn from the legislature. Examples of checks and balances. Legislative versus executive. The president can summon, prorogue, adjourn for a brief period, or dissolve parliament. Article 85. Conversely, parliament can impeach the president for violating the Constitution. Article 61. Executive versus judiciary. The executive appoints judges, but the judiciary can review the executive's actions through judicial review, e.g., Kesavananda Bharati v. State of Kerala and Minerva Mills v. Union of India. Legislative versus judiciary. Parliament can remove judges through impeachment, but the judiciary can invalidate laws they deem unconstitutional, e.g., Kesavananda Bharati case. Examples in action. Goloknath case, 1967. The court declared an amendment limiting fundamental rights as unconstitutional. Kesavananda Bharati case, 1973. The court established the basic structure doctrine, limiting Parliament's amendment power. Indira Gandhi v. Rajnarine case, 1975. An amendment protecting the Prime Minister from election challenges was struck down. Checks and balances go beyond clear separation. Each branch plays a specialized role, contributing to efficient governance. This system is vital to a healthy democracy, ensuring no single entity holds absolute power and citizens' rights are protected. Keywords: checks and balances. Constitutional objectivity. Executive, legislative, and judicial overlap. Judicial overreach. Harmonious coordination. Doctrine of prospective overruling. Ultra vires, beyond the powers. Rule of law and equality. Previous year question. 1. Judicial legislation is antithetical to the doctrine of separation of powers as envisaged in the Indian Constitution. In this context, justify the filing of a large number of public interest petitions praying for issuing guidelines to executive authorities. 2020. 2. Do you think the Constitution of India does not accept the principle of strict separation of powers, rather it is based on the principle of checks and balance? Explain. 2019. 3. Resorting to ordinances has always raised concern on violation of the spirit of separation of powers doctrine. While noting the rationales justifying the power to promulgate ordinances, analyze whether the decisions of the Supreme Court on the issue have further facilitated resorting to this power. Should the power to promulgate ordinances be repealed? 2015. 4. Starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by judicial activism in achieving the ideals of democracy. 2014. 5. The Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. Discuss critically. 2013-11 Parlia BM UESN and TEASNS. DPS OTW at EERLSE and GIPS RLIAVTILUE RGEESS SATN RDUICSTSUU REES AFRUINSC and TGIOO and UNTGO FCTOH NEDSEUCD of the strength and effectiveness of any democratic political system largely rest on its legislative body's functional efficacy. In India, the essence of democracy is upheld by our parliament and state legislatures. As the institutional pillars of the world's largest democracy, they are instrumental in upholding constitutionalism, lawmaking, holding the executive accountable, and representing the will of the people. Features of parliamentary form of government, nominal and real executives. The president serves as the de jure executive while the prime minister functions as the de facto executive. Collective responsibility. The ministers are collectively responsible to the parliament, specifically to the Lok Sabha, Article 75. Majority party rule. The political party with a majority in Lok Sabha forms the government. Double membership. The ministers are members of both the legislature and the executive. Leadership of the prime minister. The prime minister is the central figure in the parliamentary system. Political homogeneity. The members of the Council of Ministers typically belong to the same political party, ensuring ideological consistency. Dissolution of lower house. The Lok Sabha can be dissolved by the president upon the prime minister's recommendation. Secrecy. Ministers are bound by the principle of secrecy of procedure and cannot divulge information about their proceedings, policies, and decisions. Reasons for adoption. Avoidance of legislative-executive conflicts. A parliamentary system reduces conflicts between the executive and legislative branches. Familiarity with the system. The Indian political tradition had been familiar with the parliamentary system due to the British influence. Representation. A parliamentary system allows representation of various sections, interests, and regions in the government. Preference for responsibility. Dr. B.R. Ambedkar highlighted the need for a democratic executive to exhibit both stability and responsibility. Functions of the Parliament. Lawmaking. The Parliament is responsible for making new laws, amending existing ones, and even making changes to the Constitution. Control over executive. The Parliament holds the executive accountable using various mechanisms such as the no-confidence motion, censure motion, and question hour. Election function. The Parliament participates in the election of the President and Vice President. Internally, it also elects the chairperson of each House and heads of various parliamentary committees. Management of finances. The executive cannot withdraw or use funds from the Consolidated Fund of India without the Parliament's authorization. The budget is presented before the Parliament and scrutinized by committees like the Public Accounts Committee and Estimates Committee. Quasi-judicial functions. The Parliament exercises quasi-judicial powers. This includes the formation of inquiry committees, the impeachment process of the President, the removal of judges of the High Court and Supreme Court, and upholding parliamentary privileges. Issues faced by Indian legislature. Decline in the number of sittings. The 17th Lok Sabha sat for a total of 1,354 hours, which is significantly less than the average for all full-term Lok Sabha. Discipline and decorum. The Parliament has been losing valuable time due to disruptions and indiscipline among members. Low representation of women. Despite an increase in the percentage of women in the Lok Sabha over the years, it still remains low compared to other democracies. Resort to money bill route. Several bills that do not strictly fit into the category of money bills have been passed as such, avoiding scrutiny and debate in the Rajya Sabha. Inadequate discussion. Bills are often passed with minimal discussion and often by voice vote, which leads to a lack of transparency and debate. Reduced scrutiny by parliamentary committees. Fewer bills are being referred to parliamentary committees for detailed examination. While 60% of the bills in the 14th Lok Sabha and 71% in the 15th Lok Sabha were referred to DRSCs concerned, this proportion came down to 25% in the 16th Lok Sabha. Uncodified parliamentary privileges. The lack of codified rules on parliamentary privileges has led to concerns over their misuse. Legislation through ordinances. There has been an increase in the number of laws being passed through ordinances, bypassing the usual legislative process. Productivity in the Parliament. Parliament serves as the paramount democratic forum in a country, shaping its destiny through debate, deliberation, and decision-making. However, the decreasing productivity of the Indian Parliament, evident in recent sessions, raises concerns about the effectiveness of this crucial democratic institution. Reasons for low productivity. Institutional decline. Key positions such as Deputy Speaker of Lok Sabha and Leader of Opposition have not been filled, despite constitutional requirements. Increasing disruptions. Contentious issues such as the Pegasus controversy, farm bills, inflation concerns, and disagreements over various bills have disrupted recent sessions. Inadequate time for opposition. Opposition members expressed dissatisfaction over insufficient time to air grievances. Violation of parliamentary norms. Indiscipline among members, such as the unruly behavior during the bifurcation of Andhra Pradesh, is a concern. Insufficient time for unlisted discussion. Limited time for unlisted questions and objections also triggers disruptions. Unresponsive government attitude. Instances like refusal to form a joint parliamentary committee on the 2G scam have triggered disruptions. Absence of prompt disciplinary action. Lack of clear rules and action against disruptors encourages disorderly conduct. Vital stats on functioning of the 17th Lok Sabha PRS Legislative Research Report finding, the 17th Lok Sabha LS held its sessions between June 2019 and February 2024. During this period, it held 274 sittings and passed 179 bills, excluding finance and appropriation bills. Question hour functioned for 60% of scheduled time in LS and 52% in Rajya Sabha. Fewest sittings amongst all full-term Lok Sabhas with 206 instances of suspension of members of parliament. Average annual sitting days down to 55 from 135 in the first LS. For the first time, LS did not elect a deputy speaker for the entire duration. Article 93 of the Constitution requires that LS elect a speaker and a deputy speaker as soon as may be. Time spent on budget discussions has reduced with about 80% of the budget voted without discussion. Suggested parliamentary reforms fix a minimum number of sittings, ensuring a minimum number of sessions, such as 120 for the Lok Sabha and 100 for the Rajya Sabha, can increase the parliament's productivity and functioning. Codify parliamentary privileges. Clear codification of parliamentary privileges can prevent their misuse and ambiguity. Review of anti-defection law. In order to revive debate and deliberations in the parliament, the use of whip can be restricted to no confidence motion only. Strengthen departmental committees and accountability, improving the functionality of departmental committees like longer tenure, instead of the present 1 year, promoting specialization, improve the quality of legislation. Streamlining legislative functions, along with better utilization of the Law Commission, can enhance the quality of legislation. Enhance information supply for members. Keeping members of Parliament updated with developments in areas of parliamentary concern can improve the quality of debates and decision-making. Curbing criminalization of politics and strict code of conduct will improve the quality of members. Improve the public image of Parliament. Access to public opinion and fostering a better relationship with the public can improve the Parliament's image. Use of technology for virtual meetings. Leveraging technology for virtual meetings can ensure legislative work continues during crises, like the COVID-19 pandemic. Introduction of legislative impact assessment. Introducing legislative impact assessments can improve awareness and legal evaluation of proposed laws. Keywords: Public Accounts Committee, Estimates Committee, Quasi-Judicial, Question Hour, Anti-Defection Law, Whip Order, Criminalization of Politics, Legislative Impact Assessment. Parliamentary Privileges in C. de Soren v. Union of India, 2024. A 7-judge constitution bench of the SC overruled its 1998 judgment in the P.V. Narasimha Rao case. In current judgment, the SC said that legislators cannot claim immunity from prosecution for taking bribes for speech vote in the House. Key highlights of judgment: bribery is not immune. MPSMLAs accused of taking bribes cannot claim any immunity from prosecution under Articles 105 and 194 of the Constitution. Twofold test. Assertion of a privilege by an individual MPMLA would be governed by a twofold test. A. Privilege claimed has to be connected to collective functioning of the House, and B. Its necessity must bear a functional relationship to the discharge of essential duties of a legislator. Jurisdiction of criminal court. Criminal courts are not excluded from hearing bribery cases against legislators merely because it may also be treated by the House as contempt or a breach of its privilege. Scope of parliamentary privileges. Purpose of parliamentary privilege to provide legislators platform to speak and vote without fear is equally applicable to A. Elections to the Rajya Sabha and B. Elections for the President and Vice President. Parliamentary privileges in their evolution. Parliamentary privileges are a legal immunity enjoyed by members of legislatures, in which legislators are granted protection against civil or criminal liability for certain actions done or statements made in the course of their legislative duties. Origin at British Parliament. Introduced to protect legislators in the House of Commons from arrest and harassment when they criticize the monarchy. Adoption in Indian context. India's founding fathers provided absolute freedom of speech to parliamentarians within the House, even as citizens' freedom remained restricted. This decision was upheld by the Supreme Court. Power to codify. The Founding Fathers vested the power to codify privileges with Parliament. However, so far, Parliament resists. The parliamentary privileges are based on 5 sources, namely: 1. Constitutional provisions. 2. Various laws made by Parliament. 3. Rules of both the Houses. 4. Parliamentary conventions. 5. Judicial interpretations. Codification fearing a loss of parliamentary sovereignty. This was highlighted in the P.V. Narasimha Rao case. Importance of parliamentary privileges. Ensuring functionality, privileges such as freedom from arrest and freedom of speech primarily exist to ensure the House can perform its functions without hindrance. Ensure attendance of MP in parliamentary session. Protection of members. The power to punish for contempt and to regulate its own business exists for the protection of members, for maintenance of the House's authority and dignity. Preventing external interference. Privileges are granted to enable legislators to carry out their duties without fear or favor and to prevent external interference. Provisions that grant legislators immunity from prosecution. Article 105 deals with the powers and privileges of both houses of Parliament and its members and committees. Article 194 for state legislature. Right to prohibit publication of proceedings. Article 105(2) stipulates that no person shall be liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes, or proceedings. Article 194(2) for state legislature. Freedom from arrest. Code of Civil Procedure. 1908 provides that members can enjoy freedom from arrest in any civil case 40 days before and after the adjournment of the House and also when the House is in session. However, this privilege is limited to civil cases. An MP doesn't enjoy any immunity against action in a criminal case, during the session or otherwise. Freedom of speech in Parliament. Article 105(2) states that no member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules and procedures of the Parliament, as stated under Article 118 of the Constitution. However, Article 121 restricts members from discussing the conduct of judges of the Supreme Court and High Court. Privileges based on rules of procedure and precedents. Parliament reserves the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member on a criminal charge or for a criminal offense. Right to exclude strangers. Members of the House have the power and right to exclude strangers who are not members of the House from the proceedings. This right is essential for securing free and fair discussion in the House. Also, as per the provisions of Article 122, the validity of any proceeding of Parliament can't be inquired into by a court on the grounds of alleged irregularity of procedure. Role of opposition. The essence of a vibrant democracy lies in the constant churning of diverse viewpoints, with the opposition playing a pivotal role. A strong opposition stands as a necessary counterbalance to the ruling party, ensuring the plurality of voices and upholding democratic principles. Role of opposition in Indian democracy. Act as the voice of the voiceless, upholding the views of the people. The opposition acts as the voice for the unheard, as seen during the extension of PM Garib Kalyan and Yojana during the national lockdown. Ensuring accountability. The opposition holds the government accountable for its actions and adherence to its manifesto, like the combined effort of opposition parties in 2012 against corruption leading to the framing of Lokpal. Issues with the opposition in India. Electoral strength. Opposition parties, especially the Indian National Congress, Inc., often lack the numerical strength to challenge the ruling party effectively. United efforts. The opposition tends to be divided between party and regional interests, with many remaining silent on issues outside their forte. Defection. Prioritizing self-interest over national interest leads to political defections, weakening the role of opposition, as witnessed in the 2019 national elections. Needed reforms. Legal reform. In situations where no party in opposition secures 55 or more seats, the numerically largest party in the opposition should be recognized as the leader of the opposition by the Speaker. Reforms in status. The 10% formulation is inconsistent with the Salary and Allowances of Leaders of Opposition in Parliament Act, 1977, which suggests that the largest opposition party should get the post. National interest. The opposition should unite across party lines on issues of national or constitutional importance. Strengthening anti-defection law. Revisiting the anti-defection laws can help curb political defections and strengthen the role of opposition. Key terms: Parliamentary Disruption Index, expulsion, substantial illegality, defamation, leaders of opposition. Low participation of women in politics. Status of women participation and relevant data. India's ranking is a concerning 141 SD among 185 countries according to the Inter-Parliamentary Union, IPU, with women making up only 15.2% of the lower house of Parliament. State legislatures present an equally bleak picture, with an average of only 8% women representation. Bihar and Rajasthan slightly outperform other states with the approximately 11% to 12% representation. Challenges hindering women's participation in Parliament. Patriarchal influence. The pervasive influence of male members in decision-making overshadows the power held by women, significantly visible in the Panchayati Raj system through the phenomenon of Sarpanch Paddy. Work-life balance. Domestic responsibilities and societal expectations of women often interrupt their political aspirations. Financial constraints, economic dependency, and limited access to resources act as substantial impediments to women's political involvement. Identity masking. Women candidates often win elections based on their political party affiliation or family background, obscuring their individual identities. Attitudinal barriers. Prevalent sexist beliefs undermine women's capabilities, illustrated by instances where women legislators have been disparaged for fulfilling their duties. Significance of women in decision-making bodies, gender-sensitive approach. Female legislators often focus more on women-centric issues, evident from the work of female presidents in India addressing matters like sanitation, self-help groups, etc. Efficiency in governance. Countries led by women, such as Germany and New Zealand, have demonstrated commendable efficiency, including effective pandemic management. Diversity of perspectives. As women often experience different forms of discrimination and social challenges, their presence can contribute to better sensitivity towards gender-related matters and a broader understanding of social issues. Enhanced responsiveness. Female leaders have proven to be more responsive to the needs of disadvantaged groups, including prompt action on crimes against women. International commitments and best practices. Achieving greater representation of women aligns with international commitments, such as the United Nations Sustainable Development Goal 5. Which aims to achieve gender equality and empower all women and girls. Suggested measures for improvement. Implement zipper system, a practice followed by Rwanda where every third seat in a party is reserved for women. Challenge stereotypes. Encouraging women to step out of their traditional roles and take up leadership positions. Promote inter-party democracy, encouraging internal elections for various positions within political parties. Elevate women in local bodies, providing opportunities for women in local governance to serve at higher levels in state assemblies and parliament. The reservation of seats for women in the institutions of local self-government has had a positive impact in several ways. Increased representation. The policy has significantly increased the number of women in local governance. Fostering gender diversity in decision-making. Empowerment. Women who have participated in local self-government institutions have gained confidence and developed leadership skills. Decision-making. The presence of women in local governance has led to a greater focus on women-centric issues, such as health, education, and sanitation. UN Women 2012. Report. This report highlights the success stories of women leaders in Panchayati Raj institutions across India. It showcases how the reservation policy has empowered women to take up leadership roles and positively impact their communities by focusing on issues such as education, health, and women's safety. However, the reservation policy has faced limitations in addressing the patriarchal character of the Indian political process. Proxy candidates. In some cases, women who are elected serve as proxy candidates for their male relatives, undermining the true intent of reservation policies. Lack of resources and training. Many elected women representatives lack the necessary resources, training, and support to effectively participate in the political process, limiting their impact on governance. Entrenched gender stereotypes. Patriarchal norms and gender stereotypes continue to influence societal attitudes towards women in politics, often undermining their authority and effectiveness as leaders. It is worth noting that the 17th Lok Sabha had the highest proportion of women lawmakers as compared to previous. Also, few months before the general elections of 2024, the president gave his assent to 106th Constitutional Amendment Act, paving way for reservation of seats for women in central and state legislature. Sooner implementation of the law is need to leverage the unique perspectives and leadership women bring to the table. Keywords: state funding of elections, interparliamentary union, IPU, Sarpanch Paddy, gender-sensitive approach, UN women, proxy candidates. Anti-defection law. The 52nd Amendment 1985 to the Constitution added the 10th schedule which laid down the process by which legislators may be disqualified on grounds of defection. The main intent of the law was to combat the evil of political defections. The 10th schedule contains the following provisions. Members of political parties, if he voluntarily gives up his membership of such political party, abstains from voting in such house contrary to any direction issued by his political party without obtaining prior permission of such party. Independent members if she joins any political party after such election. Nominated members if he joins any political party after the expiry of 6 months from the date on which he takes his seat in the House. Importance of anti-defection law. It was introduced to maintain rule of law, reduce political corruption, and bribery. Increases faith. Anti-defection ensures that candidates elected with party support and on the basis of party manifestos remain loyal to the party policies. Reduced horse trading. Anti-defection law was brought to curb the power of money after election within the House. The horse trading and unstable government caused by money power and bribery was said to be rampant in the cross-voting reduce money power. It has succeeded in reducing the money power within House voting for passing legislation and the survival of the government. Ensure stability. Anti-defection provides stability to the government by preventing shifts of party allegiance. Party discipline. Anti-defection promotes party discipline. Issues with anti-defection law. Affects the independence of the MPs. It violates their freedom of speech and they can't take any independent stand over issue. Injustice to the constituencies. Those have elected them in the elections. Being the people's representatives, they should be allowed to boldly air their grievances and speak up for their constituencies' requirements. Accountability versus efficiency. Dr. B.R. Ambedkar, while drafting, favored stability and accountability over efficiency, thus adopting parliamentary form of government. The weakening of anti-defection law neither provides efficiency nor stability. Limited deliberations, they have indeed reduced the quality of parliamentary debate deliberations. It could in the long run generate faulty legislation with various loopholes. It could also pave way for delegated legislation rendering Parliament ineffective in the long run. Misuse of law by the Speaker, false dissent by the Speaker on MPAs as seen in the cases of Arunachal Pradesh and Uttarakhand. Role of MPs and MLAs are undermined. The legislators are tasked with twin of acting as agent of people and participate in important legislations. But when they vote only on party lines, it hinders the primary goals. No barrier for wholesale defection. The law prohibits retail defection but not so effective in the case of wholesale defection of legislatures. Issues with merger provisions. The flaw seems to be that the exception is based on the number of members, if at least two-thirds of the members of the legislature party concerned have agreed, rather than the reason behind the defection. Way forward. The Supreme Court has suggested that Parliament should set up an independent tribunal headed by a retired judge of the higher judiciary to decide defection cases swiftly and impartially. Timeline to be fixed for speakers to take the decision. Decisions under the 10th schedule should be made by the President-Governor on the binding advice of the Election Commission. Changes like barring the defectors or legislators who resign from their seat from contesting election for a sufficient time. The role of money can also be curbed by revisiting the provisions of electoral bond. Dinesh Goswami Committee reports on defection. Disqualification should be limited to cases where a member voluntarily gives up the membership of his political party. The issue of disqualification should be decided by the President-Governor on the advice of the Election Commissioner. International practice. Article 70 of the Bangladesh Constitution says a member shall vacate his seat if he resigns from or votes against the directions given by his party. The dispute is referred by the Speaker to the Election Commission. Article 46 of the Singapore Constitution says a member must vacate his seat if he resigns or is expelled from his party. Article 48 states that Parliament decides on any question relating to the disqualification of a members. Keywords: 10th schedule, nominated members, independent members, horse trading, electoral democracy, Dinesh Goswami Committee, Election Commission. Role of the presiding officer. The Speaker of Lok Sabha or State Legislative Assembly is elected from amongst its members and is mentioned in Article 94 and Article 179 of the Constitution. He is the guardian of powers and privileges of the members, the House as a whole, and its committees. The institutions of Speaker originated in India in 1921 under the provisions of the Government of India Act of 1919, Montagu-Chelmsford reforms, and at that time, the Speaker was called the President. The Government of India Act of 1935 changed the nomenclatures of the President of the Central Legislative Assembly to the Speaker. Functions performed by presiding officer. Maintains order and decorum in the House for conducting its business and regulating its proceedings. Maintaining impartiality of the office, he ensures that ample time is given to Parliament as a whole and opposition in particular to ensure accountability. Presides over the joint sitting. He presides over joint sitting of Parliament convened to resolve deadlocks between two houses. He can also convene a secret sitting of a House where none can be present in House galleries without Speaker's permission. Adjourns the House and suspends the meeting in absence of a quorum. Decides whether a bill is a money bill or not, and his decision on this is final. Decides on the question of disqualification of a member arising on the ground of defection, although not outside the purview of judicial review, Kahoto Halahan Case 1992. Appoints the chairman of all parliamentary committees of Lok Sabha and supervises their functioning. He is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purpose Committee. The presiding officer guards the rights and privileges of the members of the two houses. Fix the agenda of the House. The Speaker, in consultation with other members of the Business Committee of the House and the Prime Minister, fixes the agenda of the meetings of the House. This ensures timely debates and discussion on important issues of the country. Interpretation of rules of procedure. The business of the House is conducted according to definite and settled rules of procedure. In case of any dispute regarding the rules of the House, the Speaker interprets and applies these rules. The interpretation of rules made by the Speaker is final and cannot be challenged. Concerns relating to presiding officer. Non-adherence to standard operating procedure. SOP. The Speaker of Uttarakhand Assembly decided on a case of defection while a notice of resolution for his removal from the office is pending. The Supreme Court had to intervene and observe that the Speaker should refrain in such cases. Inappropriate use of money bill provisions. The Supreme Court has accepted a plea with respect to the Speaker's approval of the Aadhaar Bill, 2016 as a money bill. It is argued that declaring a bill that includes larger concerns like privacy, data protection, etc., should also involve Rajya Sabha to have a meaningful debate. Failure to maintain decorum. The parliamentary logjam has been a consistent scene on the floor of Parliament whereby speakers have been unable to facilitate smooth functioning and accused of bias. Review of the Speaker's decisions. Under the rules, the Speaker is not answerable to any person in performing the roles assigned to him. Decisions of presiding officers are final and are not open to appeal or subject to review. Impartiality. In a parliamentary democracy, office of Speaker should be fair and impartial, but they are usually elected to the House on a political party's ticket. In Britain, the Speaker is strictly a non-party man. Our constitutional maker envisaged integrity and impartiality from the office, but it has been progressively eclipsed by political interests and made subservient to the needs of the ruling party. Kisham Megachandra Singh v. Union of India. Legal status. Decision on anti-defection operates independently and not subject to the approval of LS or SLA powers of Speaker. The decision of the Speaker on anti-defection can be judicially reviewed, and the immunity is only on procedures followed. Provisions. Judicial review is allowed on grounds of infirmities based on violations of constitutional mandates, mala fides, non-compliance with rules of natural justice, and perversity rules. Speaker-Chairman acts as quasi-judicial authority while deciding cases of anti-defection under XTH Schedule of the Constitution. Time period. The decision to be taken within reasonable time period, within 3 months as per Cahodo-Holohan judgment. Implementation of the verdict. Such persons who have incurred disqualification do not deserve to be MPs MLAs even for a single day, as observed in Rajendra Singh Rana case. Cahodo-Holohan versus Sakilhu and others, the majority judgment, 3:2, held that the Speaker's chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. The court ruled that Speaker-Chairman, while deciding cases of anti-defection, acts as a tribunal, and accordingly the decision of Speaker-Chairman is subject to judicial review. Recommendations of various committees on role of presiding officer and anti-defection law. Dinesh Goswami Committee on Electoral Reforms, 1990. The issue of disqualification should be decided by the President-Governor on the advice of the Election Commission Law Commission, 170th Report. 1999. Political parties should limit the issuance of whips to instances only when the government is in danger. Election Commission Constitution Review Commission, 2002. Decisions under the 10th schedule should be made by the President-Governor on the binding advice of the Election Commission. NCRWC. The power of disqualification of the legislators on ground of defection should lie with Election Commission and not Speaker. Way forward. Judicial review is also used in exceptional circumstances. We need a permanent institutional solution. Best practices. UK's model of appointing a committee of 2 senior legislators to assist the Speaker over the question of a money bill is a case to consider. In the UK, a parliamentary convention has developed, where an MP elected as Speaker resigns from the respective party. This lends credence to his impartiality. Cooperation among government and opposition. Both government and the opposition need to cooperate so that Parliament can function smoothly and the Speaker is not put into difficult situations too often. Democratic ethos. Also, Speaker needs to keep in mind the democratic ethos while presiding over the esteemed office, and his actions must appear to be objective and neutral, as justice should not only be done, it must also be seen to be done. Question of disqualification. Power to decide upon the question of disqualification can be taken away from the Speaker and entrusted to some independent constitutional authority like the Election Commission of India. Need amendment. There is a need for amendment in the law to sync it with representative democracy and not become a system of blindly following the instruction of party leadership, thus allowing legislators the right to dissent and promote independent thinking as allowed in other democracies of the world such as the US, UK, Australia, etc. Case studies of Andhra Pradesh and Telangana. In recent years, opposition MLAs in some states, such as Andhra Pradesh and Telangana, have broken away in small groups gradually to join the ruling party. In some of these cases, more than 1/23 of the opposition has defected to the ruling party. In these scenarios, the MLAs were subject to disqualification while defecting to the ruling party in smaller groups. However, it is not clear if they will still face disqualification if the presiding officer makes a decision after more than 1/23 of the opposition has defected to the ruling party. Parliamentary scrutiny. Parliamentary scrutiny is the close examination and investigation of government policies, actions, and spending that is carried out by the lower and upper houses of Parliament and their committees. Various methods of parliamentary scrutiny of the government. Discussion debate. During discussions, debates on bills, matters of public or national interest on in Parliament, legislatures could point out question hour. During the question hour, the members can ask questions on every aspect of administration and governmental activity. Parliamentary committees. Parliament has put in place large machinery of committees to scrutinize the bills which are brought before it by the government. Finance committees. The Committee on Estimates reviews budgetary estimates of regulators. The annual audit reports on the accounts of the regulators are tabled before Parliament and reviewed by the Public Accounts Committee, PAC. The PAC may require the regulator's officers to depose before the committee. Ad hoc committees. Parliament may establish ad hoc committees which may examine the working of regulators. Reasons for ineffective parliamentary scrutiny. Not referring bills to the Parliament committees. While 60% of the bills in the 14th Lok Sabha and 71% in the 15th Lok Sabha were vetted by the parliamentary committees, this proportion came down to 26% in the 16th Lok Sabha. Decline in the number of sittings. The 17th Lok Sabha sat for a total of 1,354 hours, which is significantly less than the average for all full-term Lok Sabha. Disruptions during question hour. In the 16th Lok Sabha, question hour has functioned in Lok Sabha for 77% of the scheduled time, while in Rajya Sabha it has functioned for 47%. No effective leader of the opposition. Importance of question hour. The first hour of every parliamentary sitting is reserved for this. During the time, the members ask questions and the ministers usually give answers. The questions are of three kinds, namely, starred, unstarred, and short notice. Ensures accountability and transparency. Question hour make Parliament transparent and accountable since it covers every aspect of government activity, domestic and foreign. Makes government accountable. The government of the day gets to know the pulse of the nation and gives the public a view of the performance. Addressing of questions. The reliability of the answers given are matters of utmost importance and rules allow correction of mistakes by the minister concerned. Extract wider debates. Questions asked during question hour are in general to the point and very precise to the issue. Answers provided at times have extracted wider debates and inquiries on the government's performance, helps government to define their stand. Question hour also helps the government to tell their position on any issue both to the member concerned and also to the public in general. Way forward. The question hour and 0 hour must be returned immediately when the pandemic situation improves. Second Arcade also recommends that annual reports submitted by the regulators to Parliament should include the progress on pre-agreed evaluation parameters and should be discussed in the Parliamentary Committee, periodically examined. According to the National Commission to Review the Working of the Constitution, NCRWC, DRSCs should be periodically examined so that the committees which have outlasted their utility can be replaced with fresh ones. The opposition should be proactive in asking the question to the government, new parliamentary committees. As there is increasing complexity in matters of economy and technological progress, there is a need for setting up new parliamentary committees. Major reports of all committees should be discussed in Parliament, especially in cases where there is a disagreement between a committee and the government. Expert support should be provided to MPs as effective scrutiny depends on their skill and resources. Keywords. Section 124A, free speech, flirting with fascism, vibrant democracy, ad hoc committees, 0 hour, National Commission to Review the Working of the Constitution. Previous year questions. 1. Discuss the essential conditions for exercise of the legislative powers by the governor. Discuss the legality of promulgation of ordinances by the governor without placing them before the legislature. 2022. 2. Discuss the desirability of greater representation to women in the higher judiciary to ensure diversity, equity, and inclusiveness. 2021. 3. Rajya Sabha has been transformed from a useless stepney tire to the most useful supporting organ in the past few decades. Highlight the factors as well as the areas in which this transformation could be visible. 2020. 4. The reservation of seats for women in the institutions of local self-government has had a limited impact on the patriarchal character of the Indian political process. Comment. 2019. 5. Individual parliamentarians' role as the national lawmaker is on a decline, which in turn has adversely impacted the quality of debates and their outcome. Discuss. 2019. 6. What are the major changes brought in the Arbitration and Conciliation Act, 1996 through the recent ordinance promulgated by the President? How far will it improve India's dispute resolution mechanism? Discuss. 2015. 7. The powers, privileges, and immunities of Parliament and its members as envisaged in Article 105 of the Constitution leave room for a large number of uncodified and unenumerated privileges to continue. Assess the reasons for the absence of the legal codification of parliamentary privileges. How can this problem be addressed? 2014. 8. Discuss the essential conditions for exercise of the legislative powers by the governor. Discuss the legality of promulgation of ordinances by the governor without placing them before the legislature. 2022 UPSC Offline Foundation Course, based on CTR model. GS classes optional classes. BC SAT classes * 24/7 library. Any other relevant features. W with 3 years validity. PW0AS 500. For extra discount. Starts from? For 7,200. Carol by. Apply coupon code. Our offline centers. Ethics and Essay Crash Course 2024, 60+ hours. Ethics discussion and questionnaires or Form AT. 2 ethics and 2 essay full-length test with evaluation. B. Theme-wise, essay coverage, H evaluation by faculty. Coverage of 150+ ethics and 50+ essay questions. Any doubt sessions W with faculty. Batch starts 24th June for extra discount. Offline fee 315, 000, PW0AS 500 apply coupon code. 992-061-3613 OnlyIAS. Com12 Judicial System in India. The judiciary, which is an important organ of the government, performs the role of independent dispute resolution. Indian judiciary, one of the very powerful judiciaries in the world, has been the nation's moral conscience, speaking truth to political power, upholding the rights of citizens, mediating center-state conflicts, providing justice to the rich and poor alike, and on several momentous occasions, saving democracy itself. Comparison of Indian and other judicial systems. India USA Judiciary of India America. Judicial system. Integrated system. Hierarchy of courts I. Supreme courts, high courts, and subordinate courts. Double system of courts. Federal judiciary for federal laws and state judiciary for state laws. Jury system does not exist. Allowed. Appointment of judges. Collegium system. The judiciary has a greater role in the appointment. Justices are nominated by the President and confirmed by the Senate, i.e. greater role to elected representatives. Retirement age for judges. Supreme Court, 65 years. High Court and other subordinate courts, 62 years. Judges serve for a lifetime. Original jurisdiction of the Supreme Court. Confined to federal cases plus cases relating to naval forces, maritime activities, ambassadors, etc. Appellate jurisdiction of the Supreme Court. Constitutional, civil, and criminal cases. Only constitutional cases. Deciding of cases. Indian judges sit on several benches of 3 to 5 judges, and if necessary then more number of judges. All American judges sit together for decision-making. Advisory jurisdiction of Supreme Court. Yes, no. Change in jurisdiction can be enlarged by Parliament. Powers are limited to that conferred by the Constitution. Control over subordinate courts. Integrated judicial system. Power of judicial superintendents over HCs. Double or separated judicial system - no such power. India-UK divergence. India-UK jury system not present. Present judicial review originally procedure established by law. Post-Maneka Gandhi case. Due process of law. Thus, its scope of judicial review has been widened. Due process of law - Parliament is supreme and the court does not check the fairness of the law. Judicial appointment. Collegium system. Greater role of the judiciary which results in less transparency. Judicial Appointment Commission - primacy to Parliament - greater transparency. Convergence. Independence of judiciary, ensured through the doctrine of separation of power in both countries. OEG. The UK removed the judicial function from the office of Lord Chancellor similar to the Keshavan and Burdi case of 1973. Alternate dispute resolution. Both countries are exploring ADIR mechanisms to improve justice delivery. OEG. The UK established the Ministry of Justice in 2007. Similarly, India has started a national mission for justice delivery and legal reform. Accountability. India is exploring ways to ensure transparency in judicial appointments through steps like NJC. Keywords: mediating center-state conflicts, independence of judiciary, original jurisdiction, special leave, integrated judicial system, collegium system, due process of law. 75 years of the Supreme Court of India. Recently, the Prime Minister inaugurated the Diamond Jubilee celebration of the Supreme Court of India on January 28, 2024 at the Supreme Court Auditorium in Delhi. About Supreme Court, according to Article 124(1) of the Indian Constitution, the Supreme Court of India must have a Chief Justice of India, CJI, and a maximum of 7 additional justices unless Parliament specifies a higher number through a statute. Currently, the Supreme Court comprises the Chief Justice and 33 other judges. Constitutional provisions, outlined in Articles 124 to 147 of the Indian Constitution. Key features of the Supreme Court of India, highest court of appeal. The Supreme Court is the highest appeal court, is also known as the apex court of India and even the last resort, where the citizens of India can seek justice if they are not satisfied with the judgment of the High Court. Evolution of Supreme Court of India 1774, Regulating Act of 1774 1/61 India High Courts Act 1/61. 1436 Government of India Act, 1435. 1450 SC came into existence. Why? Advisory jurisdiction. As per Article 143 of the Constitution, the S can advise the President of India that is related to the question of law, and the nature of the matter is associated with public importance. Adjudicate federal disputes. The court resolves disputes between the Union and the states and between different states, Article 131. Judicial review. The Supreme Court reviews laws and actions of the executive to ensure they comply with the Constitution. Protection of fundamental rights. The court protects the fundamental rights of citizens by issuing writs and orders, Article 32. Challenges faced by Supreme Court, massive case backlog. As of 2023, there were over 80,439 cases pending in the Supreme Court alone. Judicial activism versus judicial restraint. This debate revolves around the appropriate role of the judiciary in policy making and governance. Uncle Judge Syndrome. The Law Commission of India's 230th report highlighted a concern about potential favoritism in the appointment of judges to the High Court and Supreme Court, impacting the impartiality and fairness of the judicial system. Judicial-executive conflict. The judiciary and executive have faced rising conflicts, marked by delays in judicial appointments, the tribunalization of justice, and public criticism of the executive during COVID-19. Way forward, case management and technology. Implementing case management systems and leveraging technology for filing, video conferencing, and virtual hearings can help reduce case backlog and improve efficiency. Enhancing transparency and accountability. Transparency in the appointment of judges and making judgments more accessible to the public can help improve public trust in the judiciary, strengthening judicial independence. Ensuring that the judiciary is free from undue influence and interference from the executive or other branches of government can help maintain the integrity of the judicial system. Various significant roles that judiciary plays. Judiciary as protector of fundamental rights. Judiciary is entrusted with the task of protecting the rights of individuals. The Constitution provides two ways in which the Supreme Court can remedy the violation of rights. First, it can restore fundamental rights by issuing writs of habeas corpus, mandamus, etc., Art. 32. The High Courts also have the power to issue such writs, Article 226. Secondly, the Supreme Court can declare the concerned law as unconstitutional, Article 13. Function as interpreter of the Constitution. Judiciary as protector Constitution and savior from the arbitrariness of governmentate. Judicial review of constitutional amendments, legislation of the Parliament and state legislatures. Subordinate legislation, and administrative action of the Union and state authorities. Article 142 allows the Supreme Court in the exercise of its jurisdiction to pass such decree or make such order as is necessary for doing complete justice. E.g. Bhopal gas tragedy case, the court had awarded compensation of $470 million to the victims to do complete justice. Interpretation of Constitution. Under its original jurisdiction, the Supreme Court keeps the government within their limits by judicial interpretations. Therefore, the Founding Fathers incorporated in the Constitution itself the provisions of judicial review. This enables the judiciary to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms of citizens. Important judicial concepts. Procedure established by law. Due process of law. Borrowed from British USA. Test to check the validity of a law. Whether there exists a law that authorizes the executive action. Whether the legislature had the competence to pass that law. Whether the legislature followed the established procedure to enact that law. Along with procedure established by law, also examines the inherent goodness of the law using principles of natural justice. Relies upon good sense of legislature and the strength of the public opinion. Also, upon judicial conscience. Judicial power. Limited. Can declare laws violative of rights of citizens only on procedural grounds. Can declare laws violative of rights of citizens on both substantive and procedural grounds. Protection against the arbitrary action of the only executive and not legislature. The arbitrary action of both the executive and the legislature. Principle of natural justice and authority shall act bona fide, in good faith, without any bias. No man should be punished without being heard. No man shall be the judge of his own case. Maneka Gandhi vs. G.I. 1978, Article 21 incorporate principles of natural justice. Central Inland Water Transport Corporation Ltd. vs. Broho Nath Ganguly, 1986, P&J are implicit to the right of equality under Article 14. Keywords: highest court of appeal, judicial activism, judicial restraint, uncle judge syndrome, protector of fundamental rights, habeas corpus, mandamus, judicial review, interpretation of Constitution, doctrine of separation of powers. Judicial conscience, judicial pendency average disposal Tim E. compared to Europe 4.4 times in civil cases and 6 times in criminal cases. Law com emission, it will take 464 years to clear pendency with present judge's strength. Courts pendency OF cases as OF decem BER 2022. Supreme Court 69,598. High Courts 59, 78, 714. Lower Courts 4.4 crore. Reasons. Personnel, 327 out of 1,114 sanctioned judges posts in the 25 high courts are vacant on April 1, 2024. 10.5 judges million population, Law Commission recommend 50 million. ADM administrative, more than 50% of cases violate the rule of 3 adjournments per case. Supreme Court works on average 222 days despite the rule mandating a minimum of 225 days. Summer vacation for judges reflects colonial hangover. Special leave petition A Article 36 comprises 40% of the court's pendency. Lawyers collusive corruption, especially at subordinate levels, in order to drag the case. Infrastructure, existing infrastructure could accommodate only 15,540 out of sanctioned 20,558. Judicial officers. 0.09% of GDP spent on court infrastructure. Old technologies used in administration increases time of litigation. Other, delayed investigations, lack of modern and scientific tools has resulted in a handicapped police investigation. Center and the states were responsible for over 46% of the pending cases. Steps to reduce pendency, 120th Law Com emission. Appoint efficient and experienced judges as ad hoc judges. Article 128 and Article 224A, Law Commission and Supreme Court in Vasanta case. Separate Supreme Court's function into the Court of Appeal and Constitutional Court. Judges' allocations considering the need and factors like criminal cases have a 2.5 times higher backlog. Life cycle analysis to identify specific stage for causing delay, i.e. procedural inefficiency, human resource shortage. E.g. zero pendency case of Delhi HCO state-wise case clearance rate. Gujarat has 100% CCR and Bihar has 55.8% CCR, increasing court productivity. Increase the number of working days. Strict codes of conduct for judicial officers to ensure the adequate performance of duties. Business process re-engineering. Deployment of modern technology, NJDG under eCourt. Big data analytics of cases. Online filing of cases. Three-pronged approach is recommended by Justice Ramana. Improving judicial infrastructure through the use of e-platforms and setting up of more courts. Dispute settlement at the pre-litigation stage through counseling. Strengthening the existing alternative dispute resolution ADR mechanism. Grouping of cases. Cases of specific types having high pendency shall be identified and a special committee shall be appointed for the same. E.g. recently court recommended panel to clear check bounce cases, which constitutes almost 30% to 40% of cases in trial courts. Legal Information Management and Briefing System, LIMS, is a web-based application created by the Department of Legal Affairs under the Ministry of Law and Justice to make the legal data available at one single point and streamline the procedure of litigation matters conducted on behalf of Union of India. Alternative dispute resolution mechanisms like arbitration, conciliation, lock adalats, etc. should be promoted by judges. Further, legal services authorities, such as NALSA, SALSA, DALSA, and TALSA, can generate awareness. Role of media. The media, as the fourth pillar of democracy, should do periodic and constructive reporting on the pendency of cases. This will have a dual benefit, placing better accountability on judges, bringing the pendency to the public domain. The culture of rule of law must prevail, as the government cannot be improved in silos. Well-functioned, accessible, affordable, and speedy justice delivery act as an economic and social multiplier. The right to fair and speedy trial must be upheld in all circumstances, as it is an important component of dignified life under Article 21 of the Indian Constitution. Keywords: business process re-engineering, LIMS, lock adalats. Judicial appointments. Recently, President appointed 5 new judges to SC, working strength of SC rise to 32 against sanctioned strength of 34, by accepting the recommendations made by Supreme Court Collegium. Constitutional provision related to appointment. Article 124, to appointment of S judges OCJA, by President after consulting such judges of the SC and HC as the President deems necessary. Other judges, by President after consulting CJI and other SC and HC judges as he considers necessary. Article 217, appointment of HC judges. Chief Justice of HC, by President after consultation with CJI and Governor of the state concerned. Other judges, by President after consultation with CJI and Governor of the concerned state and Chief Justice of concerned HC. Collegium system. A committee of the Chief Justice of India, for senior judges of the Supreme Court, take decisions related to appointments and transfer of judges in the SC and HC. 3-judge cases. Lacuna in Collegium system. Autocratic. It isn't a constitutional body. The constitution of Collegium can be perceived as an act of the judiciary too. First judge's case. S.P. Gupta case, 1981. Consultation with CJI doesn't mean concurrence, and it only implies exchange of views. Greater say to the executive. Second judge's case, 1993. Consultation with CJI means concurrence, i.e. advice tendered by CJI is binding on the President. However, CJI needs to consult 2 senior-most judges. Third judge's case, 1998. CJI should consult with 4 senior-most SC judges to form his opinion. Control the appointments and transfer in the judiciary. Opaqueness, lack of transparency and functioning undemocratic. Law Commission, 230th report. Nepotism, corruption, and personal patronage are prevalent in the functioning of the Collegium system. Uncle Judges Syndrome. Violation of Article 74. President to act on the aid and advice of the Council of Ministers. Merit versus seniority. Due to the seniority rule, people with better qualifications and better track records have been sidelined to make way for someone incompetent. Appointments failure. The Collegiums has failed to appoint judges as per the vacancies. No system of checks and balances. Second judge's case made CJI recommendation binding on President. Virtually no say of the executive. Way forward. Early finalization of Memorandum of Procedure, MOP. Permanent independent body. Adequate safeguards to preserve the judiciary's independence, judicial primacy, but not judicial exclusivity. Collaborative process. Filling up vacancies is a continuous process involving the executive and the judiciary, so difficult to have a time frame. The process of filling up vacancies should ensure independence, diversity, professional competence, and integrity. Objective eligibility criteria. to understand reasons for an appointment or non-appointment. Recently SC Collegium has decided to put all its recommendations in public domain, indicating the reasons is a positive step. Collegium must provide a panel of possible names to the president to appoint in order of preference and other valid criteria. Law Commission. Parliament to pass a law restoring the primacy of the CJI, while ensuring that the executive played a role in making judicial appointments ensures power balance. Removal of judges. Constitutional provision for removal. Article 124, for judge of SC can be removed only by the president. Ground. Proved misbehavior or incapacity only after a motion to this effect is passed by both the Houses of Parliament by a special majority. Concern in removal procedure. Vagueness, lack of clarity as terms like misbehavior is undefined and open to interpretation. Lengthy process, cumbersome and tedious impeachment process virtually no accountability of judges. Against separation of power. 3 members committee to investigate is headed by CJI or the S judge. This leads to judges removing the judge's situation. Lack of transparency, secrecy in the procedure of committee. The judge continues to hold the post. Both the Constitution and the Judges' Inquiry Act of 1968 are silent on whether a judge facing an impeachment motion should recuse from judicial work or not. The judge during an investigation is not prohibited from discharging duties in court. Politicization, e.g. Congress abstained from voting on the motion for removal of Justice V. Ramaswamy resulted in failure of the process. Way forward, transparency in appointment, is listed in MOP. Integrity shall be the primary criteria. Only judges of high caliber and impeccable integrity are appointed to the higher courts. The Judges' Inquiry Bill 2006 proposed the National Judicial Council (NJC) to conduct inquiries into allegations of incapacity or misbehavior by High Court and Supreme Court judges by people. Greater internal regulation, prompt disciplinary actions on misconduct. National Judicial Oversight Committee should be created by Parliament to scrutinize the complaints and investigation. Keywords: 3-judge cases, Memorandum of Procedure, National Judicial Appointments Commission, Judges' Inquiry, Act of 1968. Judicial accountability. Judicial accountability describes the view that judges should be held accountable in some way for their work. This could be public accountability, i.e. getting approval from voters in elections, or accountability to another political body like a governor or legislature. Need of judicial accountability to uphold public trust. Recent remarks like asking a rape victim to marry a rapist, prioritizing cases of some people for hearing, and delaying others erodes trust in the judiciary. Judicial appointment. The collegium system results in judges appointing judges with virtually no role of executive and legislature. Conflict of interest. CJI decides master of roles despite himself being a party in a case. E.g. recent press conference by 4 senior-most judges against CJI. Conduct of judges. Recent allegations of corruption on Justice Ramaswamy, allegation of sexual harassment on Justice Ranjan Gogoi raises a question on the character of CJI. Opacity in operation. Under the blanket of judicial independence, judiciary restricts outside bodies' involvement in the investigation of corruption cases and sets up in-house mechanisms. Information asymmetry. Supreme Court rules do not provide a time frame, appeal mechanism, penalty for the delay to give information. Contempt of court, being utilized for rightful critics also. E.g. recent contempt proceedings against Kunal Kamra and Prashant Bhushan. Judicial overreach. Activism towards citizen grievances has encroached on a line of overreach. D.G. National Anthem case, highway liquor ban. Judicial independence. Without accountability, judicial independence can be used for the personal benefit of judges and not for the protection of the rule of law and the rights of citizens. Steps taken to ensure judicial accountability. Adoption of a charter, restatement of values of judicial life by Supreme Court in 1997 and Bangalore Principles of Judicial Conduct in 2002. Judicial Standards and Accountability Bill, 2010, establishes the National Judicial Oversight Committee, which may issue advisories or warnings to judges and also recommend their removal to the President. The Supreme Court, SC, approves live streaming of court proceedings. Draft Memorandum of Procedure, 2016, include merit and integrity as prime criteria for the appointment of judges. Permanent Secretariat in Supreme Court for maintaining records of High Court judges, SCVS Subhash Chandra Agrawal case, CJI is declared as a public authority under the RTI Act. Steps required. The media shall study the judgment. Comment on it academically so that judges know that they are being watched. That is the way to ensure accountability. Arun Shourie, Independent Judicial Locale for complaint against judges. Comprehensive Code of Conduct for Judges, 2-level judicial discipline model. First level, fine suspend. Second level, removal. Awareness and sensitivity of the appointees to the country's diversity criteria in the appointment. Judicial activism and judicial overreach. Judicial activism, judicial overreach. It is proactive and assertive role played by the judiciary to force the executive and legislature to discharge their constitutional duties to uphold the rights of citizens. Extreme form of judicial activism where arbitrary and unreasonable interventions are made by the judiciary into the domain of the legislature or executive, e.g. directing to create a new policy to handle drought, setting up a bad loans panel, ordering to restore the internet in Kashmir, etc. E.g. Supreme Court, ruling on a PAL which was about road safety, has banned the sale of liquor at retail outlets, as also in hotels, restaurants, and bars that are within 500 m of any national or state highway. Methods of judicial activism, constitutional interpretation, judicial review. Power of the judiciary to interpret the Constitution and to declare any such law or order of the legislature and executive void. If it finds them in conflict with the Constitution, PL, the person filing the petition must not have any personal interest in the litigation. This petition is accepted by the court only if there is an interest of large public involved. Supervisory power of the higher courts on the lower courts. Access of international statute for ensuring constitutional rights. Benefits of judicial activism. Checks and balance. Creativity to bring out innovation in the form of a solution, e.g. giving the order to ban the polluting industry in the area around Taj Mahal, which has resulted in the restoration of heritage. Judges' wisdom, e.g. Vishaka guidelines to prevent sexual harassment at workplace. The shift from locus standi to public interest litigation made the judicial process more participatory and democratic. Complete delivery of justice. Invocation of Article 142 to release under trials and for granting $470 million compensation to victims of Bhopal gas tragedy. Speedy solution. Legislature gets stuck in the issue of majority. D.G. Banning of old vehicles in Delhi. Issues with judicial activism. Exceeding power. Judges are supposed to exercise judgment in interpreting the law, according to the Constitution. But sometimes they appear to exceed their power in deciding cases before the court. Hampering spirit of Constitution. It destroys the spirit of the Constitution as democracy stands on the separation of powers between the organs. Tyranny of unelected. Results in tyranny of the unelected as judges assume central role in day-to-day decision-making. Personal agenda. Judicial activism describes judicial rulings suspected of being based on personal or political considerations rather than on existing law. The judicial opinions of the judges once taken for any case becomes the standard for ruling other cases. Lack of expertise. Judiciary lacks both time and resources to enact legislation. Sometimes practical difficulties of such enactments are not known to the courts. Ban on BS4 vehicles from April 2020, which had to be extended many times. Concerns over judicial overreach. Undermining the doctrine of SOP. The power vested in SC in Article 142 is extraordinary. Frequent use of this power. Violation of the doctrine of separation of power. Negligence of the challenges faced by legislature and executive. The legislature and executive works depend on 4F, i.e. fund, function, framework, and functionary. Judicial order without considering the holistic impact on these 4F can cause harm to the economy, e.g. canceling of coal blocks allocations and spectrum allocations resulted in poor health of the financial institutions. Lack of accountability of the judiciary. Judiciary is not accountable to the people. Power of contempt of court could be misused to evade public criticism for many of its actions. Selfish motives of judges which can harm the public interest, e.g. proactive censorship in Jolly LLB, uncertainty in laws, e.g. cancellation of telecom license, knee-jerk reaction. Decisions in the anxiety of doing complete justice but without considering research on widespread consequences cause greater harm. E.g. highways liquor ban in 500 meters from national and state highways resulted into lakhs of unemployment. However, accidental deaths caused due to drunken driving were only 4.2% as against the 44.2% caused by overspeeding. Way ahead. Improving the quality of legislation. Judiciary should exercise self-restraint and eschew the temptation to act as a super-legislature. Article 142 cases should be referred to a constitution bench of at least 5 judges. This will ensure decision as an outcome of 5 independent judicial minds operating on matters having such far-reaching impact on the lives of people, appropriate when it is in the domain of legitimate judicial review. However, it should not be a norm nor should it result in judicial overreach. Making law is the function of the legislature and the executive has to implement it properly, so that only interpretation remains a work for the judiciary. Only the fine equilibrium between these organs of the government can sustain the constitutional values. Difference between judicial activism and judicial restraint. Perm Eater's judicial activism judicial restraint definition. It is judicial philosophy of going beyond the traditional role of just checking the legality of the law. Judicial philosophy of showing restraint from striking down a law or stopping interfering in the working of the other organs of the government. Usage when there is the scope of judicial intervention to correct things. When there is scope to maintain separation of powers and other grievance redressal mechanisms are available. Examples: the courts taking up suo moto cases. Banning the sale of liquor on highways, separation of powers, and other grievance redressal mechanisms. Expressing restraint from not involving in speakers' actions and deciding anti-defection law. Famous case: the 2G scam verdict cancelling telecom licenses. SR Bommai vs. Union of India 1994, Almatra H. Patel versus Union of India 1998. Keywords: public trust, contempt of court, judicial overreach, restatement of values of judicial life, locus standi, public interest litigation. Contempt of Courts Act, 1971 defines contempt of court as civil contempt, willful disobedience to any judgment, decree, direction, order, writ, or other processes of a court or willful breach of an undertaking given to a court. Constitutional provision, Article 129 and 215, powers SC and HC as a court of record including the power to punish for contempt of itself. Article 142(2) enables the Supreme Court to investigate and punish any person for its contempt. Need of contempt power, upheld court honor, judiciary rest on the trust of people. Freedom Law v. The High Court of MPSC held that it is the duty of the court to punish the Contempt Act to preserve its dignity. Types of contempt of court: 1. Civil contempt, criminal contempt. Willful disobedience, of Q&Y judgment publication of any matter which scandalize or lower the authority of the court, interferes or obstructs the administration of justice in any manner. Willful breach of any undertaking given to a court. Rule of law, disobedience of court's order violates the principle of rule of law. Hence contempt power holds together the basic structure of the Constitution. Equality before law, tool against the rich and the powerful by forcing compliance to the court orders. Independence of the judiciary, protection from the opinion of public and media trials. Reasonable restricts, Article 19(1) of the Constitution provides contempt of court as a reasonable restriction for curbing the freedom of speech and expression. Law Commission, 274th reports several inbuilt safeguards to protect against its misuse. E.g. Section 13 of the Contempt of Courts Act, 1971. If degree of harm is slight and beneath notice, the court won't punish for contempt, interference in justice administration. The High Court in Brahma Prakash Sharma v. State of Uttar Pradesh observed that it is not necessary to specifically prove that an actual interference with the administration of justice has been committed in contempt of court case. Argument against free speech and expression, judicial accountability. In free democratic society, criticism of the judiciary is inevitable to hold it accountable. It should not be a matter of concern as long as it doesn't obstruct justice delivery. Vague grounds such as scandalizing the court, are open-ended and prone to misuse. Against the principle of natural justice, no man should be the judge in his own case. But in contempt cases, judges are a judge in their own cause. International practices, USA, dignity of the court will not be established and respected if free discussions about the court were restricted on the pretext of preserving its duty. The contempt jurisdiction is not intended to uphold the personal dignity of the judges. Period of limitation. Despite the maximum duration for initiating contempt proceedings is 1 year, but many of the contempt cases are pending for more than 10 years. Way forward. Reduce discretion. Contempt power shall be made more determinate and principled. Identify the difference between contempt of court and contempt of judge. Proportional punishment. Punishment for contempt is inadequate and is not sufficient should be sufficiently enhanced to deal with interference in justice delivery. Deterrent. NCRWC, contempt power and judicial review restricted to SC and HC only. Elements of mens rea, legal concept denoting criminal intent or evil mind, may be incorporated in the Act. Public institutions in a free society must stand upon their own merits. They cannot withstand it if their conduct does not command the community's confidence. If their conduct justifies the respect of a community, then they do not need the protection under contempt rules. Keywords: rule of law, equality before law, reasonable restricts, proportional punishment, mens rea. Women in judiciary. Recently, Supreme Court had an all-woman bench which was only the third time in its history. Reasons for lower representation of women: social factor, long and inflexible work hours in law, combined with familial responsibilities, force many women to drop out of practice and they fail to meet the requirement of continuous practice. Seniority principle. This principle is followed in case of appointments to the higher judiciary. However, strict adherence to this also discourages more women appointments. Lack of judicial infrastructure, the absence of restrooms, child care facilities, etc. It was found in a survey of 6,000 trial courtrooms that about 22% of them do not have washroom facilities for women. No women reservation. Many states have a reservation policy for women in the lower judiciary, which is missing in the high courts and Supreme Court. Important data: women in working strength of judges is T3.9% in SCs, 93% in HCs, and 363% in subordinate courts. Only 3 times, 203, 2022, in history of SC, all women benches were formed. SC currently has only 3 women judges, and country will get its first woman Chief Justice only in 2027. Eligibility criteria for entrance exams. A major barrier to women's recruitment as district judges is the eligibility criteria to take the entrance exams. Lawyers need to have 7 years of continuous legal practice and be in the age bracket of 35 to 45. Low representation of women in litigation. Number of women advocates is still low, reducing the pool from which women judges can be selected. Frequent transfers. Magistrates are made to transfer every 3 years. This can be seen as another challenge to fill the gender gap in the judicial system, as the defined gender roles in the Indian society makes it difficult for women to stay away from their homes for their careers. Patriarchal society. According to a study by the International Commission of Jurists, ICJ, the lower representation of women in the judiciary is often due to gender stereotyping. Importance of women representation. Encourage more women to report cases. Easy availability of women advocates - make women victims more comfortable to communicate problems like sexual violence, justice quality. Empathy and sensitivity are virtues associated with women which can improve the quality of judgment. Public trust. Gender-diverse bench will result in judiciaries being perceived as more transparent, inclusive, and representative of the people whose lives they affect, breaking patriarchal barrier of terming women incapable for litigation jobs. Global commitment. SDG 5 and SDG 16 aims to achieve gender equality and women's representation in public institutions, such as the judiciary. Diversity in views. It is definitely valuable to have representation of various marginalities in the judiciary because of their different lived experiences. Diversity on the bench would bring an alternative and inclusive perspectives to statutory interpretations. Flip to women empowerment. More women as judges would hail as role models to other females, thus providing an overall lift to women empowerment. Way forward. Effective long-term plan. Collation of data of prospective women candidates in the lower judiciary, revisiting appointment criteria to ensure marginalized section women representation. Gender sensitization. Judges of old school and patriarchal in outlook should be sensitized to prevent them from passing orders objectifying women in sensitive cases. Retaining women in profession. Governments should rationalize salary and allowances of lower judiciary and provide security of income to female lawyers to reduce uncertainty. Societal mindset. Judges and lawyers shall be judged on merit and not on gender. Reservation. Higher judiciary should also have horizontal reservation for women, such as subordinate judiciary, without diluting merit. Fast-track courts. Recently, Law Minister presses for accelerating setting up fast-track courts, FTCs, and fast-track special courts, FTSCs. FTCs and FTSCs are dedicated courts expected to ensure swift dispensation of justice. Article 247, Parliament to establish certain additional courts for the better administration of laws made by it or of any existing laws with respect to a union list. Historical evolution. Important data. Of the sanctioned 1,200 FTCs, 243 were functional as of January. C. Pendency increasing by 90% since 2020. Of the 1,023 sanctioned FTSCs, 764 FTSCs including 411 exclusive POCSO courts, are functional in 22 states UTs as of January 2023. 0.98 lakh cases are pending in these FSCSJ. 11th Finance Commission, 2000 established 1734 fast-track courts - speedy disposal of pending cases especially under trials in the lower judiciary. HC appointed judges on an ad hoc basis from retired HC judges, eligible bar members, etc. 2005. 1562 FTC functional - scheme extended till 2011 - 2011. 1192 FTC functional. Post 2011. No central funding and state to establish FTC with their fund. 14th Finance Commission, setting up 1,800 FTCs, RS. for 1,144.00 crore, and urged the state to utilize the enhanced evolution of central taxes 42% to fund this effort. Ministry of Law and Justice, scheme for setting up 1023 FTSCs for rape and POSCO Act cases as a part of National Mission for Safety of Women in MSW. Important cases handled, 2,611 attack case, Best Bakery case. Advantages of FTC, reducing pendency. FTCs have solved millions of cases to reduce the burden on other courts. Judicial efficacy, simplified procedure - high case clearance rate and speedy trial rate - increases judicial efficacy. Promote specialization. FTCs are established to handle specific types of cases. This enables the appointment of experts in that field as judges. Consistency and predictability. FTCs have high performance rates and are stable and steady. It renders justice with high accuracy. Act as a deterrent. Speedy justice acts as an effective deterrence in reducing crime in society. Increase in effectiveness. Speedy justice results in enhanced efficiency and effectiveness of our judicial system, promoting people's confidence in the justice delivery mechanism in India. Issues faced. Systemic issues. An insufficient number of FTCs and judges compared to cases to be handled. E.g. Delhi FTCs have only 1 or 2 judges. Ad hocism. Instead of establishing to address pendency, established based on specific incidents. Heavy workload. Increasing cases assigned without increasing number of judges - increased pendency in FTCs, not special or speedier procedure, usual delay like the regular courts. NCRB 2018 78% out of 28,000 trials done in FTCs took more than a year to complete. Lack of infrastructure, often housed in an existing court and various equipments needed to conduct video and audio recordings of victims reduces the effectiveness, financial constraints, SC and Bridge Mohan law case. Continuation of FTCs is in the state domain with their funds. E.G. As per PRS date, March 2019, 56% of the states and UT had no FTCs. Lack of coordination, tribunals managed by different ministries, fast-track courts and special courts under different judicial bodies, with little coordination or uniformity among them. Way forward, capacity building and improving infrastructure, appointment of additional judges, making FTCs permanent, dedicated courtrooms, technological facilities, etc. shall be the priority. Suggested by the Supreme Court, the ad hoc judges and support staff should be granted permanent appointments shall be a priority. Modern technologies, tools like big data analysis, AI shall be used to ensure better grouping of cases and decide priority. Sensitizing state governments, Conference of Chief Ministers and Chief Justices, the state in consultation with Chief Justices of HC establish a suitable number of FTCs and provide adequate funds. Coordination, FTCs and special courts under different judicial bodies with little coordination a lead agency to be established by central and state governments to streamline the functioning of courts systematically. Holistic approach, police reforms to improve investigation, special procedure for speedy disposal of cases. Keywords, judicial infrastructure, national mission for safety of women, case listing, digital divide, data management. Regional bench off Supreme Court recently, the Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice informed the Parliament about the government's acceptance of its recommendation to establish regional benches of the Supreme Court, SC. The recommendations were made in the 133rd report of the Parliamentary Standing Committee titled, Judicial Processes and Their Reform. SC of India may invoke Article 130 of the Constitution for establishing its regional benches at 4 or 5 locations in the country. The interpretation of Constitution and constitutional matters may be dealt at Delhi, and the regional benches may decide appellate matters. The appellate bench's decisions should be treated as final, and it should not be treated as another layer of the judiciary. Law Commission's recommendations on regional benches of SC 95th Report of Law Commission, 1984 SC should consist of 2 divisions, namely, Constitutional Division and Legal Division. 229th Report of Law Commission, 2009 recommended setting up Constitution Bench at Delhi, 4 Cassation Benches in the Northern Region at Delhi, the Southern Region at Chennai Hyderabad, the Eastern Region at Kolkata, and the Western Region at Mumbai. Need for regional benches. Inclusive justice delivery. Article 39 Adirect states to make provisions to ensure that no person shall be deprived of getting justice. Accessibility. For the poor and people living in far-off places like the Northeast, access to SC seats in Delhi is less. High pendency. As per NJDG, approximate 80,000 cases are pending in SC, and disposal of appeals takes many years. Constitutional Court. Cases decided by Constitution benches, i.e. 5+ judges, have declined from about 15%, 1950s, to 0.12%, last decade. With regional benches, SC and Delhi can only hear matters of constitutional law. Economic growth. More prosperous states have higher civil litigation rates. But judicial backlogs discouraged civil case filings. Regional bench is a step in right direction. Recommended by various committees. Parliamentary Standing Committees in 2004, 2006, and 2008 recommended the same. Law Commission, 229th Report, Constitution Bench in Delhi for constitutional and allied issues, and 4 Cassation Benches in Delhi, Chennai Hyderabad, Kolkata, and Mumbai for all appellate work. Supreme Court, 1986 Establishment of National Court of Appeal with regional benches at Chennai, Mumbai, and Kolkata. O.V. Vasantha Kumar case, 2016 The SC referred the matter to a constitutional bench for the decision on the National Court of Appeal. Concerns may dilute superiority of the S decisions, fundamental change in the character of SC and its aura as apex court. It would require amending Article 130, which might not stand basic structure. Affect integrated judiciary system. In 2010, CJI and 27 judges had rejected Law Commission recommendations for regional benches, citing this reason. NALSA Parliamentary Standing Committee submitted its report on review of the working of legal aid under the Legal Services Authorities Act, 1987. The National Legal Services Authority, NALSA, has been constituted under the Legal Services Authorities Act, 1987 to monitor and evaluate the implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. Constitutional basis. Article 39A provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Articles 14 and 22, 1, make it obligatory for the state to ensure equality before the law and a legal system that promotes justice based on equal opportunity to all. Main functions: state legal services authorities, district legal services authorities, Talaka legal services committees discharge the following main functions on regular basis. O to provide free and competent legal services to the eligible persons. O to organize lock adalats for amicable settlement of disputes. O to organize legal awareness camps in the rural areas. O providing compensation to the victims of crime. O promoting dispute settlements. Persons eligible for getting free legal services includes women and children, members of SCSD. Industrial workmen. Victims of mass disaster, violence, flood, drought, earthquake, industrial disaster. Disabled persons. Persons in custody. Persons whose annual income does not exceed Rs. 1 lakh. In the Supreme Court Legal Services Committee, the limit is Rs. 5,000,000. Victims of trafficking in human beings or beggar. Challenges faced in ensuring free legal aid. Lack of awareness among people about their basic rights of free legal aid. Free aid versus quality. There is a perception that free service doesn't provide quality services. History of legal aid movement in India. I-960 Introduction of Guidelines for Legal Aid Scheme. 1976 Article 39 A 62nd CAA, 1976. 1980 Formation of Silas, Committee FO are implementing legal aid schemes. Under Justice Bhagwati. 1987 Enactment of Legal Service Authorities Act. 1995 Establishment of NALSA. 1998 Introduction of lock adalats offering ADR mechanism. 2000. L. Various other initiatives like literacy programs, counseling centers, etc. Human resources, dearth of enough lawyers to deliver free legal aid by the legal services authorities. Lack of motivation. Though lawyers are assigned to provide legal aid and paid with public funds, they lack interest in their clients. This hampers the quality of arguments by lawyers. Demand for money. Assigned lawyers compel many innocent clients to pay additional amounts of money to them, even though services are free. Inefficiency. The system for free legal aid is not very streamlined and standardized. This has resulted in inefficient delivery of free legal aid. Way forward. Encourage more lawyers to deliver free legal supplemented with an awareness campaign to inform people about free legal aid. Lock adalat and mediation. Legal aid and assistance. OV-Treach programs. Key. Of NALSA programs. Victim compensation schemes. The use of ICT, big data analytics, etc. can minimize the average time between application for legal aid and lawyer assigned time, which at present is 11 days nationally. Incentivizing lawyer for free legal aid with a decent salary and other additional perks like a priority in any appointment process, international experience, for seamless delivery of free legal aid countries like South Africa, Kenya, etc. Categorized it as essential services. SDG 16 seeks to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. The role played by NALSA and its networks assist in achieving the same. Government initiatives for legal aid, designing innovative solutions for holistic access to justice in India. Disha Nyaya Bandha platform, facilitate connection between pro bono advocates and registered beneficiaries, encouraging pro bono culture among law students, advocates, and law schools. Telelaw service, connect beneficiaries with lawyers via televideo conferencing, available in 2.5 lakh gram panchayats across 766 districts. Legal Aid Defense Counsel System, LADCS, initiated by NALSA, ensures efficient legal aid in criminal cases by engaging full-time lawyers across 676 districts nationwide, mirroring public defender systems in developed countries. Keywords: cassation benches, essential services, state legal services authorities, district legal services authorities, language barrier, National Court of Appeal, civil litigation rates, inclusive justice delivery. Judicial infrastructure in India. The Chief Justice of India proposed creation of a National Judicial Infrastructure Authority of India, NJII. What is judicial infrastructure? An efficient judicial infrastructure means providing equal and free access to justice. This could be realized through a barrier-free and citizen-friendly environment. It includes the physical premises of courts, tribunals, lawyers' chambers, digital and human resources infrastructure, etc., that are essential to ensure timely dispensation of justice. Reasons for the poor judicial infrastructure in India. Low budgetary allocation. India spends only about 0.09% of its GDP to maintain the judicial infrastructure. A 2023 report published by the Supreme Court showed that existing infrastructure could accommodate only 20,831 sanctioned strength of judges in district judiciary against the all India sanctioned strength of 25,081. Lack of planning. The infrastructure is overburdened as the future needs are not adequately addressed during the construction itself. Complex financing. The financing judicial infrastructure requires coordination between various departments of the state government, including the district collectorate, the public works department, and the finance ministry. Delay and underutilization of resources. The primary responsibility of infrastructure development for the subordinate judiciary rests with the state governments. Some of the states are either delaying the process or not giving their share of money as a contributing share. Judiciary's dependence on the executive. The project design, monitoring, and execution of the infrastructure, mainly the building infrastructure, remains the sole prerogative of the Public Works Department's PWD. Need for reforms in judicial infrastructure. High pendency. There is a huge backlog of over 4.4 crore pending cases. A study by the Ministry of Finance found that it takes, on an average, almost 20 years for a property-related dispute to be resolved, and that it would take 324 years just to clear the present backlog at the current rate of disposal. Issues with enforcing contracts. Ease of doing business in India is severely constrained by the inability to enforce contracts or laws, lengthy and costly litigation and arbitration processes, and archaic legislations. Digitization of judiciary. In the backdrop of COVID-19 pandemic and the shift towards digital mode, it is all the more important to ensure modernization of judicial infrastructure in the country. At present, 73% of courtrooms have no video conferencing facility. Lack of accountability. In the absence of a dedicated special purpose vehicle or body for the purpose of enhancing judicial infrastructure, nobody is willing to take responsibility to execute infrastructure projects. Underutilization of funds. Some states transfer part of the funds for non-judicial purposes. Out of total 981.98 crore sanctioned in 2019-20 under CSS, only 84.9 crore was utilized by a combined 5 states, rendering the remaining 91.36% funds unused. Institutionalizing the mechanism for augmenting and creating state-of-the-art judicial infrastructure will help in delivering quantitative and qualitative justice and ensure the bell of justice rings at the door of those deprived and underprivileged. Keywords: National Judicial Infrastructure Authority of India, Sarkaria Commission Report, President's Rule, Underutilization of Funds, State Emergency, Constitutional Emergency, Digitization of Judiciary. Previous year question. 1. The judicial systems in India and UK seem to be converging as well as diverging in recent times. Highlight the key points of convergence and divergence between the two nations in terms of their judicial practices. 2020. 2. Judicial legislation is antithetical to the doctrine of separation of powers as envisaged in the Indian Constitution. In this context, justify the filing of large number of public interest petitions praying for issuing guidelines to executive authorities. 2020. 3. Critically examine the Supreme Court's judgment on National Judicial Appointments Commission Act, 2014, with reference to appointment of judges of higher judiciary in India. 2017-13 Dispute Redressal Mechanism. A dispute redressal mechanism is a structured process that addresses disputes or grievances that arise between two or more parties engaged in business, legal, or societal relationships. Dispute redressal mechanisms are typically non-judicial in nature, meaning that they are not resolved within the court of law. The different mechanisms formed in India: Gram Sabha, Nyaya Panchayat, Lok Adalat, Family Court, Counseling Centers, Commission of Inquiry, Tribunal, Consumer Court, Indian legislation on ADR, etc. Main focus. In essence, the system focuses on mediation rather than winner-take-all, increasing accessibility to justice and improving efficiency in reducing court delays. Alternative dispute resolution. ADR. ADR means any procedure agreed to by the parties of a dispute, in which they use the services of a neutral party to assist them in reaching an agreement and avoiding litigation. Constitutional basis. Article 14. Equality before law. Article 32. Right to constitutional remedies. Right of people to seek justice. Article 39A. Equal justice and free legal aid. Advantages. OFIDER. Law Commission. According to the Law Commission Report 222, need for justice dispensation. Advantage of ADR. Area less expensive. O less time-consuming. No appeal. Speedy dispute resolution. O free from technicalities. It is more flexible and responsive to the individual needs of the people involved. O parties are free to discuss their differences of opinion without any fear of disclosure before the court. Continuing relationship. No feeling of winning and losing among parties and grievances getting redressed. More likely to preserve goodwill. Improved enforcement. As per World Bank's Ease of Doing Business report, average days for enforcement of contracts in India is more than the other emerging economies. The ADR can help to improve it. Greater compliance. The parties' involvement in the process creates greater commitment to the result so that compliance is more likely. Saving forex reserves. Significant amounts of forex are lost on arbitration in foreign countries like Singapore. Limitations. OFIDER. Lack of awareness. People, lawyers, and judicial officers are unaware of the mandate to transfer cases to arbitration and conciliation. The good faith of the parties, that is necessary for the success of ADR. Uninformed parties remain at a disadvantage in succeeding in an ADR. Skepticism about the process and result. Many of the litigants are not satisfied and invariably dissociate themselves and go to formal courts. Voluntary process. Without a mutually signed agreement, parties can't be forced to resolve their disputes by ADR. Neutral arbitrator. Unsatisfied party invariably blames the arbitrator for bias and non-fairness. Non-resolution of disputes. Except for arbitration, a binding decision, the ADR process may not always yield a resolution. It can be used just as a stalling tactic. Limited scope. ADR resolves only issues of money or civil disputes, and its proceedings will not result in injunctive orders, ordering parties to do or not do something. No appeal. Unlike courts where appeal to a higher court is available, the decision of a neutral arbitrator cannot be appealed. Way forward, speedy, and successful ADR. Incorporating tools like Adalat, expanding scope and pre-litigation building confidence in the litigants and making them opt for ADR mechanisms. Promote as a career by creating trained arbitrators and mediators, laying down procedures for quality control, ethical standards, and accountability of arbitrators. Expand scope. Establish arbitration and mediation centers for non-commercial disputes. Attitudinal change. It needs to bring people to choose ADR mechanisms with confidence and trust. Other measures. Infrastructure for ADR, skilling of lawyers in ADR, providing required manpower. Arbitration and Conciliation Amendment Bill enacted the Arbitration and Conciliation Amendment Act 2021 to fill legislative lacuna. Arbitration Council of India, appointment of arbitrator by SCHC. Electronic depository of arbitral awards, protect the arbitrator from legal proceedings for an action done in good faith. Lokadalat, philosophy. Lokadalat is a unique system developed in India. It means people's court and is based on Gandhian principles. It encompasses negotiation, mediation, and conciliation as tools to settle disputes between the parties. First Lokadalat camp and post-independence was organized in Gujarat in 1982. Jurisdiction. The cases or disputes which are pending in a court or which are at the pre-litigation stage, not yet brought before a court. Some cases taken up in Lokadalats are matrimonial family disputes, criminal compoundable offenses cases, land acquisition cases, etc. Offenses which are non-compoundable, serious in nature, under any law fall outside the purview of the LA. Present status. The institution of Lokadalats has been given statutory status under the Legal Services Authorities Act 1987. Organizing authority. The State District Legal Services Authority or SCHC Taluk Legal Services Committee may organize Lokadalats. Members. Lokadalat members consist of a judicial officer, chairman, a lawyer, advocate, and a social worker. Power of civil court. Lokadalats have the same powers as vested in civil courts under the Code of Civil Procedure, 1908, and Code of Criminal Procedure, 1973. No appeal shall lie to any court against the award of the Lokadalat. One of the advantages of Lokadalat is that a number of disputes between different parties can be settled in one go without wasting much time. Mobile Lokadalat systems. Revolutionary changes are also happening in the administration of Lokadalats with the introduction of mobile Lokadalat systems to bring justice to the doorsteps of the needy and poor. OnlyIAS. Evolution of OnlyIAS Law Commission in the 114th report recommended establishing them with the following purpose: more humane and accessible justice delivery to the most marginalized sections. Reduce around 50% of case pendency in subordinate courts, reduce workload on higher tiers of the judiciary. OnlyIAS Act, 2008. It was expected to set up 5,000 OnlyIAS and central government allocated about Rs. 1,400 crores as assistance to the state's UTs. The uniqueness of OnlyIAS. Mobile courts, presided over by Nyadhikaris, judicial officer equivalent of judicial magistrates of the first class. Appointed by the state governments in consultation with its high court powers of both criminal and civil courts, and their judicial competence was to be limited to disputes specified in the first 3 schedules of the Act. Aim for the settlement of disputes using reconciliation. Not bound by the rules of evidence under the Indian Evidence Act of 1872, but subject to rules framed by respective HCs and guided by the principles of natural justice. Appeal to the district court in civil cases and sessions court in criminal cases. Established at headquarter of every panchayat at the intermediate level or a group of contiguous panchayat in a district where there is no panchayat at the intermediate level. Reason for poor functioning of OnlyIAS. Overlapping jurisdiction. Over the years, many states have established regular courts at the taluka level, thereby lessening the need for an additional institution of OnlyIAS. Lack of attention. Despite 1,400 CR allocations by the central government, OnlyIAS have simply been sidelined by most state governments in their pecking order of policy priorities. The slow pace of funds utilization under the scheme due to the lack of proposals from the states for setting up OnlyIAS. Lack of human resources, shortage of judicial officers for Nyadhikaris post, non-availability of notaries, stamp vendors, etc. have hampered the progress. Lack of clarity. Whether OnlyIAS gives an additional option for quick dispute resolution or not is doubtful, as alternative forums, such as labor courts and family courts, are already available. Lack of awareness. In general, awareness among all stakeholders, i.e. litigants, lawyers, and police officers involved in case resolutions, remain extremely limited. Way forward, mass awareness campaigns to sensitize stakeholders on the utility and benefits of such a forum for availing justice. Establishing permanent OnlyIAS in every panchayat and making new judicial officers mandatory to serve in it to train OnlyIAS. A cadre of OnlyIAS, individuals with a degree in social work along with law, shall be recruited to this service. Change in working. The judicial, political, and executive will have been completely missing to establish OnlyIAS. This needs to be changed first and foremost. Other measures. Creation of necessary infrastructure like separate buildings, local language training to recruit NIADAKARIs, etc. Keywords: Gandhian Principle, Non-Compoundable, Legal Services Authorities Act 1987, Legal Services Committee, NIADAKARIs. Tribunals, Part 14. Article 323A, 323B. Recently, the Supreme Court, SC, ruled that tribunals cannot direct the government to frame policy. Also, SC said that making policy is not in the domain of the judiciary. Definition: a tribunal is a quasi-judicial institution constituted with the objective of speedy, inexpensive, and decentralized dispute resolution in various matters like administrative or tax-related disputes. Constitutional provision. Constitution by 42nd Amendment Act, 1976, Sworn Singh Committee. Dimension: Article 323, A. Article 323b. Purpose: administrative tribunals. Tribunals for other matters established only by Parliament, both by Parliament and state hierarchy. May be created. Advantages of tribunals: flexibility, not restrained by rigid rules under the Civil Procedure Code and the Indian Evidence Act, and follow the principles of natural justice. Relief to courts, relief to overburdened ordinary courts of law. Less expensive, less formal, and a faster way to resolve disputes than the traditional court. Legally binding decisions, same powers as a civil court, viz. issuing summons and allowing witnesses to give evidence. Its decisions are legally binding on the parties, subject to appeal. Technical expertise, provision to appoint expert members who play a critical role in the adjudication of matters demanding technical expertise. Concerns with tribunals: against the separation of powers. It has both administrative and judicial members. Conflict of interest, appointments by executive, and executive is also the largest litigant in the country. Undermining judicial authority, largely replaced HC for disputes under the various acts. Appeal against the appellate tribunal, directly go to SC, sidestepping the HC. L. Chandrakumar's case, first appeal to HC, lack of autonomy, operates under parent administrative ministries at their mercy for facilities, infrastructure, and also rulemaking. Low transparency, lack of information available on the functioning, websites are routinely non-existent, unresponsive, or not updated. Increasing pendency, average pendency is 3.8 years, pendency in high courts is 4.3 years, overlapping jurisdiction. Tribunals function under various ministries and departments, creating confusion about the management of the tribunals. Also, multiple tribunals perform similar functions. Delayed awards. Kaveri Interstate Water Dispute Tribunal was established in 1990 and took 17 years to pronounce its judgment in 2007. This was further challenged in the Supreme Court. This reflects the very purpose of the tribunal as a quick dispute resolution mechanism. Way forward, Law Commission. Procedure for improving the working of the tribunal system, qualification of judges, transfer of HC jurisdiction qualified to be HC judge. Appointment. Nodal agency under law ministry to ensure uniformity in the appointment, tenure, and service conditions of all members appointed in the tribunals. Vacancy. Filled preferably within 6 months before occurrence by initiating the procedure well in time. Selection of the members. Impartial with minimal involvement of government agencies. Separate selection committee for both judicial and administrative members. Tenure. Chairman 3 years 70 years and Vice Chairman and members 3 years 67 years. Accessibility. Benches in different parts of the country, ideally where the HC are situated. Aligning with the basic structure. Tribunal order may be challenged before the division bench of the HC having territorial jurisdiction over the tribunal. Tribunal reforms, ACT 2021. The Tribunals Reforms Bill 2021 was introduced in Lok Sabha by the Finance Minister, Ms. Nirmala Sitharaman, on August 2, 2021. Now it became an act after presidential assent. Features: qualifications of tribunal members. Their service terms, such as qualifications, removal, and pay, are to be decided by the central government. Search and selection committees. The chairperson and members of the tribunals shall be selected by the central government based on the recommendations of a search cum selection committee. State administrative tribunals will have their own search and selection panels. The central government shall act on the recommendations of selection committees as soon as possible, preferably within 3 months of the date of the recommendation. Eligibility and term of office. The Act establishes a 4-year tenure for tribunal members. It establishes a maximum age of 70 years for the chairperson and 67 years for the other members. The minimum age for appointments is 50 years. Uniform compensation and rules. The statute establishes uniform pay and rules for search and selection committees across tribunals. It also allows for the removal of tribunal members. It provides that the central government may remove any chairperson or member from office upon the suggestion of the search cum selection committee. Pay and allowances. The statute specifies that the chairpersons and members of the tribunal being disbanded would cease to hold office and will be entitled to compensation equal to 3 months' pay and allowances for their premature termination. Keywords: Armed Forces Tribunal, Sworn Singh Committee, Conflict of Interest, L. Chandrakumar's case. State water disputes. Recently, the Union Cabinet approved the terms of reference to Krishna Water Disputes Tribunal 2, KWD2, under the Interstate River Water Disputes, ISRWD, Act, 1956. Constitutional Provisions Article 262. According to this article, in case of disputes relating to waters, Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution, or control of the waters of, or in, any interstate river or river valley. Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as mentioned above. Article 246. 7th Schedule of the Constitution distinguishes between the use of water within a state list, and the purpose of regulating interstate water, union list. Parliament has enacted TWO laws. River Boards Act, 1956. A river board is established by the central government on the request of the state governments concerned to advise them. Interstate Water Disputes Act, 1956, an act to provide for the adjudication of disputes relating to waters of interstate rivers and river valleys. Online Dispute Resolution. Definition. ODR is the resolution of disputes, particularly SM-all and M-idiom value cases, using digital technology and techniques of alternate dispute resolution ADR, such as negotiation, mediation, and arbitration. Current status: low ranking. We are ranked 163rd in contract enforcement, a slight improvement from 186th in 2015 and 173rd in 2016 in ease of doing index. High project cost. For these requirements, we also perform poorly in terms of time, for years, and cost, more than 30% of project cost. Sri Krishna Committee. According to the Sri Krishna Committee's 2017 report, we have also earned a reputation for being antagonistic to arbitration. Benefits of ODR: increased access to justice. ODR tools such as online negotiation and mediation are based on the parties coming to a consensual agreement, making the dispute resolution process less confrontational and complicated for the parties, hence increasing access to justice. Improve legal health of the society. Easier access to dispute resolution processes will improve the judicial health of society by ensuring that individuals and businesses are aware of their rights and have the tools to enforce them. Convenient and quick dispute resolutions. It will reduce travel time and cost associated with it. By providing a speedier and more convenient mechanism for resolving disputes, ODR can help to reduce delays. Cost-effective. ODR has the potential to lower legal costs by shortening the time it takes to resolve disputes and eliminating the need for legal counsel. Removes unconscious bias. While resolving conflicts, ODR techniques reduce the neutral's implicit prejudice. ODR platforms separate audiovisual cues relating to gender, socioeconomic position, ethnicity, race, and other factors, and aid in the resolution of conflicts based on the claims and information provided by disputing parties. Examples from around the world. Singapore, a small country, established the Singapore International Arbitration Center in the 1990s when India was opening up to global investment. Since then, it has grown as a global arbitration powerhouse, as evidenced by its #1 ranking in enforcing contracts. Ironically, Indian businesses are among its most important clients. Challenges associated with ODR: archaic legal processes. The antiquated procedure does not function well with the end-to-end online dispute resolution process and creates obstacles for ODR. Furthermore, the notarization of documents is only possible in person under the notary's rule of 1956. Therefore, online assistance will be problematic. Digital infrastructure. Adoption of ODR will necessitate critical technological infrastructure across the country, with high-bandwidth internet connections. Digital India Mission and BharatNet Mission can be instrumental in achieving seamless digital connectivity. Lack of awareness regarding ODR. Due to a lack of understanding about ODR, plaintiffs and their attorneys are more likely to file lawsuits. Businesses with a low level of trust in ODR will practice little ODR usage. Privacy issues, online impersonation, violation of confidentiality through the circulation of papers and data given during ODR processes, and tampering with digital evidence or digitally transmitted awards agreements are only a few privacy-related issues. Why ahead, improving digital connectivity and digital literacy. Digital India Mission and BharatNet Mission can be instrumental in achieving seamless digital connectivity. DISH's mission aims to improve digital literacy in rural areas. Adoption of ODR for government litigation mechanism. According to the Ministry of Law and Justice, government departments are a party to around 46% of court cases. Capacity building. Time-to-time skill upgradation of employees associated with the ODR mechanism to make technology adoption easier. Augmenting archaic laws and regulation of the ODR mechanism. It is critical that the regulatory approach safeguards end users' rights while avoiding over-regulation that stifles innovation. Government agencies should investigate ODR as a means of resolving grievances. Proactive adoption of ODR by government institutions will not only build trust in the process but will also provide citizens with a convenient and cost-effective method of resolving issues with the government. Keywords: Digital India Mission, BharatNet Mission, River Boards, Concurrent List, Interstate Council, Mihir Shah's Report, Interlinking of Rivers, Cooperative Federalism, Sri Krishna Committee. Previous year questions. 1. The Central Administration Tribunal, which was established for redressal of grievances and complaints by or against central government employees nowadays, is exercising its powers as an independent judicial authority. Explain. 2019. 2. How far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? In view of the above, discuss the constitutional validity and competency of the tribunals in India. 2018. 3. What is the quasi-judicial body? Explain with the help of concrete examples. 2016. 4. What are the major changes brought in the Arbitration and Conciliation Act, 1996 through the recent ordinance promulgated by the President? How far will it improve India's dispute resolution mechanism? Discuss. 2015. 5. Constitutional mechanisms to resolve interstate water disputes have failed to address and solve the problems. Is the failure due to structural or process inadequacy, or both? Discuss. 2013 Local Self-Government, Part 9, Part 9a. The Panchayat's local self-government in India empowers local bodies to govern their jurisdictions, fostering democratic values and grassroots development. It ensures effective governance, citizen participation, and delivery of essential services at the local level. Issues and challenges faced by Panchayati Raj government. Recently, the Reserve Bank of India, RBI, released its report titled Finances of Panchayati Raj Institutions. The report discusses the fiscal position of PRIs for the years 2020 to 21 to 2022 to 23. The second ART mentions 3 FS, functions, funds, and functionaries, for the ineffectiveness of panchayats. Funds, inadequate funds, with little of its own funds and inadequate devolution from the states, PRIs in many states have been reduced to simple agents of higher-level governments. Inadequate powers to generate revenue. PRIs have limited powers in respect of imposing cesses and taxes. Further, they are usually hesitant to collect required funds for fear of losing public support. State Finance Commission. Many state governments have failed in appointing the State Finance Commission on time as mandated by Article 243(I) of the 15th FCHAS made it mandatory to set up of state finance commissions in states before March 2024 to receive grants for local bodies. Reluctant to tax locals. The Gram Panchayats neither show conviction to tax local people nor revise the existing tax periodically. As a result, they are permanently dependent on fund devolutions. Finances mechanisms of panchayats and municipality. Grants, by center, Article 280, and state government, devolution from state government based on state FC. Loans, from state government, internal resource generation, tax and non-tax, program-specific allocation, under centrally sponsored schemes and additional central assistance. Functions, poor devolution of functions to local bodies. Article 243G asks state legislatures for devolving the functions. Example, core functions like water supply, sanitation, link roads, street lighting, maintenance of community assets, etc. continue to be in the hands of state governments. Unfunctional District Planning Committee. Despite the availability of the District Planning Committee as a constitutional mechanism for integrated planning of rural and urban areas, most states have not made them functionally empowered. Women have token representation. Most states now have 50% of panchayat seats reserved for. Principle of Foundation FO are subsidiary democratic structure. Local leadership significance of PRIs EWMOM PEW in participatory grassroots democracy. Women, but there still continues a dominant narrative about how these women remain titular post holders with their husbands taking the lead. Functionaries, low manpower. The municipal administrations don't have enough people to handle even the most fundamental duties. Additionally, because the majority of personnel are hired by higher-level departments and deputed to local governments, they do not feel accountable to the latter. Instead, They work as a part of a departmental system that is vertically integrated. Missing accountability mechanisms. Accountability of public funds is at the heart of sound public finance. Not enough progress has been made in this area. The 15th FC has included having both provisional and audited accounts online in the public domain to be one of the entry-level conditions for local bodies to receive grants. Delayed elections. Delay in PRI elections is becoming a frequent phenomenon that downgrades the effectiveness of PRIs. PRI elections have been delayed in MP, Haryana, and TN. Politicization of PRIs. Now, Panchayati Raj institutions are viewed only as organizational arms of political parties, especially of the ruling party in the state. Government efforts for empowering PRI, ensuring property rights. The ministry has launched a scheme named Svamitva to prepare property records of rural people of their houses using drone surveying technology. Capacity building of PRIs. A new scheme of Rashtriya Gram Swaraj Abhiyan, RGSA, was launched on April 1, 2018, to develop and strengthen the capacities of PRIs. E-Gram Swaraj. It assists in enhancing the credibility of panchayats, which would induce greater devolution of funds to PRIs as well as provide a platform for effective monitoring by higher authorities. Gram Panchayat Development Plan, GPDP. It is an annual exercise carried out by Ministry of Panchayati Raj, MOPR. In all Gram Panchayats and other local self-governance bodies where GP development plans are prepared in a participatory manner under People's Plan campaign. Capacity building. Panchayat Sashaktikaren Abhiyan. CPSAID had provided assistance to the state's UTs for capacity building and training of Panchayat elected representatives to enable them to perform their functions, including planning and implementation of development programs effectively and efficiently. Steps to be taken. Fiscal federalism in true spirit. The second arcade had recommended that there should be a clear-cut demarcation of functions of each tier of the government. The 15th Finance Commission, 15FC. In its interim report for 2020-21 and final report for 2021 to 2026 recommended an amount of 60,750 rupees crore and 236,805 rupees crore respectively for all three tiers of panchayats. District-level planning. District planning based on grassroots inputs received from the village, intermediate, and district levels through people's participation in the gram and ward savas. Audit committees. They may be established at the district level by the state governments to oversee the accuracy of financial data, the effectiveness of internal controls, adherence to the relevant legislation, and the moral character of every member of local bodies. Financial empowerment. Panchayats need to be empowered to levy and collect taxes, tolls, user charges, fees, etc., along with other activities to enhance their own source of revenue. Separate cadre. Establish a separate cadre of panchayat officials who would be subordinate to the elected authority, not lording it over them. Digital panchayats. eGrams Swaraj PFMS interface. It is a simplified work-based accounting application for Panchayati Raj. eGrams Swaraj PFMS interface (EGSBI). It was launched in 2018 for enhancing transparency and accountability. In order to facilitate online payments by panchayats for expenses incurred by the Central Finance Commission, the accounting module of EGS and the public financial management system were integrated. Keywords: Montague-Chelmsford reforms, 3FS, function, fund, and functionaries, centrally sponsored schemes, Rashtriya Gram Swaraj Abhiyan. Role of women in Panchayati Raj Institution for women. Almost one-third of all constituencies have been set aside. Additionally, it promotes and guarantees women's involvement in public life. It aims to develop a fundamentally sound national policy for women. Positive outcomes and empowerment. Women become more powerful and have their economic, social, and political status in society elevated with the implementation of the reservation system in Panchayati Raj institutions. It allows for liberalization within the traditionally male-dominated culture and introduces a new viewpoint on sound governance. Women are encouraged to participate in politics thanks to the reservation system. It has improved outcomes in terms of health, education, and family income, among other areas. The Panchayati Raj system has now recognized women's rights as a result of the passage of this amendment, a critical step towards realizing the potential that women have to contribute to government. It makes it possible for women to participate in planning, decision-making, and necessity execution in rural panchayats. Challenge sand issues. Panchayat Pati Raj System, proxy politics, and gender-based discrimination. Extreme violence was a barrier that the women sarpanches had to overcome in order to challenge established power structures in their communities. Additionally, it has been noticed that male family members use the status of the women in their families as an advantage when running for office, allowing the men to use the women to dominate the PRI. Both visiting the Gram Panchayat office and managing and controlling the Gram Sabhas were prohibited for Dalit women Panchayat leaders. As agents, their husbands were in charge of the office. The municipalities recently, the Capacity Building Commission, CBC, in collaboration with MHUA, organized a national workshop on capacity building of ULBs to foster a unified approach to capacity building ULBs across India. The workshop marked the launch of key initiatives, i.e., Annual Capacity Building Plan, ACBP, to enhance the capabilities of MHUA. ACBP for 6 pilot ULBs, i.e. Ahmedabad, Bhubaneswar, Mysore, Rajkot, Nagpur, and Pune need for capacity building for ULBs. To cater the needs of increasing India's urban population, which is expected to almost double from 460 million 2018 to 876 million by 2050. To deal with regional aspirations by ensuring social and economic development through bottom-up planning. For successful and effective implementation of schemes like Smart City Mission, Amrut Mission, etc. Impact of local self-government. Decentralization of power. Local self-governance has empowered local communities to make decisions and implement policies that directly affect their areas. Community participation. For instance, ward committees in urban areas provide a platform for residents to voice their concerns, suggest improvements. Effective service delivery. For instance, village panchayats responsible for providing essential services like water supply, sanitation, etc. Ensure better responsiveness to local needs. Grassroots development. For example, district planning committees play a crucial role in formulating district-level development plans that address the unique needs and priorities of the local population. Empowerment of marginalized communities. For instance, the reservation of seats for scheduled castes, scheduled tribes, and women in local bodies ensures they're active. Issues in municipalities. Lesser functional autonomy of UAB. 12th schedule of the 74th CAA. 18 functions are enlisted that are required to be performed by the ULBs, but many states have not been allotted all the functions to ULBs. In a considerable number of states like Karnataka and Kerala, even water supply is still managed by respective state government. Low revenue. Property tax is the single largest source of own revenue for ULBs. However, the tax collections are low, due to wide exemptions, undervaluation of property, and incomplete land registers. Concentration of power. Power in urban bodies is consolidated in a single municipal body, whether it is a municipal corporation, municipal council, or town panchayat. Poor link with urban citizens. Citizens in urban areas are rarely included or involved in decision-making, especially the marginalized and vulnerable sections of society who indeed are the most affected by the emerging crisis of urbanization. Measures taken for capacity building of ULBs. National Urban Digital Mission. It aims to create a shared digital infrastructure working across 3 pillars of people, processes, and platform to provide a framework for digital governance in the country. Jawaharlal Nehru National Urban Renewal Mission, JNURM, focuses on efficiency in urban infrastructure and service delivery mechanisms, community participation, and accountability of ULB's parastatal agencies towards citizens. Municipal bonds. These are financial instruments that municipal corporations and other associated bodies in India issue to raise funds. Way forward, leveraging city economy. Each city needs to be recognized as a distinct unit of the economy. In larger cities, city economic councils can serve as a clearinghouse between businesses and governments to hasten the progress of specific projects, improve the ease of doing business, and catalyze investments into the city. Encourage transfer of FFF. State governments can be encouraged to transfer 12th schedule funds, functions, and functionaries to the ULBs. Strengthening finances of ULBs and civic agencies. This includes market-oriented revenue models, value capture techniques, fiscal decentralization, medium-term fiscal plans, PPPs in urban infrastructure and services, and financial accountability via audited balance sheets and performance MIS reports. It also includes optimizing return on assets, particularly land and buildings. Citizen participation. Enhanced citizen participation is needed for greater trust between citizens and governments, improved sustainability, better service delivery, and accountability. Ward committees and area savas should be activated with a technology-enabled, open cities framework and the use of digital tools for feedback and reporting. Municipalities in India serve as vital units of local governance, responsible for the administration and development of urban areas. Continued efforts are needed to enhance the effectiveness and efficiency of municipal governance, ensuring sustainable and inclusive urban development in India. Keywords: Panchayat Patti Raj System, Capacity Building Commission, State Finance Commission, Decentralization of Power, Community Participation, Ward Committees, District Planning Committees, Functional Autonomy, City Economic Councils. Value Capture Techniques, Medium-Term Fiscal Plans, Open Cities Framework. Municipal elections. The Supreme Court invalidated and annulled the outcome of the mayoral elections held for the Chandigarh Municipal Corporation. Need for fair and timely municipal elections. The first mile connect. Municipalities are critical since councillors serve as first-mile, elected citizens' representatives. Tackle grassroots level issues. Timely elections would ensure local action which is required to tackle the 21st century human development priorities, which includes environmental sustainability, primary healthcare, gender equality, and jobs and livelihoods. Challenges in municipal elections, untimely elections, despite the SC-specific direction in Suresh Mahajan v. State of Madhya Pradesh, 2022, state governments do not hold timely elections for urban local governments. Over 1,500 municipalities did not have elected councils in place from 2015 to 2021 across states. Delay in council formation. Even after elections, councils are not constituted, and elections of mayors, deputy mayors, and standing committees are delayed. Delimitation and reservation. Most of the time state delayed the delimitation process, which in turn delayed council elections. Inconsistent mayoral terms. In India, 17% of cities, including 5 of the 8 largest ones, have mayoral terms less than 5 years. While the terms of mayors, deputy mayors, and standing committees being less than 5 years leads to frequent elections. SECs lack power, as they depend on state governments to complete the delimitation of ward boundaries and to notify reservations for women as well as marginalized communities. Way forward, the power of delimitation must be vested in the SECs or an independent delimitation commission in each state for conducting the delimitation and reservation process. Empowering SECs, strengthening SECs, and giving them a more significant role in the entire election process can help ensure timely, free, and fair municipal elections. Single electoral roll. A single electoral roll for all 3 tiers of government, as suggested by the High-Level Committee on Simultaneous Elections, will reduce redundancy and duplication across multiple agencies. Previous year questions. 1. To what extent, in your opinion, has the decentralization of power in India changed the governance landscape at the grassroots? 2020. 2. The strength sustenance of local institutions in India has shifted from their formative phase of functions, functionaries, and funds to the contemporary stage of functionality. Highlight the critical challenges faced by local institutions in terms of off-tier functionality in recent times. 2020. 3. The reservation of seats for women in the institution of local self-government has had a limited impact on the patriarchal character of the Indian political process. Comment. 2019. 4. Assess the importance of the panchayat system in India as a part of local government. Apart from government grants, what sources the panchayats can look out for financing developmental projects? 2018. 5. The local self-government system in India has not proved to be an effective instrument of governance. Critically examine the statement and give your views to improve the situation. 2017. 6. In the absence of a well-educated and organized local-level government system, panchayats and samitis have remained mainly political institutions and not effective instruments of governance. Critically discuss. 2015. Mains Wallah PYQs. Mains Wallah. GNERLSTUDIES-2. Our offline centers. KRLBAC MUK HERJENAGA are Lucknow, PATNA. 992-061-3613 PWONLYIAS. COEM. Year, WISE Subject, C. Overage. C. Errant A. Fairs Integ rated M. Odell Answers. 2014 to 2023. Wallah 15 Comptroller and Auditor General of India CAG is considered the guardian of the public purse and is the head of the Indian Audit and Accounts Department. It upholds the Constitution of India and the laws of Parliament in the field of financial administration. For these reasons, Dr. B. R. A. Ambedkar called the CAG as one of the bulwarks of the democratic system of government in India. Duties and power of CAG. These are laid down by the Parliament in the CAG, Duties, Powers and Conditions of Service, Act, 1971. CAGOD its THEFO low and GG over Met. Accounts. See Constitutional PROV Ish and S for CAG. Central Government expenditure from the Consolidated Fund of India, Contingency Fund of India, and the Public Account of India. State Government and UTs, with a Legislative Assembly, expenditures from the Consolidated Fund of the State, the Contingency Fund of the State, and the Public Account of the State. Central and State Government Departments. All trading, manufacturing, profit and loss accounts, balance sheets, and other subsidiary accounts. Bodies substantially financed from the central or state revenues. Government companies. Article 148. Provisions related to appointment, oath and conditions of service of the CAG. Article 149. CAG shall perform such duties and exercise such powers as may be prescribed by or under law by Parliament. Article 150. It advises the President about the prescription of the form in which the accounts of the Union and the States shall be kept. Article 151. Reports of the CAG relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. Similarly, reports of the CAG relating to the States shall be submitted to the Governor of the State, who shall cause they to be laid before the State Legislature. A CTS as a guide, friend, and PHILO so PHE are of the Public Accounts Committee of the Parliament. CAG and the Public Accounts Committee, a parliamentary standing committee, was created under the JOA Act of 1919. It receives the CAG audit reports both at the center and the state level. CAG assists the PAC in performing multiple roles. e.g. a suggested corrective action by CAG, if not undertaken, is reported to the PAC, which takes it up with the government. Audi. Report on Appropriation AC. CAG Audit Report or EPR-TSX Audit Report on PS use. Finance AC. Difference in role of CAG. In India and Britain. India's CAG is Auditor General, only in name as it only performs an auditing role. The audit is done only after the expenditure is made, i.e. only an ex post facto audit is done. CAG is not a member of the parliament. CAG performs the role of both auditor and comptroller. No money can be withdrawn by the public exchequer without CAG's approval. CAG is a member of the House of Commons. Independence of CAG, security, OF tenure, appointed by the President by warrant under his hand and seal. He has a tenure of 65 years or 6 years, whichever is earlier. Removal by the President under the same procedure as a Supreme Court judge can be removed. Post-retirement office, not eligible for further office under both central or state government. Salary and other service conditions, determined by the Parliament, and the same cannot be altered to the disadvantage of the CAG after his appointment. Expenses. The administrative expenses of the office, salaries, allowances, and pensions are charged upon the CFL, administrative powers, conditions of service of people serving in the Indian Audit and Accounts Department, whose head is the CAG, and the administrative powers of the CAG are prescribed by the President after consultation with the CAG. No minister can represent the CAG in the Parliament, both houses, and no minister can be called upon to take any responsibility for any actions done by him. Limitation of office of CAG appointment. The appointment of CAG is the complete discretion of the executive, which limits its role of holding the executive accountable. The Auditor General and not Comptroller. Its report is post facto, i.e. it can audit expenditures only when they are done. Limited usefulness. Auditors know what is auditing and not administration. It is a highly pedestrian function with a narrow perspective and very limited usefulness. Shorter tenure. The age cap of 65 years affects the proper functioning of the institution. Exceeding mandate. It has been criticized for exceeding the mandate sometimes. For e.g. reports on 2G and coal block allocations had outlandish or sensational figures of losses or corruption. Limited resources, shortage of manpower and increment in responsibility results in very few accounts actually being audited annually. Discourage risk-taking. CAG, while looking into the wisdom, faithfulness, economy of policy, may not consider practical problems of administration. Independence. Conflict of interest arises as former secretaries, usually IS, are appointed as CAG, which compromises the independence of the institution. Secret expenditure. CAG cannot ask for particulars of expenditure in some matters and has to accept a certificate from the competent administrative authority. Intentional obstruction in audits. Delayed supply of crucial documents to the auditors and sometimes even that is denied. No criteria for appointment, either in the Constitution or in any statute, is provided for the appointment of a CAG. Lack of statutory recognition for the officials and staff of the Indian Audit and Accounts Department. The CAG has the constitutional and statutory mandate and responsibility to ensure public accountability, transparency, effective service delivery, and good governance. It recently audited the UN headquarters, which shows the credibility of the institution. Keywords: First Mile, Connect, Delimitation Commission, Bulwarks of the Democratic System of Government, Contingency Fund of India, Philosopher of the Public Accounts Committee, warrant under his hand and seal. Indian Audit and Accounts Department, Wisdom, Faithfulness, Economy of Policy. Previous your question. 1. The Comptroller and Auditor General, CAG, has a very vital role to play. Explain how this is reflected in the method and terms of his appointment as well as the range of powers he can exercise. 2018. 2018. 2. Exercise of CAG's powers in relation to the accounts of the Union and the states is derived from Article 149 of the Indian Constitution. Discuss whether an audit of the government's policy implementation could amount to overstepping its own CAG jurisdiction. 2016-16 NCSC Mixed Composition. Composition. Chairman plus Vice Chairman plus 3 members equals appointed by President. General functions of NCSC and CSD and CBC investigate and monitor all matters concerning constitutional and other legal safeguards for SC, ST, and OBC communities. Inquire into specific complaints WRT the deprivation of rights of the SC, ST, and the OBCs. Participate and advise on the planning aspect WRT socio-economic development and evaluate the progress under the union or state. Send annual reports to the President upon the working of safeguards for the SC, ST, and OBC communities. Recommend measures to the union and the states for the effective implementation of safeguards and measures for the protection, welfare, and socio-economic development of these sections. Online complaints. Complaints of atrocities against SC can now be registered with the NCSC via its online portal. Special courts. A key monitoring activity performed by the Commission relates to the setting up of special courts for the speedy trial of offenses committed under the Civil Rights Act and the Prevention of Atrocities Act, 1989. Collect statistics and comments on the statistics pertaining to cases under the Civil Rights Act of 1955 and the Prevention of Atrocities Act of 1989. Law implementation. These commissions monitor the implementation of the various legal provisions in force for the welfare and protection of the SC, ST, and OBC communities. Specific functions of NCST, conferring ownership rights of minor forest produce, MFP, to STs living in forest areas. Measures for the development of tribals and to work for more viable livelihood strategies. Seek cooperation and involvement of tribals in the protection of forests and undertaking social afforestation. Take measures to ensure full implementation of PASA, safeguard the rights of the tribal communities over different resources like water resources, mineral resources, etc. As per the law. Improve the efficacy of rehabilitation measures taken for the tribals displaced by development projects. Take measures to reduce and ultimately eliminate the practice of shifting cultivation by tribals. Limitations of constitutional bodies to protect vulnerable sections, lack of infrastructure, manpower, and resources. Lack of capacity and insensitiveness of the institutions towards these communities. Commission's recommendations are not binding. Inefficient functioning as the bar for appointment is too high given the backwardness of these communities. Vague selection and appointment process, exorbitant budget. 102nd Constitutional Amendment Act 2018, it added a new Article 338(b), which granted constitutional status to NCBC. It enlarged the functions of NCBC to safeguard the interests of the socially and educationally backward classes more effectively. Positives of granting constitutional status to NCBC concerns that remain. Giving more teeth, constitutional status increases the stature of NCBC as a constitutional body will be better placed to ensure the welfare of BCs. Greater objectivity. Article 342(a) makes it mandatory to take the Parliament's concurrence for adding or deleting any community in the backward list. The misuse of creamy criteria by certain sections will be reduced. Annual report. The Constitution obliges central and state governments to provide valid reasons for not acting on the report of the committee. Grievance redressal. NCBC will have an exclusive function with all power of civil courts, enabling it to ensure justice for backward classes. Wider responsibility. NCBC with an additional scope can look beyond reservation to ensure holistic development and advancement. Non-binding recommendation. This may lead to reduced priority towards the report of NCBC and its budget allocations. No power to define. NCBC has no authority to define backwardness. Hence, it cannot address the demands of various castes to be included as BCs. Composition. No exclusive provision for the appointment of experts in the body and leaves it to the discretion of the executive without any mention of qualification. Revision of BC list. Article 338(b)(5) is silent on the periodic revision of the BC list and the role played by NCBC. Multidimensional challenges. Mere constitutional status can't solve diverse issues like skewed representation and cornering of benefits by few BC castes, etc. No link with Art 340. Article 340 ensures the welfare and protection of BCs have not been linked with Article 338(b). Steps need to be taken. Composition compulsorily includes experts and females to ensure gender sensitivity. Capacity building and sensitization of layers, judges, and policemen to ensure proper and empathetic treatment and timely grievance redressal of backward class members. Effective implementation of existing government policies and evaluation of their impact for timely course correction. Ease to register a complaint. Take steps like registering a complaint via an online portal as done by NCSC. Holding regional level meet. The NCBC shall hold regional level meets to increase accessibility to the Commission. Just like NCSC. Timely discussion. The importance of the annual report is generally overlooked. The President should be empowered to fix a period for the discussion of the report in Parliament. Issues faced by communities. Increased atrocities. 60% out of 16,000 complaints received by NCSC were related to atrocities in public places. NCRB data. E.g. caste-related honor killings in Haryana. Tribal eviction. NCSTs have been ineffective in stopping the eviction of STs due to development projects. E.g. rejection of more than 5 lakh tribals claim. Economic deprivation. Visible by the failure to uphold the spirit of FRA 2006 in depriving access to minor forest produce in the name of protected forests. Vanishing cultural identity. As many as 250 tribal languages have disappeared. Report by People's Linguistic Survey of India. NCSC, NCST, and NCBC are critical for the rights of the weaker section of society and tools for their upliftment. They possess great responsibility, and to perform these needs to be strengthened further. Keywords: socially and educationally backward classes, creamy layer, atrocities, protected forests, subcategories SCs, UPSC and SPSC. Constitutional provisions. Article 312, the Parliament can create one or more All India services, including an All India Judicial Services. Common to the Union and the States. Article 315 to 323. Provisions relating to appointment, composition, removal, and powers and functions of the UPSC and the SPSC. Constitution of Public Service Commission for the Union and the States and provisions related to composition, appointment, and removal and powers and functions. UPSC Viz A, Viz SPSC. UPSC SPSC. Composition consists of a chairman and other members appointed by the President of India. Strength, discretion of the President. Usually 9 to 11. No qualifications are prescribed for membership except 50% of members should have held office for at least 10 years under the government of India or the state government. Term, 6 years 65 years of age. Whichever earlier reached. Removal, by President on the ground of adjudging an insolvent, paid employment outside the duties, unfit due to infirmity of mind or body. For misbehavior, by the President on the inquiry of the Supreme Court. Composition, consists of a chairman and other members appointed by the Governor of State. Strength, discretion of the Governor of the respective state. No qualifications are prescribed for membership except 50% of members should have held office for at least 10 years under the government of India or the state government. Term, 6 years 62 years of age. Whichever is reached earlier. Removal, President can remove the members and chairman on the same grounds and in the same manner as he can remove a chairman or a member of the UPSC. Independence of commission conditions of service, determined by the President, by the Governor for SPSC, and cannot be varied to the disadvantage of the members after their appointment. Expenses, salaries, allowances, and pensions are charged by the Consolidated Fund of India and are not subject to the vote of Parliament. Security of tenure. Chairman and members can be removed by orders of the President only on the grounds specified in the Constitution. Post-retirement. The chairman of UPSC is not eligible for further employment with the Union or the state government in any capacity. SPSC chairman can be appointed chairman member of UPSC or member of UPSC, but not eligible for any other employment. Member of UPSC, other than the chairman, is eligible to be appointed as chairman of any SPSC or UPSC. A member of an SPSC is eligible to be appointed as chairman of an SPSC or UPSC, or member of a UPSC. Functions and limitations. Functions of UPSC limitations. Watchdog of merit system. It conducts examinations for appointments to the All India Services and the Central Services. Supreme Court judgments, since they have the force of the law, can limit UPSC or SPSC. Assists the states in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. Serves needs of a state, on governor's request and with the President's approval. Consulted for the following matters of personnel management, methods of recruitment, promotion, and transfer to civil service and for civil posts. All disciplinary matters affecting a person serving under the government of India in a civil capacity. Reimbursement claims of legal expenses incurred by a civil servant in defending legal proceedings instituted against him in respect of acts done in the execution of his duties. Temporary appointments exceeding 1 year and unregularization of appointments. To grant an extension of service and reemployment of certain retired civil servants. SPSC is consulted by the governor while framing rules for appointment to judicial service of the state, other than the posts of district judges. Non-binding provisions. The government can act without consultation with UPSC, and the aggrieved public servant has no remedy in court. Selection by the UPSC does not confer any right to the post upon the candidate. The name recommended is only a recommendation. UPSC is not consulted on the following matters. Making reservations for any backward class in appointments. Consider the claims of SC/ST in making appointments to services and posts. For selections for chairmanship or membership of commissions or tribunals, posts of the highest diplomatic nature, in the bulk of Group C and Group D services. For a temporary appointment, if a person isn't likely to hold the post for more than a year. Classification of services, pay and service conditions, cadre management, training, etc. So far the SPSC and UPSC have performed their duties with remarkable integrity and are rewarded with the faith of millions of aspirants each year. But as per changing times, the UPSC and SPSCs need to incorporate new ways like psychometric tests to ensure people with the highest integrity are appointed. Keywords: All India Services, infirmity of mind or body, Consolidated Fund of India, Watchdog of Merit System, Cadre Management. Mains Marks Booster Series. Art of Answer Writing Booklet. Art of Essay Writing Booklet 18 Election Commission of India. Introduction. The Election Commission of India, ECI, is a permanent and independent constitutional body established under Article 324 of the Constitution. The ECI is provided with the power of superintendence, direction, and control of elections to the Lok Sabha, Rajya Sabha, state legislative assemblies, state legislative councils, and the offices of the President and Vice President of the country. It is not concerned with the elections of panchayats and municipalities in the states. For that, the Constitution of India provides for a separate state election commission. Appointment process of ECI under question. Election Commission. The need for evolution in the appointment process and bolstering its autonomy. Background of the judgment. In 2015, a public interest litigation filed by Anu Baranwal challenged the constitutional validity of the practice of the center appointing members of the Election Commission. The crux of the challenge is that since there is no law made by Parliament on this issue, the court must step in to fill the constitutional vacuum. Supreme Court, SC, on the appointment of ECs. Judgment, a 5-judge bench of the Supreme Court in March 2023, unanimously ruled that the members of ECI should be elected by a high-power committee consisting of the Prime Minister, Leader of Opposition in Lok Sabha, and the Chief Justice of India. The Chief Election Commissioner and other election commissioners, appointment, conditions of service and term of office, Act, 2023, it replaces the Election Commission. Conditions of service of election commissioners and transaction of business, Act, 1991. Novel features of the Act. The members will be appointed by the President upon the recommendation of this election committee comprising the Prime Minister, Cabinet Minister, and Leader of Opposition in Lok Sabha, or Leader of the single largest opposition party. A search committee headed by the Cabinet Secretary will suggest 5 names to the selection committee. The selection committee may consider names other than those suggested as well. Eligibility criteria. The CEC and ECs must I. Be persons of integrity, 2. Have knowledge and experience in the management and conduct of elections, and 3. Be, or have been secretary, or equivalent, to the government. Salary and pension. It will be equivalent to that of the Cabinet Secretary. Key issues and challenges with the Act. Selection criteria. It may be dominated by the executive, which has implications for its independence. Selection committees' recommendations to be valid in spite of vacancy or defect in the Constitution. It may effectively lead to a monopoly of government members in selecting candidates, particularly when Lok Sabha is dissolved. Reduced status. Making the CEC and EC salary equivalent to the Cabinet Secretary may lead to government influence as it is fixed by the government. Further, CECs and ECs also perform quasi-judicial functions, and limiting these posts senior bureaucrats may exclude other suitable candidates. Powers and functions. Administrative. Delimitation. Determine the territorial constituencies throughout the country based on the Delimitation Commission Act of Parliament. Electoral rolls. Prepare and periodically revise the electoral rolls of all eligible voters. Conduct OF elections. Notify the dates and schedules of elections and scrutinize nomination papers. Settle down election disputes. Free and fair conduct of election. Scrutiny of nomination papers. Delimitation of constituency. Preparation of voters' list. Declare election devise code results of conduct. Recognition of notify schedule political party of election. Function of ECIO registration. Registration of political parties and granting them national or state party status and allotting election symbols to them. O code of conduct. To be observed by the parties and candidates at the time of elections. Advisory. Advise the President and Governor on matters relating to the disqualifications of the members of Parliament and state legislature respectively. Quasi-judicial. Act as a court for settling disputes related to granting of recognition to political parties and allotment of election symbols to them. Independence, security. Often your Chief Election Commissioner can be removed from his office except in the same manner and on the same grounds as a judge of the Supreme Court. Other election commissioners cannot be removed except on the recommendation of the Chief Election Commissioner. Condition of service. The service conditions of the Chief Election Commissioner cannot be varied to his disadvantage after his appointment. Concerns with election commissioners. Lack of fixed tenure. The absence of a specified term may lead to concerns about political interference and instability. Potential for post-retirement appointments. Retiring election commissioners being appointed to other government positions raises concerns about conflicts of interest and impartiality. Accountability and transparency. Concerns exist regarding the transparency and accountability of election commissioners' decision-making processes. Conflict of interest. Perceived or potential conflicts of interest among election commissioners can undermine public trust in their neutrality. Lack of prescribed qualifications. The absence of specific qualifications raises questions about the expertise and experience required for the role. Inadequate enforcement powers. Discussions highlight the need for enhanced enforcement powers to effectively implement directives and tackle electoral malpractices. Steps to address issues in appointment. Second arcade. Establish a collegium headed by the Prime Minister, comprising the Speaker of the Lok Sabha, Leader of the Opposition, Law Minister, and Deputy Chairman of the Rajya Sabha, for transparent appointment of Chief Election Commissioner and election commissioners. Supreme Court. Fill the legal vacuum to ensure a fair and transparent selection process for election commissioners. Constitutional protection. Amend the Constitution to provide constitutional protection to all 3 members of the Election Commission, rather than just one, ensuring their independence and security. Fair elevation. Introduce provisions in the law where the senior-most election commissioner automatically becomes the Chief Election Commissioner, safeguarding the appointment from executive interference. Issues faced by Election Commission: allegation of partisan role, actions raising concerns over impartiality, such as giving clean chits for Model Code of Conduct, MCC, violations by high-profile individuals. Lack of power. Despite being vested with absolute powers under Article 324, the ECI lacks authority in areas like registering political parties and exercising contempt powers. Lack of proactive use of authority. Limited power to take action against politicians seeking votes based on caste or religion, hindering effective enforcement. Politicization. The absence of post-retirement employment restrictions for election commissioners poses obstacles to independent functioning. Non-transparency. Lack of transparency in the selection process for the Chief Election Commissioner and commissioners, influenced by the ruling government. Criminalization of politics. Inability to effectively address the increased use of money and involvement of criminal elements in politics. Other challenges with the ECI. Use of EVM and WBT, an issue of transparency. Use of these technologies has become a matter of concern regarding trust in the Election Commission of India, ECI. Although, time and again the ECI has addressed it, it needs to make an error and doubt-free process by conducting regular checks and trials. Challenges in ensuring inter-party democracy. Section 29A of the RPA Act requires political parties to submit documents on organizational structure, office bearers and their appointment, terms and powers and duties of office bearers, organizational elections, etc. However, due to lack of express provision for enforcing internal democratic functioning of political parties and lack of power to deregister parties, the issue of criminalization of politics, money, and muscle power arises. Lack of parity in the removal of ECs and CEC. Only the CEC enjoys the same status of the removal process as that of judges of the Supreme Court, SC. The ECs can be removed on the CEC's recommendation. There is a good case for extending the same tenure security to the ECs too. Way forward. Enhance independence and impartiality. Ensure transparent and impartial selection processes for election commissioners, reducing government influence. Strengthen powers. Grant the ECI additional authority, including deregistration powers and proactive action against violations of the Model Code of Conduct. Proactive enforcement. Empower the ECI to take proactive action against caste and religion-based campaigning. Inter-party democracy and financial regulation. Promote reforms to enforce transparency and accountability within political parties. Post-retirement employment restrictions. Implement restrictions on post-retirement employment to prevent conflicts of interest. EVM security and trust building. Improve EVM security measures and engage stakeholders to build trust. Keywords: dispute resolution, legal complexities, independence and impartiality, inter-party democracy, quasi-judicial, voter awareness, political interference. Political parties and the Election Commission of India. The Election Commission of India, ECI, serves as the guardian of democracy and plays a crucial role in regulating political parties in the country. It acts as a watchdog, monitoring party finances, overseeing elections, and taking measures to maintain a level playing field for all political entities. Role of the Election Commission of India in regulating the political parties. Registration and recognition. ECI's authority to register political parties ensures equal compliance with election conduct rules. Allocation of symbols. ECI allows exclusive symbols to recognized parties and provides a list of free symbols for non-recognized parties. Model Code of Conduct. The code prevents the party in power from gaining unfair advantages during elections, coming into force from the announcement of the election date. Ceiling on election expenditure. ECI sets limits on expenditure to prevent undue influence, mandates separate accounts, and non-reporting can lead to disqualification. Financial transparency. Registered parties must submit audited reports under Section 29C of RPA, 1951 to prevent misuse of tax-free donations. Appointments of observers. ECI appoints general and expenditure observers to ensure a free and fair electoral process. Lowering voting age to 18. Introduced EVMs, electors' photo identity, EPIC. Provision of adjournment of polls in case of booth capturing. Press old, F electoral reforms. Post, 20 dash asterisk introduction of NOTA and WPT dash ceiling on individual spending, introduction of electoral bonds are voter awareness programs dash asterisk extension of postal ballots steps required to improve effectiveness. Power to deregister political parties. Granting the ECI the authority to deregister parties under the RPA, 1951 can create a deterrence effect. Transparency in political funding. The effectiveness of instruments like electoral bonds, resulting in skewed donations, necessitates a re-evaluation. Principle of precedence. Ensuring consistent actions by the ECI for similar electoral offenses, irrespective of the party involved. Second arcade recommendation. Establishing a collegium comprising key stakeholders for appointment recommendations of the Chief Election Commissioner and election commissioners. Independence of ECI. Ensuring constitutional security of tenure for all three election commissioners and debarment from post-retirement positions to reduce executive interference in ECI. In India's multi-party democracy, effective regulation of political parties by the Election Commission is essential to ensure fair competition, prevent misuse of concessions, and uphold electoral integrity. Simultaneous elections, One Nation, One Election. A high-level committee, HLC, headed by Ramnath Kovind, former president of India, was constituted in September 2023 to examine the issue of holding simultaneous elections for the Lok Sabha, state legislative assemblies, and local bodies of all states. The HLC has invited responses from political parties, the Law Commission, and other groups on the proposal to hold simultaneous elections. In favor of simultaneous elections, against simultaneous elections. Expenditure. Lack of expenditure caps leads to high spending in elections. Policy paralysis. Frequent application of the Model Code of Conduct disrupting government functions and civic life. Resource savings. Potential benefits of utilizing the same voter and booth for both elections. Social harmony. Escalation of communalism and casteism during election periods. Sustainable development. Focus on short-term reforms due to the frequency of elections. Global experiences. Implementation of simultaneous elections in countries like South Africa and Sweden. Invisible socio-economic costs. Undetermined impact on education, welfare schemes, and resource allocation during election duties. Engagement of security forces. Diversion of armed police forces from other internal security responsibilities. Practical difficulties. Resistance from political parties due to adjustments in assembly terms. Constitutional hurdles. Lack of fixed tenures for Lok Sabha and state assemblies. Anti-federalism. Influence of national issues on state elections and vice versa. Reduces accountability. Frequent elections keep politicians connected with voters. Grassroots economy. Job creation and economic boost during elections. False arguments related to MCC. Misconceptions about restrictions on new schemes. Against multi-party democracy. Blurred distinction between state and national elections. Inconsistent with Westminster democracy and federalism. Impact on the dissolution of governments and political shifts. The disadvantage to regional parties. Dominance of national parties and disadvantage for regional parties. Alternative reforms. Expenditure caps, state funding, shorter poll durations, and enhanced security measures. Recommendations of the report by committee. The Ramnath Kovind Committee has suggested that the President, through a notification issued on the first sitting of the Lok Sabha post-general elections, set an appointed date. This date would mark the beginning of the new electoral cycle. State assemblies that are formed after the appointed date and before the completion of the Lok Sabha's term would conclude before the subsequent general elections. After this, elections to the Lok Sabha and all state assemblies would be held simultaneously. The panel recommended that fresh elections could be held to constitute a new Lok Sabha in the event of a hung House or a no-confidence motion, or any such event, but the tenure of the House will be only for the unexpired, remaining term of the immediately preceding full term of the House. When fresh elections are held for legislative assemblies, then such new assemblies, unless sooner dissolved, shall continue up to the end of the full term of the Lok Sabha. To effect these changes, the panel has recommended amendments to Article 83, Duration of Houses of Parliament, and Article 172, Duration of State Legislatures, of the Constitution. This constitutional amendment will not need ratification by the states, the committee noted in its report. The panel recommended suitable amendments to the Article 324A of the Constitution to allow simultaneous elections in panchayats and municipalities. Article 325 to allow the Election Commission of India, ECI, in consultation with state election authorities, to prepare a common electoral roll and voter ID cards. Both these constitutional amendments would require ratification by the states, the report said. Presently, the ECI is responsible for Lok Sabha and assembly polls, while local body polls for municipalities and panchayats are managed by state election commissions. Way forward. Law Commission's recommendations to address hurdles. Amend the Constitution and RPA, 1951. New Lok Sabha and Assembly to serve the remaining term after midterm elections, and replace no confidence motion with a constructive vote of no confidence. Full House election of PMCM. Provide stability by electing them similar to the Speaker of the Lok Sabha. Dilute anti-defection law. Make exceptions to prevent stalemates in the Assembly during a hung parliament. Two-phase elections. Conduct synchronized elections in 2 phases, aligning with Lok Sabha elections and mid-term intervals. Scheduled by-elections. Conduct all vacant seat elections during a predetermined time period. Election Commission recommendations. For Lok Sabha. No confidence motion should include a confidence motion for a named individual as the future Prime Minister. In case of unavoidable dissolution, the President can administer the country with an appointed Council of Ministers until the next House is constituted, or hold fresh elections for the remaining term. For Legislative Assembly, mandatory simultaneous confidence motion with a no confidence motion to form an alternative government, reducing premature dissolution. Provision for the governor to administer the state with an appointed council of ministers or imposition of president's rule until the term expires if the assembly has to be dissolved prematurely. The debate on simultaneous elections, known as One Nation, One Election, calls for careful consideration and consensus. Balancing advantages like governance efficiency with regional dynamics and democratic principles is crucial. With thoughtful reforms, simultaneous elections could enhance the electoral process and citizen engagement. Keywords: one nation, one election, no confidence motion, anti-defection law, scheduled by-elections, unavoidable dissolution, resource savings, policy paralysis, sustainable development. Demand-associated issues, legal provision. Section 61A of the Representation of the People Act, 1951 empowered the Commission to use voting machines. This amendment was made in 1988. Advantages of EVM: concerns with EVM accuracy. EVMs ensure accurate and error-free vote counting, minimizing the chances of manual counting errors and discrepancies. Efficiency: EVMs expedite the voting process by reducing the time required for casting and counting votes, allowing for quicker declaration of results. Global precedents: Germany, Netherlands, and Ireland have abandoned EVMs and reverted to paper ballots following concerns and legal rulings. ADR suggested, and later withdrew the suggestion, that India should return to the paper ballot system, citing the example of countries like Germany. Transparency: EVMs provide transparency in the election process as they display the total votes cast and individual party-wise vote counts, ensuring the integrity of the electoral system. The integrity of the election: EVMs maintain the secrecy of the voter's choice as the voting is done in a private compartment, preventing any influence or coercion. Cost-effective: EVMs eliminate the need for large quantities of paper ballots, reducing the cost and environmental impact associated with printing and transportation. Deterrent to booth capturing: EVMs make booth capturing and bogus voting more difficult due to their tamper-proof design and the use of technological safeguards. Reduced human error: with EVMs, the chances of human errors, such as invalid or wrongly marked ballot papers, are significantly reduced, ensuring a more accurate electoral process. Lack of secrecy: EVMs may compromise voter secrecy as candidates can determine how each booth voted, enabling the potential misuse of this information. Storage and counting concerns: EVMs are stored in decentralized locations, and experts emphasize the need for secure storage throughout their life cycle to ensure their integrity. Lack of verifiability: critics argue that EVMs lack a paper trail, making it difficult to verify the accuracy of the voting process. Without a physical record, it becomes challenging to conduct a reliable recount or audit. Technological failures: EVMs are electronic devices that are prone to technical malfunctions, such as software glitches or hardware errors. These failures can potentially disrupt the voting process and raise doubts about the integrity of the results. Manipulation during transportation: EVMs are transported from storage locations to polling stations, creating opportunities for tampering or unauthorized access. The security of EVMs during transit has been a subject of concern, especially in regions with political tensions or inadequate logistical arrangements. Initiatives of assisto counter concerns: WPT alongside EVMs. Implementing WPT machines in all polling stations enhances transparency and credibility of the electoral process. Counting of WPT slips: Election Commission of India considers suggestions from political parties and will count WPT slips up to a specified percentage, ensuring further verification. EVM challenge: ECI conducted a challenge where political parties were given an opportunity to demonstrate any tampering with EVMs, showcasing their commitment to addressing concerns. Inclusive participation: EC ensures the active involvement of all political parties in crucial steps like first-level checking, randomization of EVM SWPATs, mock polls, and EVM sealing and storage, promoting transparency throughout the election process. EVM prototype for migrants: the ECI developed a remote electronic voting machine, RVM, for domestic migrants, enabling them to vote without traveling to their home districts, promoting voter participation. Voter education: the ECI conducts voter education programs through the Systematic Voters Education and Electoral Participation SVP to educate voters on EVM usage and the significance of voting, aiming to increase voter participation for a stronger democracy. Various judgments of Supreme Court: in its 2013 ruling in the case of Subramanian Swamy v. Election Commission of India, the court held that a paper trail is an indispensable requirement of free and fair elections. Later, in 2019, while dealing with a plea seeking 50% cross-verification of EVM votes with WPT slips in each assembly constituency, the court favored an increase in the number of polling stations in which WPT verification would be done from 1 per assembly constituency or segment to 5. Recent judgment of Supreme Court on WPT. While refusing a revival of paper ballots, the Supreme Court on April 26, 2024, upheld the electronic voting machine EVM polling system and underscored the need to exercise care and caution when raising questions about the integrity of the electoral process. It also declined the petitioner's demand to direct 100% cross-verification of votes cast on EVMs with the accompanying voter verifiable paper audit trail, WPT, paper slips. Only 5% of EVM WPT counts are currently randomly verified in any assembly constituency. Way forward: procedural change: implement a system where voters receive a printed paper and drop it in the ballot box. Manual counting. Mandate manual verification if the winning margin is less than 10% instead of resorting to court cases. Supreme Court. Increase the VPT verification rate from 1 to 5 random EVMs per constituency. Totalizer machines. Improve voting secrecy by counting votes from multiple polling booths together instead of booth-wise results. Safety demonstration. Organize a hackathon, as done in 2017, to challenge individuals to demonstrate the hacking of EVMs. Human resources. Provide comprehensive training to all ECI staff to handle any issues that may arise with EVMs at polling stations. Conclusion. In democratic systems, the conversion of voters' preferences into a political mandate through free and fair elections is crucial for effective policymaking. Enhancing the accuracy and efficiency of voting procedures strengthens democratic institutions. The Election Commission should actively acknowledge and address concerns raised by different stakeholders, promoting transparency and ensuring the credibility of electronic voting machines (EVMs) in the conduct of impartial and transparent elections. Keywords: human resources, procedural change, inclusive participation, technological failures, cost-effective, deterrent to booth capturing. Nota background. The introduction of the none of the above, Nota, option in India in 2013 came as a result of a Supreme Court judgment in the People's Union for Civil Liberties (PUCL) versus Union of India case. The Supreme Court mandated the use of Nota in direct elections for the Lok Sabha and state assemblies. Since its implementation, Nota has gained significant popularity among Indian voters and has even received more votes than the winning margin in some elections. Significance arguments against. Expression of dissatisfaction. Nota allows voters to express their dissatisfaction by rejecting all the candidates if they find them unsuitable for the position. Encouraging better candidates. Nota acts as a catalyst for political parties to field better candidates who are more capable and have a clean image, as parties aim to avoid losing votes from dissatisfied voters. Increased voter participation. Nota can boost voter participation by providing an option for voters who were previously disinterested or felt compelled to vote for undeserving candidates. Fundamental right. Nota allows people to exercise their freedom of expression and right to liberty by expressing consent or discontent to candidates. Moral pressure. Nota enables voters to voice their dissatisfaction with unsuitable candidates, exerting. Symbolic gesture without electoral impact. Nota is seen as a symbolic gesture without electoral value, as the candidate with the most votes is declared the winner regardless of Nota votes. Limited solution to voter dissatisfaction. Nota fails to address the root cause of voter dissatisfaction, which lies in the lack of good candidates, offering only a rejection option without resolving the problem. Potential for voter apathy. Nota can contribute to voter apathy by allowing voters to abstain from voting if they find no suitable candidates, potentially reducing voter participation and weakening democracy. Vulnerability to misuse. Nota can be manipulated by political parties to influence election results by fielding weak candidates and encouraging supporters to vote for Nota, potentially splitting opposition votes. Moral pressure on political parties to field better candidates. Resource wastage. Nota entails additional resources for ballot papers and counting procedures, potentially increasing the cost and time required for elections. The Nota option was introduced in 2013 on the direction of the Supreme Court as a step to empower voters in the expression of their choice. While it has been seen as a symbolic gesture of rejection and as a negative vote, it has been rather a toothless facility than a useful tool to influence the election process. Model Code of Conduct, MCC. Model Code of Conduct, MCC, is a set of guidelines issued by the Election Commission of India, ECI, to regulate the behavior of political parties and candidates during elections. The Model Code of Conduct was first introduced by the Election Commission in the Assembly election in Kerala in 1960. In 1962, the Election Commission introduced the Model Code of Conduct for general elections. The guidelines of the Model Code of Conduct were made stricter by the Election Commission in 1991 after repeated flouting of norms by political parties. Evolution. 1960, the Model Code of Conduct was first observed during the general election to the State Legislative Assembly in Kerala. 1962, the code was taken into national cognizance during the Lok Sabha elections and the State Legislative Assembly elections. 1991, the Election Commission of India, ECI, issued guidelines for the Model Code of Conduct for political parties and candidates. 1993, the ECI issued a revised set of guidelines for the Model Code of Conduct. 2013, the Supreme Court of India directed the ECI to include the option of none of the above (Nota) in the electronic voting machines (EVMs) and ballot papers. 2019, the ECI issued new guidelines for the Model Code of Conduct for political parties and candidates during the Lok Sabha elections. Challenges. Challenges of the digital age. The Model Code of Conduct fails to adequately address the challenges posed by digital platforms, allowing the spread of fake news and hate speech. Limited enforcement power. The Model Code of Conduct lacks legal enforceability, enabling political parties and candidates to violate it without facing significant consequences. Lack of clarity. The Model Code of Conduct lacks clarity on issues like the use of government resources, leading to confusion and inconsistent enforcement. Time-bound effectiveness. The model code of conduct is time-bound, losing its effectiveness once the elections are concluded, allowing for pre- and post-election violations without repercussions. Limited scope. The model code of conduct only covers the conduct of political parties and candidates during elections, overlooking crucial areas like campaign finance regulation. Loopholes. The model code of conduct has several loopholes that political parties and candidates can exploit. For example, the code does not prohibit the use of religion or caste in election campaigns, which can lead to communal and divisive politics. Making model code of conduct legally enforceable. The Standing Committee on Personnel, Public Grievances, Law and Justice recommended making the MCC legally binding and recommended that the MCC be made a part of the RPA 1951. Ensuring accountability. Legal enforceability of the model code of conduct would establish accountability, discouraging unethical practices among political parties and candidates. Strengthening democracy. Making the code legally enforceable would bolster democracy by ensuring fair and transparent elections. Upholding the rule of law. Making the code legally enforceable would uphold the rule of law, preventing the misuse of power by political parties and candidates. Feasibility. ECI has opposed this for the reason that elections must be completed in a short time and judicial proceedings take a longer time. Therefore, it is not feasible to make it enforceable by law. Consistency. Legal enforceability would promote consistent enforcement of the code, eliminating disparities in its application. Clarity. Legal enforceability would bring clarity to what constitutes a violation of the code, facilitating its enforcement. Way forward. Strengthening penalties. The Election Commission of India, ECI, can consider strengthening penalties for violations of the Model Code of Conduct. For example, in the 2019 Lok Sabha elections, the ECI disqualified a candidate for 3 years for violating the code by seeking votes in the name of religion. Improved monitoring. The ECI can improve its monitoring mechanisms to detect violations of the Model Code of Conduct. For example, in the 2019 Lok Sabha elections, the ECI used mobile apps to monitor election campaigns and detect violations of the code. Addressing loopholes. The ECI can address the loopholes in the Model Code of Conduct by updating its provisions to include a ban on the use of religion or caste in election campaigns. For example, in the 2019 Lok Sabha elections, the ECI issued guidelines to political parties to refrain from using the armed forces for political propaganda. Awareness campaigns. The ECI can launch awareness campaigns to educate voters and political parties about the Model Code of Conduct and its provisions. For example, in the 2019 Lok Sabha elections, the ECI launched a voter awareness campaign called SVP to encourage voter participation and promote ethical voting. The Model Code of Code is inherently an obligatory guideline and cannot be used as a wholesome rulebook before a court of law. The warnings by the Election Commission are the general course of action in case of violation of the Model Code of Conduct. However, if violations fall under the Indian Penal Code, 1860, and the Representation of the People Act, 1951, then there are many serious repercussions, and the violator could even go to jail. Keywords: addressing loopholes, rule of law, time-bound effectiveness, digital age, limited enforcement power, symbolic gesture. Election funding. The process by which political parties raise funds for their campaigns and activities, including reaching out to voters, is known as election funding. Concerns have been raised by the Supreme Court about the potential misuse of funds obtained through electoral bonds for purposes such as supporting terrorism or instigating violent protests. Challenges with election funding. Anonymity. Concerns with electoral bonds. The introduction of electoral bonds in 2017 has raised worries about the anonymity of political donations, allowing unlimited anonymous contributions from companies and increasing the risk of illicit funding influencing elections. Opacity in funding sources. According to a report by the Association for Democratic Reforms, ADR, political parties in India receive a high proportion of their income from unknown sources, indicating issues with electoral funding. This lack of transparency makes it difficult to track the flow of money and identify potential sources of corruption. Escalating campaign expenses. Elections in India are costly, requiring political parties and candidates to gather substantial funds for campaigning. This can result in the influence of affluent donors and the adoption of unlawful means to finance political activities. Transparency challenges. The Indian political funding system lacks transparency, making it challenging to hold parties and candidates accountable. Uncertainty surrounds the origins of donations, with many contributions made anonymously. Limited public funding. Although the government provides some funding for election-related expenses, the amount of public funding available is restricted. Consequently, political parties and candidates rely on private donations, potentially leading to the influence of wealthy donors. Electoral bond issue. In a landmark judgment on February 15, 2024, a 5-judge bench of the Supreme Court of India declared the electoral bond scheme unconstitutional. This was a scheme which opened the floodgates of unlimited anonymous funding of political parties and consolidated the role of big money in the Indian political system. Concerns. Advantages. The Supreme Court stated that anonymous electoral bonds violate the right to information in Section 19, L.A. Selective anonymity and confidentiality. The court said that the scheme provides for selective anonymity and selective confidentiality as the details of electoral bonds are available with the State Bank of India, SBI, and can also be accessed by the law enforcement agencies. Right to know source of funding. The court criticized the government's contention that voters do not have the right to know the source of funding of political parties. Need for a new balanced system. The court added that the union government should consider designing a new system that balances proportionality and paves the way for a level playing field. Enhanced transparency. Promotes transparency through engagement with election authorities and the public. Preservation of donor anonymity. Allows confidential donations by individuals and organizations. Accountability assurance. Donations are credited to disclosed party bank accounts, ensuring explanations of fund utilization. Discouragement of cash transactions. Requires payments through designated banks, reducing cash use. Way forward. National Commission to Review the Working of the Constitution, 2001 recommended state funding of elections as an anti-corruption measure if certain transparency conditions are met. State funding of elections implies the use of public funds to support the electoral expenses of political parties and candidates. Chilean experiment. Reserved contributions. Under it, the donors could transfer the money they wish to donate to parties to the Chilean Electoral Service. The Electoral Service would then forward the sum to the party without revealing the donor's identity. State funding of elections. In state funding of elections, parties and candidates receive funds from the public exchequer state budget rather than having to raise money entirely on their own. Need challenges. Lack of transparency in political funding. There are no limits on campaign spending or mandatory disclosures of sources of funds for parties and candidates. Potential for corruption. Private funding can lead to the influence of wealthy individuals, businesses, or interest groups on political decisions. Policy capture. Donors and corporations may influence the policies of the parties they fund. This can lead to cronyism and policy capture. Unequal playing field. Those with access to greater financial resources have a competitive advantage, which can hinder the participation of others, having lesser financial resources. Black money and illicit funding. It can compromise the integrity of the electoral process and erode public trust in the political system. Frivolous spending. In the absence of spending limits, parties indulge in an arms race of expenses on rallies, advertising, etc., which may be wasteful. The burden on taxpayers. Using public funds for political campaigns places an additional burden. Potential misuse of public funds. Without proper oversight and accountability mechanisms, there's a risk that public money could be wasted or used for unintended purposes. Unfair to non-political causes. State funding may divert resources from other essential public services like education, health, and infrastructure that require attention and funding. No guarantee of fairness. Allocation criteria and distribution mechanisms can be manipulated or biased, potentially favoring certain political parties or candidates. Free speech concerns. Restrictions on private funding may limit the ability of individuals and organizations and violate their right to express political preferences. Voter manipulation. Unchecked spending on voter gifts, cash for votes, etc. manipulates electoral outcomes through money power. Criminal nexus. Unaccounted funding facilitates the nexus between criminals, wealthy businessmen, and politicians. Government influence. Parties may become overly dependent on the government for funding, compromising their independence and ability to act as a check on the government. One-size-fits-all approach. Different regions, parties, and candidates may have varying needs, and a one-size-fits-all approach may not address these differences effectively. Committees. Indrajit Gupta Committee on State Funding of Elections, 1998 recommended partial state funding in the form of limited indirect subsidies for candidates and recognized parties. Law Commission Report on Electoral Reforms, 1999 advocated partial state reimbursement of election expenses to recognized parties and candidates to reduce corruption. Second Administrative Reforms Commission Report, 2008 endorsed state funding of elections as part of a package of reforms to tackle corruption and criminalization in politics. National Commission to Review the Working of the Constitution, 2001 recommended state funding of elections as an anti-corruption measure if certain transparency conditions are met. Way forward. Digital transactions. Implementing a complete shift to digital transactions for political donations to enhance transparency and reduce the influence of illicit funding. Limiting anonymous donations, restricting anonymous donations to a maximum of 20% to curb the potential corporate political nexus. Transparency through RTI, bringing political parties under the purview of the Right to Information, RTI, Act, similar to practices in Bhutan and Germany, to ensure transparency in their functioning. National Electoral Fund, establishing a national electoral fund where donors contribute, and funds are distributed among parties based on their performance in the previous elections. State funding of elections, exploring the recommendation from the Second Administrative Reforms Commission, Second Arcade, for state funding of elections, considering the high costs involved. Expenditure cap on political parties, imposing a cap on the expenditure of political parties, calculated as a multiplication of half of the maximum prescribed limit for individual candidates and the total number of candidates fielded. Keywords: expenditure cap, state funding of elections, digital transactions, anonymous donations, policy capture, frivolous spending, criminal nexus, one-size-fits-all approach, unequal playing field. Criminalization of politics. The Supreme Court recently issued guidelines to monitor the speedy disposal of criminal cases, addressing the alarming issue of the criminalization of politics against members of Parliament, MPs, and members of legislative assemblies, MLAs. After the 2019 Lok Sabha elections, 43% of the newly elected MPs had pending criminal cases against them, highlighting the issue of criminalization of politics. The Association for Democratic Reforms, ADR, is an advocacy group focused on electoral reforms. As per media reports of February 2022, the number of pending criminal cases against sitting and former MLAs and MPs had risen to close to 5,000 towards the end of December 2021. Definition: the criminalization of politics refers to the infiltration of individuals with criminal backgrounds into the political arena, involving their participation in elections and subsequent election as members of Parliament, MP, or members of the Legislative Assembly, MLA. Reason for the criminalization of politics: political, legal, and voters-related ECI. Nexus between politicians and bureaucracy. This undesirable and dangerous relationship leads to the infiltration of criminals, lawbreakers, and corrupt individuals into the political system. For example, the 2G spectrum scam, which involved politicians and bureaucrats, was one of the biggest corruption scandals in India's history. Corruption. In every election, political parties put up candidates with a criminal background, and there is an evident link between criminality and the probability of winning. For example, in the 2019 Lok Sabha elections, 43% of the candidates who won had criminal cases against them. Disqualification after conviction. The Representation of the People Act, 1951 disqualifies individuals from being MPs MLAs after conviction, but it doesn't prohibit them from holding positions within the party. Example: a politician convicted of a criminal offense may be disqualified from being an elected representative but can still hold influential party positions or exercise significant control over party affairs. Narrow interest. Despite awareness of candidates' criminal history, voters often prioritize narrow interests like caste or religion when casting their votes. Vote buying. The vulnerability of voters to manipulation and the practice of buying votes undermines the democratic process. Example: instances have been reported where politicians distribute money, gifts, or other incentives to influence voters' choices, compromising the integrity of elections. Trust deficit. Delayed action against ruling party candidates and open flouting of the Model Code of Conduct erode public trust in the ECI. Lack of infrastructure. Example: limited manpower, technological resources, and logistical challenges can make it difficult for the ECI to comprehensively monitor campaign activities and enforce election rules. Limited powers. The ECI lacks the power, under Section 8 of the Representation of the People Act, to disqualify candidates before conviction. Example: ECI may not have the authority to disqualify them from contesting elections until a conviction is secured. Lower conviction rate. The low conviction rate in criminal cases against MPs and MLAs creates a perception of impunity and encourages the entry of individuals with criminal backgrounds into politics. Example: the conviction rate for criminal cases against MPs and MLAs is only 6%, which is significantly lower than the national average conviction rate of 46% under the Indian Penal Code. Consequences of criminalization of politics. Parliament's credibility undermined. Criminal lawmakers weaken the legislative quality and erode public trust in institutions. Corruption breeding ground. The influx of money fosters a tainted democracy dominated by financial and muscle power. Limited voter choice. Criminal candidates restrict options, contradicting free and fair elections. Poor governance impact. Substandard legislation, exclusionary policies, and corruption hinder public service delivery. Judicial faith in question. Political manipulation raises doubts about an impartial judiciary's independence. Disrupting social harmony. Criminal politicians set negative role models, promoting a culture of violence. Steps taken by Supreme Court. Judgment importance. 1997 judgment not to suspend the conviction of a person on appeal if convicted and sentenced to imprisonment under the POCA, 1988. ADR versus UOL, 2002 contesting candidate to disclose pending criminal convictions. Lily Thomas versus UOL, 2013 automatic disqualification of MP and MLA upon conviction to 2 years jail. Term. People's Union for Civil Liberties versus UOL case, 2014 right to negative vote, noted to put moral pressure on political parties. Public Interest Foundation versus UOL, 2014. Complete pending trials of MP and MLA cases within 1 year. Mains Prahaar versus UI case, 2018 mandatory disclosure of the source of income of political candidates as well as their dependents and associates. Public Interest Foundation case, 2018. Disclose pending criminal cases against candidates through EC and political parties and publicization of the same through different media. Public Interest Foundation and ORS versus Union of India and ANR. 2020. Mandatory for political parties to publish details of pending criminal cases against candidates and reasons to select them over others. Recent SC judgment on vote for bribe issue. The Supreme Court ruled that lawmakers cannot claim immunity from prosecution in bribery cases. The court explained that the legal protection provided to MPs and MLAs under Articles 105 and 194 of the Constitution does not shield them in cases of accepting bribes for votes or speeches in the House. With this verdict, the Supreme Court overruled the 1998 P.V. Narasimha ruling, which held that MPs and MLAs who take bribes for voting and asking questions in the House enjoy immunity as per the Constitution. Steps taken by the Election Commission, 1997. Returning officers to reject the nomination of candidates who stand convicted on the day of filing nomination papers even if their sentence is suspended. Flying squads to seize black money during elections. Candidates are to furnish an affidavit containing information about criminal antecedents, their assets, liabilities, and educational qualification. Voter awareness campaigns use tools like SVP and using celebrities to spread a message to not sell their vote. Way forward. Strengthening of legal framework. Candidates against whom charges have been framed in court for serious offenses should be disallowed from participating in elections by making an amendment to the RPA, 1951. The 244th Law Commission recommends disqualification at the stage of framing of charges, accompanied by other legal safeguards. Internal democracy in political parties. Convicted politicians may continue to influence lawmaking by controlling the party and fielding proxy candidates in the legislature. Although the RPA 1951 disqualifies a sitting legislator or a candidate on certain grounds, there is no regulation over the appointments to offices within the party. State funding. Implementation of state funding of elections, as recommended by Dinesh Goswami in the Inderjeet Committee. Right to recall, granting voters the power to recall non-performing elected representatives. Bar on contesting. Barring individuals charged with offenses punishable by more than 5 years from contesting elections. Timely trials and disqualification, complete trials within 1 year, and automatic disqualification after 1 year. Law Commission. Amendments to the following sections of RPA, 1951. Disqualification ground. Section 125A. Conviction as a ground for disqualification under Section 8. 1. False affidavits. Section 125A. Minimum 2 years sentence for filing false affidavits. Corrupt practice. Section 123. Include filing false affidavits as a corrupt practice. Keywords. Law Commission. Limited voter choice, disrupting social harmony, credibility undermined, narrow interest, vote buying. Internal party democracy. Intra-party democracy in Indian political parties is essential for fostering internal accountability, inclusive decision-making, and the overall health of the democratic process within political organizations. Internal party democracy means to uphold the decision of the majority of the party members, in accordance with their respective constitution. The lack of democratic functioning of the parties is mainly manifested in two fundamental aspects: not open and inclusive procedure. The procedure for determining the leadership and composition of the parties is not completely open and inclusive. This adversely impacts the constitutional right of all citizens to equal political opportunity to participate in politics and contest elections. Centralized mode of functioning. The centralized mode of functioning of the political parties and the stringent anti-defection law of 1985 deters party legislators from voting in the national and state legislatures according to their individual preferences. Politics Off Freebie. A webinar titled Freebies Culture and Its Impact on Indian Politics and Democracy was organized by the Association for Democratic Reforms, ADR, in view of a public interest litigation, PL. Challenging freebies. Freebies. The Reserve Bank of India, RBI, in a bulletin in June 2022 defined freebies as a public welfare measure that is provided free of charge. It includes provisions like free electricity, water, public transportation, the waiver of outstanding utility bills, and farm yoan waivers. Concerns associated with excessive use of freebies. Heavy tax burden on states. Many states are burdened with substantial debts, limiting their capacity to invest in more significant welfare programs. Punjab's electricity subsidy constitutes over 16% of its total revenues. Against constitutional principles, making promises when the states lack money to guarantee fundamental rights and implement directive principles is against constitutional principles. Shrinkage of fiscal space. The subsidy burden needs to be funded through debt, which will result in mounting deficits. It will lead to breach of fiscal responsibility and budget management, FRBM, rules, and the states ending up in a debt trap. Violation of the principle of a level playing field. Freebies gives the political parties undue advantage by making promises to provide private goods for only a section of voters. For instance, promising cycles for girl students or laptops for college students, or grinders for housewives, etc. Social impact. Despite receiving more resources, the RBI's study reveals a decline in social sector spending by states, particularly in vital areas like health and education. Environmental concerns. States offer free electricity to farmers, leading to overuse of groundwater and the continuation of traditional crop patterns. In Punjab and Haryana, the groundwater extraction stands at 161% and 134% against the national average of 61% due to highly subsidized electricity. Challenges in curtailing freebie culture. Lack of regulatory powers with ECI. The Election Commission of India, ECI, has stated that it lacks the authority to regulate or penalize political parties for making electoral promises. According to the ECI, the offering or distribution of freebies, either before or after an election, falls under the jurisdiction of the respective party. No assessment of financial viability of populist policies. Political parties often fail to clarify the funding sources for the promises made in the form of freebies. Lack of information to the voters. They don't delve into the financial aspects of freebies, prompting political parties to compete for promising freebies. Supreme Court response on freebies. The Supreme Court bench in a recent judgment proposed the constitution of an apex body to address the issue of freebies and poll promises. It will comprise several stakeholders like the Niti Aayog, Law Commission, Finance Commission, Reserve Bank of India, and members of ruling party and opposition parties. The reference is a shift from the court's own stand in the S. Subramaniam Balaji versus Tamil Nadu judgment of 2013. S. Subramaniam Balaji versus Tamil Nadu judgment of 2013. The court had held that making promises in election manifestos does not amount to a corrupt practice under Section 123 of the Representation of People (RPA) Act, 1951. Way forward. Responsibility of voters. Voters need to be vigilant and inquire about the financial implications of the populist policies. Empowering the ECI with greater authority. Statutory provisions as a backup or warnings on the use of funds are needed. Model Manifesto. ECI could bring in certain measures under the MCC to introduce a responsible way of making promises to the public. Voters need to decide whether an election campaign is credible and whether the promises and the freebies are in their interest. Fixing limit awful fare schemes. Fixing spending of 1% of GSDP or 1% of state-owned tax collections or state revenue expenditure would help to implement welfare schemes properly. Tracking social sector budgetary allocations, prioritizing higher resource allocation to welfare schemes is needed. India's spending on health and education, at 4.7%, lags behind that of other developing countries, such as sub-Saharan Africa, which spends 7%. Pranab Sen, economist and former chief statistician of India, says the financial landscape of some states would have been more damaging had political parties implemented every promise they had made when they came to power. The actual impact of freebies on the Indian economy is still limited because some promises remain unfulfilled. The legacy subsidies are the real problem. At times, voters don't mind if a promise is not fully implemented. But once a freebie is given, no political party will dare to withdraw it, fearing a backlash. Economics Times. AI and elections. Artificial intelligence, AI, refers to the simulation of human intelligence in machines that are programmed to think like humans and mimic their actions. It includes technologies like machine learning, pattern recognition, big data, self-algorithms, etc. Significant potential of in elections, increased and effective voter engagement. By spreading awareness through social platforms and education campaigns, AI can help the voters to understand the issues and candidates, which can consequently result in increased engagement and inform voters more effectively. Promoting inclusiveness. With the help of AI-based apps like Bashini, the information can be made available in multiple Indian languages. This will be helpful for the deprived sections of the society. AI technologies can help voters with disabilities, such as those who are visually impaired, making the voting process more accessible and inclusive. Election transparency and security. AI can help in the implementation of transparent advertising policies, rolling out content labels, and restricting election-related queries to combat misinformation. The AI-based chatbot can be introduced on the Election Commission website to address the grievances. AI tools will monitor polling processes, analyze data, and ensure election integrity through machine learning algorithms and preventive measures. Strengthen democracy. The ECI is also making optimum use of the technology with options like online voter registration and releasing the voters list on the website. They can use AI and social media to create awareness and broader reach and address grievances. Challenges associated with the use of AI in elections. Misinformation and disinformation. Deepfakes and other AI-generated content can create hyperrealistic digital falsification and can potentially be used to damage reputations, fabricate evidence, and undermine trust in democratic institutions. Social media amplification. Social media companies such as Facebook and Twitter compound the influence and misinformation risks, which significantly cut their fact-checking and election integrity teams. Micro-targeting. Through micro-targeting techniques, AI algorithms can be used to manipulate voter preferences and undermine the fairness of elections by influencing voters. Privacy concerns. The main privacy concerns surrounding AI is the potential for data breaches and unauthorized access to personal information. With so much data being collected and processed, there is a risk that it could fall into the wrong hands, either through hacking or other security breaches. Erosion of trust. The mere existence of AI-generated content can foster a general atmosphere of distrust, where people question the authenticity of all information. This phenomenon is known as the liar's dividend. No specific law. India lacks specific laws to address deepfakes and AI-related crimes, but provisions under many legislations could offer civil and criminal relief. Example. Section 66E of the Information Technology Act, 2000, IT Act, is applicable in cases of deepfake crimes that involve the capture, publication, or transmission of a person's images in mass media, thereby violating their privacy. Such an offense is punishable with up to 3 years of imprisonment or a fine of ₹2 lakh. Actions taken by India, issuance of advisory to digital platforms. The Indian government has asked digital platforms to provide technical and business process solutions to prevent and weed out misinformation that can harm society and democracy. The government said a legal framework against deepfakes and disinformation will be finalized after the elections. The government also said companies should not generate illegal responses under Indian laws or threaten the integrity of the electoral process. Google ECI Partnership. Google has partnered with the Election Commission of India, ECI, to prevent the spread of false information during the general elections. Google is committed to providing reliable information and preventing deceptive AI-generated content. Way forward, regulation framework. There is a need to establish a precise legal framework mechanism for the use of AI in elections, such as regulations on data protection, transparency and AI-driven advertising, and standards for the ethical use of AI collaboration. Governments and electoral bodies must collaborate with technology companies to combat misinformation and secure electoral processes. Public awareness. Educating the public about the challenges of AI-generated misinformation can empower voters to evaluate the information critically. Technological solutions. The time has come to develop AI systems capable of detecting and flagging false information and deepfakes. Conclusion: this is an era where technological evolution is inevitable. Maintaining democratic principles whilst utilizing technology for advancement calls for significant thought and constant ethical examination. The proper integration of social media and AI will influence political discourse and decision-making for years to come as Bharat moves towards the Amrit call of its democracy. Electoral literacy. Initiatives by ECI and Electoral Literacy Club is a platform to engage school students through interesting activities and hands-on experience to sensitize them on their electoral rights and familiarize them with the electoral process of registration and voting. ELCs are also present in colleges and rural communities. At ELCs, learning is fun. Activities and games are designed to stimulate and motivate students, provoking them to think and ask questions. Through ELC, Election Commission of India aims at strengthening the culture of electoral participation among young and future voters. Systematic Voters Education and Electoral Participation (SVP) program are undertaken to educate the electors regarding procedure relating to registration of name and electoral roll, corrected their existing particulars in electoral roll, and deletion of name of shifted and deceased family members. Encore. The Election Commission of India, ECI, has unveiled Encore, Enabling Communications on Real-Time Environment, a software solution designed to enhance the management of candidates in election proceedings. This innovative digital platform simplifies the nomination process by allowing candidates to complete forms online, which can then be printed and submitted offline along with required documentation. Candidates are provided the opportunity to register accounts on the ECI's online portal, granting access to nomination forms, the ability to submit security deposits, and the option to arrange appointments with the returning officer. Encore facilitates the seamless processing of candidate nominations and the authentication of affidavits, empowering returning officers to efficiently manage nomination submissions and affidavit verification. Keywords: erosion of trust, freebies, Encore, internal party democracy, dynastic politics, criminalization of politics, MCC, second arcade, misinformation, micro-targeting, systematic voters education and electoral participation, SVP, misinformation and disinformation. Previous year questions. 1. In the light of recent controversy regarding the use of electronic voting machines (EVM), what are the challenges before the Election Commission of India to ensure the trustworthiness of elections in India? 2018. 2. Simultaneous election to the Lok Sabha and the state assemblies will limit the amount of time and money spent in electioneering, but it will reduce the government's accountability to the people. Discuss. 2017. 3. To enhance the quality of democracy in India, the Election Commission of India has proposed electoral reforms in 2016. What are the suggested reforms and how far are they significant to make democracy successful? 2016-19 Delimitation Commission background. The Delimitation Commission in India is a statutory body responsible for determining the boundaries of various constituencies in the country for the purpose of elections. Constitutional provisions. Article 81. Every state and UT would be allotted seats in the Lok Sabha in such a manner that the ratio of population to seats should be as equal as possible across states. Article 82. Delimitation of parliamentary constituencies after every census by Delimitation Commission established by the GOL under Delimitation Commission Act. Article 170. States get divided into territorial constituencies as per Delimitation Act after every census. 84th Constitutional Amendment Act. Freezing of delimitation till 2026. Reasons. Family planning and population stabilization objective. Implications. Violation of Article 81 due to unequal representation across constituencies. Delimitation Commission appointment. The Delimitation Commission in India is appointed by the President and works in collaboration with the Election Commission of India, ECI. Composition: it comprises a retired Supreme Court judge, the Chief Election Commissioner, and the respective state election commissioners. Authority: it is a high-powered body with its orders having the force of law and cannot be challenged in court. Reporting: the Commission's orders are presented before the Lok Sabha and state legislative assemblies, but modifications are not permitted. Functions of the Delimitation Commission: boundary determination, determines the boundaries and number of constituencies, ensuring population equality among them. Seat allocation for SC/ST, decides on the allocation of seats for scheduled castes, SC, and scheduled tribes, ST, in areas with significant SC/ST populations, as per Articles 330 and 332. Readjusting the representation of territorial constituencies, readjust the representation of territorial constituencies in the Lok Sabha, House of People, and legislative assemblies based on the latest population census statistics. Recommendations and public participation, publishes draft recommendations in the Gazette of India, state gazettes, and regional media. Conducts public hearings to consider public opinions, incorporating modifications as necessary. Majority decision, adopts the majority decision in case of dissent among commission members. 84th Constitutional Amendment Act, 2002, delimitation freeze. The 84th Amendment froze the delimitation of Lok Sabha and state assembly seats until the first census after 2026. Objective and reasons. O for population stabilization, keeping in view the progress of family planning programs in different parts of the country, the government, as part of the National Population Policy Strategy, decided to extend the freeze on undertaking fresh delimitation up to the year 2026 as a motivational measure to enable the state government to pursue the agenda for population stabilization. International practices. In a federation like the U.S., the number of seats in the House of Representatives, the equivalent of our Lok Sabha, has been capped at 435 since 1913. The seats among the states are redistributed after every census through the method of equal proportion. This does not result in any significant gain or loss for any of the states. In the European Union (EU) Parliament, which consists of 720 members, the number of seats is divided between 27 member countries based on the principle of digressive proportionality. Under this principle, the ratio of population to the number of seats shall increase as the population increases. Significance of Delimitation Commission challenges. Supreme authority. The Delimitation Commission's decisions and instructions are final and unchallengeable by law or the courts. Responsible for equitable representation, the Commission sets constituency boundaries and numbers to ensure nearly equal population distribution. This ensures fair representation. It upholds the principle of one vote, one value. Fair regional distribution. It ensures fair regional distribution to prevent one political party from outperforming others in an election. Identifying reserved seats. The Delimitation Commission identifies seats that are reserved for scheduled castes, SC, and scheduled tribes, ST, in areas where these communities have a significant population. This ensures their adequate political representation. Southern states concerns. The southern states, with successful population control measures and higher per capita revenue generation, feared losing meaningful political representation compared to the northern states. Disenfranchisement and economic contributions. Delimitation based solely on population would have politically disenfranchised economically developed southern states, while the central government continued to benefit from their economic contributions. Amendments and postponement. To address these concerns, the Constitution was amended during the emergency rule in 1976, suspending delimitation until 2001. Subsequently, another amendment further postponed it until 2026, with the hope of achieving a uniform population growth rate by then. Criticism of Delimitation Commission population control bias, states promoting family planning risk having their seats reduced, while states with less emphasis on population control may gain more seats. Outdated seat allocation. Delimitation done in 2008 was based on the 2001 census, but the total number of seats remained unchanged since 1971, leading to a disparity between population growth and representation. Constitutional seat limits. Because there are fewer seats available, 550 for the Lok Sabha and 250 for the Rajya Sabha, fewer representatives can effectively represent larger populations. Unequal representation. Fixed seat allocation and population growth lead to unequal representation, impacting the voice and influence of growing populations. Keywords: unequal representation, population control bias, fair regional distribution, disenfranchisement, and economic contributions, responsible for equitable representation. 20 Attorney General of India Introduction. The Attorney General of India, AGI, is the highest legal officer and chief legal advisor to the Government of India. Appointed by the President of India, the Attorney General represents the government in legal matters, provides legal advice, and represents the government in the Supreme Court of India. About AGI. Duties: advising the government. The AG provides legal advice to the Government of India on matters referred to them by the President. They offer their expertise and guidance on various legal issues. Performing assigned legal duties. The AG performs other legal duties assigned to them by the President. These duties may vary and can include providing legal opinions, drafting legal documents, and representing the government in legal matters. Discharging constitutional and legal functions. The AG carries out functions conferred upon them by the Constitution or any other law. This involves upholding and safeguarding the legal framework of the country. Representation in presidential references. The AG represents the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. This refers to cases where the President seeks the Supreme Court's opinion on certain constitutional or legal matters. Representation in the Supreme Court. The AG represents the Government of India in all cases before the Supreme Court where the government is a party. They present arguments and advocate on behalf of the government's position. Representation in high courts. When required by the Government of India, the AG appears in high courts to represent the government in cases where the government is involved. Limitations: not to advise or hold a brief against the Government of India. Not to advise or hold a brief in cases in which he is called upon to advise or appear for GOL. Not to defend accused persons in criminal prosecutions without the permission of the GOL. Not to accept an appointment as a director in any company without the permission of GOL. Not to advise any ministry, department of GOL, any statutory organization PSU unless the proposal or a reference for this is received through the Department of Legal Affairs. Keywords: legal duties, discharging constitutional and legal functions, grievance redressal, spreading awareness, constitutional safeguards. 21 National and State Human Rights Commission. Introduction. NHRC is a statutory body established in 1993 under the legislation, the Protection of Human Rights Act, 1993. It is the watchdog of human rights in the country. It was established in conformity with the Paris Principles, 1991, adopted for the promotion and protection of human rights. Functions: challenges. Inquire into any violation, negligence of human rights by a public servant, either suo motu or on a petition presented to it or on an order of a court. Intervene in any proceeding involving an allegation of violation of human rights pending before a court. Review the constitutional and other legal safeguards for the protection of human rights and recommend measures for their effective implementation. Study treaties and other international instruments on human rights and make recommendations for their effective implementation. Promote research in the field of human rights and spread human rights literacy among the people. Visit jails and detention places to study the living conditions of inmates. Review the factors inhibiting the enjoyment of human rights, including an act of terrorism, and recommend remedial measures. Encourage the efforts of NGOs working in the field of human rights. Role played by NHRC. It has issued the following guidelines: prison reforms, reporting of custodial death within 48 hours, and the recommendation to public authorities to deal with manual scavenging. Criticized laws like POTA and TATA with the possible scope of misuse for violating human rights. Going beyond physical human right violation to protect the socio-economic rights of people like poverty and starvation in Odisha's Kalahandi. Absence of investigation mechanism. It is dependent on central and concerned state governments for investigation of the human right violation cases. Non-binding orders. NHRC has no power to enforce its decisions. The government often outrightly rejects the recommendation of NHRC. Lack of infrastructure. Despite a 1,450% increase in cases between 1995 to 2005, its strength has been reduced by 16%. This limits cases handled by NHRC. Pendency and delays. It is overburdened with cases that have resulted in more than 10,000 cases pending with it. Staff-related issue. A maximum of its staff is on deputation. Many times investigating officers belong to the accused service, which results in a conflict of interest. The UN-recognized Global Alliance of National Human Rights Institutions, GANRI, deferred the accreditation of National Human Rights Commission, India, NHRC India, citing objections like political interference in appointments, involving the police in probes into human rights violations, poor cooperation with civil society, lack of diversity in staff and leadership, insufficient action to protect marginalized groups, limitations to handle cases, NHRC can investigate complaints registered after 1 year of the incident, the exclusion of armed forces and paramilitary forces from its ambit, NHRC takes cases solely on media reports and not through its on-field work. It cannot challenge the personal laws. Supreme Court impledes NHRC, NCW and Muslim personal law case. Remarks by Soli Sorabji. India's teasing illusion due to its incapacity to render any practical relief to the aggrieved party. Remarks by Supreme Court. It is a toothless tiger. Protection of Human Rights, Amendments, ACT, 2019 composition. Judge of SC can also be appointed as chairman. Increase the number of people with human rights knowledge to 3 with at least 1 woman. Chairpersons of the NCBC, the National Commission for the Protection of Child Rights, and the Chief Commissioner for Persons with Disabilities have been included as ex officio members. Term of office. Reduced office term to 3 years from 5 years. Union territories. Central government can confer functions related to human rights cases of UT on nearby SHRC. Significance. Effective compliance with the Paris principles, i.e. autonomy, independence, and pluralism to effectively protect and promote human rights. Facilitated increased representations to civil society. Increased accessibility to human rights courts to citizens of Union territories. A reduced age limit will ensure the timely filing of vacancies. Recent news. Recently, the National Human Rights Commission, NHRC, has called for an action-taken report from the Odisha government regarding the Balasore train accident. The Subcommittee on Accreditation (SCA) of GANRI is evaluating the NHRC's accreditation status, which will decide if it retains its status for participation in UN human rights bodies. Way forward. Enforceable powers. Decisions of NHRC should be made enforceable. Commission's composition. Greater representation to civil society, human rights activists, etc. instead of ex-bureaucrats. This will ensure the independent functioning of the body. Amati Commission recommendations. Remove one-year ceiling to take cases by NHRC. Also, the term of the armed force shall not include paramilitary forces. Independent staff and dedicated investigating team to ensure timely disposal of cases. Coordination mechanism. Need to establish coordination mechanism between NHRC and SHRC. Diversify the role of NHRC towards new emerging concerns like rights of LGBT, industries and human rights, environmental impact on human rights, etc. Conclusion. NHRC has played a significant role in many cases since its inception. Disposal of more than 15 lakhs cases and more than 100 CR as victim compensation reflect its success. Considering rising cases against vulnerable sections, it is high time to strengthen Commission in all spheres to ensure fundamental rights enshrined in the Indian Constitution are enjoyed by everyone. Keywords. Enforceable powers, coordination mechanism, investigation mechanism, political interference, insufficient action, Global Alliance of National Human Rights Institutions, GANRI. 22 Central and State Information Commission. Introduction. The CIC is a high-powered independent and statutory body to look into the complaints made to it about offices, financial institutions, PSUs, etc. under the central government and the Union territories. Functions. Challenges. Inquiry into complaints and disciplinary action against information officers. Unable to submit information request due to non-appointment of a public information officer. Refused requested information, not received a response to an information request within the specified time limits. Fees charged are unreasonable. Feels that information given is incomplete, misleading, or false. Suamoto power. It can order an inquiry into any matter if there are reasonable grounds. Powers of a civil court while inquiring. Examine any record. All public records must be given to the CIC during inquiry for examination. Secure compliance to its decisions from the public authority. Promote good governance. CIC promotes citizen participation in governance and promotes transparency and accountability in governance. Removal of the fixed term. Instead of the earlier 5 years, now terms of CIC, IC, and 6 will be decided by the central government. Determination of salary by central government instead of the earlier status of equality with Chief Election Commissioner in case of CIC and Election Commissioner in case of ICs. Delayed appointments. As per the RTI, since 2014 CIC was functioning without a Chief Information Commissioner for more than 400 days and has not functioned at full strength for more than 4 years. Pendency. As per the report by Sat Arkneg Rik Sangathan, over 3.2 lakh pleas are pending before 27 information commissions across country. Delayed case disposal. As per the report by Sat Arkneg Rik Sangathan, CIC takes an average of 388 days to dispose of a case from the date that it was filed before the commission. Poor judgments. Government officials in only 2.2% of cases face any punishment for violating the law, despite various analyses showing a rate of about 59% violations. Issues highlighted by Sat Arkneg Rik Sangathan report. Missing during COVID-19 pandemic. 21 out of the total 29 studied ICs were not holding any hearings. Absence of a centralized database of RTI applicants at the central or state level leads to inaccurate annual RTI reports and analysis. No adequate authority. The Act did not give adequate authority to the ICs to enforce their decisions. Inadequate trained PIOs and first appellate authority. This results in breaking the 30 days timeline for providing information, as due to lack of proper training, PIOs are not able to provide the information in a time-bound manner. No punishments. Government officials do not face any penalty for lack of their duty or improper behavior. Conclusion. RTI has been termed as historic legislation in India's democratic history. To give teeth to RTI, we need strong CIC and 6. Hence, all reforms must be taken to ensure transparency and openness in the functioning of government. Keywords. Inadequate trained, good governance, suamoto power, bureaucratization, pendency. 23 Central Vigilance Commission, CVC. The Central Vigilance Commission, CVC, is an apex governmental body in India that is responsible for addressing issues related to corruption and promoting transparency and integrity in public administration. CBC was established in 1964 by an executive resolution on the recommendation of the Santhanam Committee. In 2003, the Parliament conferred a statutory status on the CBC. It is the main agency for preventing corruption in the central government. Independence of CBC. Appointment by the President on the recommendation of a three-member committee, PM plus Home Minister plus the Leader of the Opposition in the Lok Sabha. Removal by President only on the ground mentioned in the statute. Composition: Central Vigilance Commissioner plus maximum 2 Vigilance Commissioners. Fixed tenure: for years 65 years whichever is earlier and ineligible for further employment under the central or state government. Fixed salary, allowances, and service conditions: it is similar to the chairman of UPSC in the case of Chief Vigilance Commissioner, and similar to a member of UPSC in the case of Vigilance Commissioner. Independent staff: CBC has its Secretariat, Chief Technical Examiners Wing, and a wing of commissioners for departmental inquiries. Way forward. Functions challenges: inquiry or investigation against an alleged employee of the central government for an offense under the Prevention of Corruption Act, 1988, POCA. Superintendence over the functioning of CBI and giving directions to CBI related to the investigation of offenses under the POCA. Superintendence over the vigilance administration in the ministries of the central government. Doing preliminary inquiry into complaints referred by LOCPAL in respect of officials of groups A, B, C, and D. Working as competent authority. Competent authority under the Whistleblower Protection Act, 2014 for a person to make a public interest disclosure on corruption. Sensitization of citizens. Steps like Vigilance Week and Integrity Pledge help to generate awareness about the ill effects of corruption. Executive dependence. The appointment of CEC is indirectly under the executive only, hampering its independent functioning. Advisory and non-binding recommendations to ministries and government organizations. Delay in case handling. There is a huge delay in the cases that CVC handles, hence it does not act as an effective deterrent. Duplication of efforts, due to overlapping jurisdiction of CBI, CVC, and LOCPAL. Limitation on CVC, the need of prior consent of ministries for the above joint secretary-level officials, and exemption of private individuals limits its role in addressing the corruption challenge holistically. Pending cases, lack of funds and human resources results in huge pendency of cases. Ensure the independence of the Commission. Timely appointment of CVC and VCS and ensure diversity in Commission composition. Adequate funding. There shall be adequate funds to ensure modern infrastructure for efficient functioning. Adoption of modern technology like AI, big data, and digitization of functioning. Avoid overlapping jurisdictions of various agencies like LOCPAL and CBI by ensuring role clarity. Conclusion. Corruption is the biggest threat to inclusive development, so steps must be taken to strengthen bodies like CVC, CBI, and LOCPAL to ensure POCA is implemented in letter and spirit. Constitutional status for these bodies implies they have a greater role and responsibility in the democratic status of the country, and constitutional protections ensure they are not at the mercy of the government. Keywords: independence, adequate funding, overlapping jurisdictions, sensitization of citizens. 24 Union Executive and State Executive. Introduction. The organ of the government that primarily looks after the function of implementation and administration is called the executive, while the heads of government and their ministers, saddled with the overall responsibility of government policy, are together known as the political executive. Those responsible for day-to-day administration are called the permanent executive. Comparison of Union Executive and State Executive. Union Executive, State Executive. Articles 52 to 78 in Part 5 of the Constitution deal with the Union Executive. Articles 153 to 167 in Part 6 of the Constitution deal with the State Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers, and the Attorney General of India. The State Executive consists of the Governor, the Chief Minister, the Council of Ministers, and the Advocate General of the state. The President is the nominal executive head, whereas the PM is the real executive head. The Governor is the chief executive head of the state. But, like the President, he is a nominal executive head, titular or constitutional head. CM is the real executive head. Executive power of the Union is vested in the President and is exercised by him either directly or through officers subordinate to him in accordance with the Constitution, Article 53. The executive power of the state is vested in the Governor, and it is exercised by him either directly or through officers subordinate to him in accordance with this Constitution, Article 154. The President has to act in accordance with aid and advice of the Council of Ministers headed by the Prime Minister, Article 74. The Governor has to act in accordance with aid and advice of the Council of Ministers headed by the CM, except his discretionary functions, Article 163. The President of India. The President is the head of the Indian state. He is the first citizen of India and is a symbol of solidarity, unity, and integrity of the nation. Impeachment. Reason for impeachment. The president can be removed for violation of the Constitution. Impeachment resolution. It can be initiated by either House of Parliament. These charges should be signed by 1/4 members of the House that framed the charges, and a 14 days notice should be given to the president. 23rd majority of the total membership in the first House, where the process has been initiated after the impeachment resolution is passed by a majority of 2/3 of the total membership of that House. It is sent to the other House, which should investigate the charges. 23rd majority of the total membership in the second House. The president is removed from office as of the date the impeachment resolution is passed if the other House also upholds the allegations and votes in favor of it by a majority of 2/3 of its members. Issues with impeachment. Term. Violation of Constitution is a very vague term and has not been defined anywhere in the Constitution. Elected members of legislative assemblies have no role to play in impeachment proceedings, while they have a role in election of the president. Nominated members of Parliament have the right to vote in case of impeachment, while no voting right in election of president. Procedure and authority to investigate the charges against the president have not been specified, nor any definite time period has been specified. Criticism of the office of the president. USA impeachment. India impeachment. Grounds: treason, bribery, or other high crimes and misdemeanors. Violation of the Constitution. Voting simple majority of the House of Representatives. Special majority in the Senate is required. 23rd of total membership of each House. Houses involved: House of Representatives and Senate Lok Sabha and Rajya Sabha. Initiation. Any member of the House of Representatives can introduce a resolution of impeachment. Impeachment charges can be initiated by either House of Parliament. Examples: 3 USA presidents: Andrew Johnson in 1868, Bill Clinton in 1998, and Donald Trump in 2019, previously were impeached by the House but acquitted by the Senate. Not in India. The president is bound by the aid and advice of the Council of Ministers. Article 352, 356, and 360 of the Constitution confers upon the president the power to declare emergency, and this so-called power to declare or promulgate emergency is one of the widely abused or violated provisions. Misuse of the power to promulgate ordinance. One major issue of the ordinance is that the president generally doesn't exercise legislative discretion. The president only promulgates them. It is the council ministers who in reality decide if the ordinance is essential. This influence of the ministers may at times lead to arbitrariness. The articles of the Constitution don't specify any maximum limit of ordinances which can be passed by the president in a period of time. This lack of specification may lead to the president to pass as many ordinances as he wishes under the circumstances that the parliament is not in session and the necessity of an immediate action is met. The major issue or problem of the ordinances are relating to the repromulgation of the ordinances. The question of whether they should be legal or unconstitutional is a debate which has been going on for quite some time. Krishna Kumar Singh versus State of Bihar, 2017. In this case, the apex court held that the repromulgation of an ordinance is a fraud on the Constitution and also ruled that the satisfaction of the president and governor while issuing an ordinance is subject to judicial review. R.C. Cooper case 1970, Supreme Court in R.C. Cooper versus Union of India, 1970. Held that the president's decision to promulgate ordinance could be challenged on the grounds that immediate action was not required, and the ordinance had been issued primarily to bypass debate and discussion in the legislature. D.C. Wadhwa versus State of Bihar, 1987. The court had held that successive repromulgation of the ordinances having the same texts and without attempting to pass the bills will amount to a violation to the Constitution of India. The Vice President of India. The Vice President occupies the second highest office in the country. This office is modeled on the lines of the American Vice President. Constitutional provisions. Article Subject 63. The Vice President of India. There shall be a Vice President of India. 64. The Vice President to be ex officio Chairman of the Council of States. The Vice President shall be ex officio Chairman of the Council of the States and shall not hold any other office of profit. Powers and functions of Vice President. Ex officio Chairman of Rajya Sabha. He acts as the ex officio Chairman of Rajya Sabha. His role as the Chairman are as presiding officer of the House. As the presiding officer, the Chairman of the Rajya Sabha is the unchallenged guardian of the prestige and dignity of the House. He ensures that the proceedings of the House are conducted in accordance with the relevant constitutional provisions, rules, practices, and conventions, and that decorum is maintained in the House. As the principal spokesman of the House, the Chairman is also the principal spokesman of the House and represents its collective voice to the outside world. Casting a vote by the Chairman. Under the Constitution, the Chairman exercises only a casting vote in the case of equality of votes. Powers and duties of the Chairman, as laid down by the Constitution of India. He is empowered to adjourn the House or to suspend its sitting in the event of absence of quorum. Role in the deliberations of the House. The chairman does not take part in the deliberations of the House except in the discharge of his duties as the presiding officer. However, on a point of order raised or on his own, he may address the House at any time on a matter under consideration with a view to assisting members in their deliberations. Powers conferred on the chairman under the Rules of Procedure of the Rajya Sabha. Various powers are conferred on the chairman under the Rules of Procedure of the Rajya Sabha in connection with the proceedings of the House, committees and such other matters as questions, calling attention, motions, resolutions, amendments to bills, authentication of bills, petitions, papers to be laid on the table, personal explanations, etc. Right of the chairman to interpret the Constitution and rules. It is the right of the chairman to interpret the Constitution and rules so far as matters in or relating to the House are concerned. And no one can enter into any argument or controversy with the chairman over such interpretation. Maintenance of order in the House. Maintenance of order in the House is a fundamental duty of the chairman, and he has been invested with all the necessary disciplinary powers under the rules for the purpose. References by the chairman. It is customary for the chairman to make appropriate references in the House on solemn occasions like anniversary of Universal Declaration of Human Rights by UN, Martyrs' Day, Quit India Day, anniversary of bombing of Hiroshima, Nagasaki, etc. Powers relating to bills passed in Rajya Sabha. The chairman is empowered under the rules to correct patent errors in a bill after it has been passed by the House and to make such other changes in the bill consequential on the amendments accepted by the House. Powers relating to the Rajya Sabha Secretariat and precincts of Rajya Sabha. The Rajya Sabha Secretariat functions under the control and direction of the chairman. Admission to various galleries including Press Gallery is regulated under the direction of the chairman. Duties conferred on the chairman. Some statutes also confer duties on the chairman. For instance, rules made under the Salary, Allowances and Pension of Members of Parliament Act, 1954, do not take effect until they are approved and confirmed by the chairman and the speaker. Acting President. He acts as president when a vacancy occurs in the office of the president due to his resignation, removal, death, or otherwise. He can act as president only for a maximum period of 6 months within which a new president has to be elected. During this period, the vice president has all the powers, immunities, and privileges of the president and receives emoluments and allowances payable to the president. Elections of president and vice president. Comparison of election of president and vice president. Election of president, election of vice president. Electoral college consists only elected members from Lok Sabha plus Rajya Sabha plus legislative assemblies of state plus legislative assemblies of UTs, Delhi and Puducherry only. Electoral college consists both elected and nominated members from Lok Sabha plus Rajya Sabha only. Elected members of the state legislative assemblies are included. Exclude the members of the state legislative assemblies. Term, qualification and removal of the president and the vice president. President, vice president. Qualification. He should be citizen of India, completed 35 years of age, qualified for election as a member of the Lok Sabha. He should be a citizen of India, completed 35 years of age, qualified for election as a member of the Rajya Sabha. Conditions of office. Should not be a member of either House of Parliament or a House of the state legislature, should not hold any office of profit under the government. Should not be a member of either House of Parliament or a House of the state legislature, should not hold any office of profit under the government. Term 5 years, 5 years. Resignation to vice president to president. Removal by a process of impeachment for violation of the Constitution. He can be removed by a resolution introduced and passed by effective majority in Rajya Sabha and simple majority in Lok Sabha. Re-election eligible for re-election eligible for re-election. The governor of state. The head of the state is the governor and the executive power of the state is vested in him. He is appointed by the President of India who holds the office during the pleasure of the President. Appointment. Article 155. He is appointed by the President by warrant under his hand and seal. In a way, he is a nominee of the central government. Term of governor. Article 156. A governor holds office for a term of 5 years. However, this term of 5 years is subject to the pleasure of the President. He can resign at any time by addressing a resignation letter to the President. According to the SC, the President's pleasure is not legitimate. There is no term limit and no tenure security for the governor. The Constitution does not lay down any grounds upon which a governor may be removed by the President. Qualification. Article 157. Provided in Constitution, he should be a citizen of India and he should have completed the age of 35 years. 2 conventions developed regarding appointment of governor. He should be an outsider, that is, he should not belong to the state where he is appointed, so that he is neutral to local politics. In order to ensure the efficient operation of the state's constitutional machinery, the President is obligated to consult the Chief Minister of the affected state before choosing the governor. Other conditions, similar to President, he should not be a member of either House of the Parliament or House of the state legislature. He should not hold any office of profit under the government. Nominated versus elected governor. Arguments for nom-inad governor. Arguments for elected governor. The direct election of the governor is incompatible with the parliamentary system established in the states. The mode of direct election is more likely to create conflicts between the governor and the chief minister. Being an outsider, he may not be aware about the culture, language, and development urges of the state. There is equal likelihood of friction in the case of nominated governors. The governor being only a constitutional nominal head, there is no point in making elaborate arrangements for his election and spending huge amounts of money. An elected governor would naturally belong to a party and would not be a neutral person and an impartial head. The system of presidential nomination enables the center to maintain its control over the states. The CM would like his nominee to contest for governorship. Hence, a second-rate man of the ruling party is elected as governor. Nominated governors violate the true spirit of federalism. Mass removals can be avoided. Appointed governors may try to destabilize state governments under instructions from the center. Rajbhavan tends to become a rehabilitation center and often used for political accommodation. Powers of President and Governor. Executive powers. President-Governor. All executive actions of the Government of India are formally taken in his name. All executive actions of the government of a state are formally taken in his name. He appoints the Prime Minister and the other ministers. They hold office during his pleasure. He appoints the Chief Minister and other ministers. They also hold office during his pleasure. He also appoints tribal welfare ministers in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha. He appoints the Attorney General of India and determines his remuneration. The Attorney General holds office during the pleasure of the President. He appoints the Advocate General of a state and determines his remuneration. The Advocate General holds office during the pleasure of the Governor. He appoints the CAG, the Chief Election Commissioner and other election commissioners, the chairman and members of the UPSC, the governors of states, the chairman and members of Finance Commission, etc. He appoints the State Election Commissioner and determines his conditions of service and tenure of office. He appoints chairman and members of the State Public Service Commission. He can appoint a commission to investigate into the conditions of SCs, STs, and other backward classes. He can recommend the imposition of constitutional emergency in a state to the President. He can appoint an interstate council to promote center, state, and interstate cooperation. He directly administers the union territories through administrators appointed by him. He acts as the chancellor of universities in the state. He also appoints the vice-chancellors of universities in the state. He has the authority to designate any place as a scheduled area and to oversee the administration of both scheduled and tribal territories. The governor of the state has special responsibilities with respect to tribal population in the scheduled area under the 5th schedule. Legislative powers. President-Governor. He can summon or prorogue the parliament and dissolve the Lok Sabha. He can also summon a joint sitting of both the houses of parliament. He can summon or prorogue the state legislature and dissolve the state legislative assembly. He can address the parliament at the commencement of the first session after each general election and at the first session of each year. He can address the state legislature at the commencement of the first session after each general election and the first session of each year. He nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art, and social service. He nominates 1/6 of the members of the State Legislative Council from amongst persons having special knowledge or practical experience in literature, science, art, cooperative movement, and social service. He can nominate 2 members to the Lok Sabha from the Anglo-Indian community. Please see note given below the table. He may nominate 1 Anglo-Indian candidate for the State Legislature Assembly. Please see note given below the table. He decides on questions as to disqualifications of members of the Parliament in consultation with the Election Commission. He decides on the question of disqualification of members of the state legislature in consultation with the Election Commission. His prior recommendation or permission is needed to introduce certain types of bills in the Parliament. He can send messages to the House or Houses of the state legislature with respect to a bill pending in the legislature or otherwise, similar power of the President WRT parliamentary bill. He can make regulations for the peace, progress, and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu. He can promulgate ordinances when the state legislature is not in session. The President also promulgates ordinance when Parliament is not in session. Veto powers with regards to state and central legislations. Veto power with regard to state legislations. He lays the reports of the Comptroller and Auditor General, Union Public Service Commission, Finance Commission, and others before the Parliament. He lays the reports of the State Finance Commission, the State Public Service Commission, and the Comptroller and Auditor General relating to the accounts of the state before the state legislature. Note: in January 2020, the Anglo-Indian reserved seats in the Parliament and state legislatures of India were discontinued by the 126th Constitutional Amendment Bill of 2019, when enacted as the 104th Constitutional Amendment Act, 2019. Financial powers. President-Governor. Money bills can be introduced in the Parliament only with his prior recommendation. Money bills can be introduced in the state legislature only with his prior recommendation. He is to lay before the Parliament the annual financial statement, the union budget. He sees that the annual financial statement, state budget, is laid before the state legislature. No demand for a grant in Lok Sabha can be made without his recommendation. No demand for a grant in the Vidhan Sabha can be made without his recommendation. He can make advances out of the Contingency Fund of India to meet any unforeseen expenditure. He can make advances out of the Contingency Fund of the state to meet any unforeseen expenditure. He constitutes a finance commission after every 5 years to recommend the distribution of revenues between the center and the states. He constitutes a finance commission after every 5 years to review the financial position of the panchayats and the municipalities. Judicial powers. President Governor. He appoints the Chief Justice and the judges of Supreme Court and High Courts. He is consulted by the President while appointing the judges of the concerned state High Court. He can grant pardon, reprieve, respite and remission of punishment, or suspend, remit or commute the sentence of any person convicted of any offense. He can pardon, reprieve, respite, remit, suspend or commute the punishment sentence of any person convicted of any offense against the state law. Other powers of President. Diplomatic powers, military powers, emergency powers. The international treaties and agreements are negotiated and concluded on behalf of the President. However, they are subject to the approval of the Parliament. He represents India in international forums and affairs and sends and he is the Supreme Commander of the Defense Forces of India. In that capacity, he appoints the chiefs of the Army, the Navy, and the Air Force. The Constitution gives extraordinary powers to the President to promulgate the following 3 types of emergencies, privileges and immunities enjoyed by President and Governor. Article 361. Receives diplomats like ambassadors, high commissioners, and so on. He can declare war or conclude peace, subject to the approval of the Parliament. O national emergency, Article 352. O President's rule, Article 356 and 365. O financial emergency, Article 360. Art. 361. One President, or the Governor of a state, shall not be answerable to any court for the exercise and performance of the powers and duties of his office except the Parliament authorized any tribunal, court or body for the investigation of charge under Art. 61. Art. 361. 2. No criminal proceeding can be instituted or continued against President or Governor while in office. Art. 361. 3. No proceedings for the arrest or imprisonment of the President or Governor shall be done by any court while in office. Art. 361. For civil proceedings against a Governor or President against things done by him in his personal capacity can be done only with a previous 2 months' notice. Comparison of veto power of President and Governor. President Governor. With regard to ordinary bills of Parliament, he may give his assent, withhold his assent, return the bill for reconsideration of the Houses. With regard to the ordinary bill, he may give his assent, withhold his assent, return the bill for reconsideration of the Houses, reserve the bill for the consideration of the President. When a state bill is reserved by the Governor for the consideration of the President, he can give his assent, withhold his assent, return the bill for reconsideration of the Houses. In case of returning for reconsideration, if the bill is passed by the state and presented to the President for his assent, the President is not bound to give his assent to the bill. When the Governor reserves a bill for the consideration of the President, he will not have any further role in the enactment of the bill. If the bill is returned by the President for the reconsideration of the House or Houses and is passed again, the bill must be presented again for the presidential assent only, i.e., assent of the Governor is no longer required. With regard to money bills, he may give his assent to the bill, withhold his assent to the bill, but cannot return a money bill for the reconsideration of the Parliament. When a money bill is reserved by the Governor for the consideration of the President, he may give his assent, but cannot return a money bill for the reconsideration of the state legislature. With regard to money bills, he may give his assent to the bill, withhold his assent, reserve the bill for the consideration of the President, but cannot return a money bill for the reconsideration of the Parliament. When the Governor reserves a money bill for the consideration of the President, he will not have any further role in the enactment of the bill. If the President gives his assent to the bill, it becomes an act. With regard to constitutional amendment bills, he can only ratify. He can't reject or return the bill. Constitutional amendment bills cannot be introduced in the state legislature. Ordinance-making power of the President and Governor. The ordinance-making power is the most important legislative power of the President. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. The ordinance-making power of the Governor given under Art. 213 is similar to that of the President given under Art. 123. Why is ordinance power conferred? The power to issue ordinance to President and Governor has been conferred to deal with unforeseen or urgent matters. O. It enables the executive to deal with a situation that may suddenly and immediately arise when the parliament is not in session. Characteristics of ordinance. Ordinance cannot abridge or take away any of the fundamental rights. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from a backdate. These ordinances have the same force and effect as an Act of Parliament date, but are in the nature of temporary laws. The maximum life of an ordinance can be 6 months and 6 weeks, in case of non-approval by the Parliament state legislature, because 6 months is the maximum gap between the 2 sessions of Parliament state legislature. Ordinance can alter or amend a tax law also. However, it cannot be issued to amend the Constitution. President-Governor. He can promulgate an ordinance only when both the Houses of Parliament are not in session or either of the 2 Houses of Parliament is not in session. He can promulgate an ordinance only when the Legislative Assembly, in case of a unicameral legislature, is not in session or, in case of a bicameral legislature, when both the houses either of the 2 houses of the state legislature is not in session. He can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. He can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. His ordinance-making power is coextensive with the legislative power of the Parliament. This means that he can issue ordinances only on those subjects on which the Parliament can make laws. His ordinance-making power is coextensive with the legislative power of the state legislature. This means that he can issue ordinances only on those subjects on which the state legislature can make laws. An ordinance issued by him has the same force and effect as an Act of the Parliament. An ordinance issued by him has the same force and effect as an Act of the Parliament. He can withdraw an ordinance at any time. He can withdraw an ordinance at any time. Power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by PM. Power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by CM. An ordinance issued by him should be laid before both the Houses of Parliament when it reassembles. An ordinance issued by him should be laid before the Legislative Assembly or both the houses of the state legislature, in case of a bicameral legislature, when it reassembles. An ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. It may cease to operate even earlier than the prescribed 6 weeks, if both the Houses of Parliament pass resolutions disapproving it. An ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of the state legislature. It may cease to operate even earlier than the prescribed 6 weeks, if a resolution disapproving it is passed by the Legislative Assembly and is agreed to by the Legislative Council, in case of a bicameral legislature. He needs no instruction for making an ordinance. He cannot make an ordinance without the instructions from the President in 3 cases. 1. If a bill containing the same provisions would have required the previous sanction of the President for its introduction into the state legislature. 2. If he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President. 3. If an act of the state legislature containing the same provisions would have been invalid without receiving the President's assent. An ordinance issued by him is subject to the same limitations as an Act of Parliament. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the Parliament cannot make. An ordinance issued by him is subject to the same limitations as an act of the state legislature. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the state legislature cannot make. Repromulgation of ordinances, a violation to the spirit of Constitution? The decision of the central government to repromulgate Commission for Air Quality Management in the National Capital Region and Adjoining Areas Ordinance 2020 has led to several questions being raised regarding the practice of the issuing ordinances as well as the constitutionality of the ordinances being repromulgated. Cases relating to repromulgation of ordinances are ODC Wadhwa v. State of Bihar, 1987. The court had held that successive repromulgation of the ordinances having the same texts and without attempting to pass the bills will amount to a violation to the Constitution of India. O. Krishna Kumar Singh and ANR v. State of Bihar, 2017. This is the landmark judgment in which it was held that the re-promulgation of ordinances are a fraud to the Constitution. In this case, the 7-bench jury held that the power conferred to the executive doesn't make it a parallel law-making authority. The Supreme Court in 1986 had ruled that the repromulgation of ordinance is contrary to the basic fundamentals of the Constitution and a subversion of democratic legislative processes. The mechanism could be very likely used as an exercise of power by the government to ignore the legislature. Issues. O. Usurpation of the legislative power. O. The doctrine of separation of powers is undermined. O. It violates the fundamental structure of the Constitution. Why is the ordinance route considered undemocratic? SC in 2017 ruled that repromulgation of ordinances is a fraud on the Constitution and a subversion of democratic legislative process. Primary lawmaking power rests with the legislature and not the executive. Ordinance is an undemocratic route to lawmaking, which is the job of the legislature. The executive is only given the legislative power to issue an ordinance to meet an emergent situation, thus it shall not be invoked frequently. Repromulgation represents an effort to overreach the legislative process, which is the primary source of lawmaking in a parliamentary democracy. Ordinance is a backdoor to escape the parliamentary scrutiny, debates, discussions, etc. Way forward, as governments, both at the center and state, are violating this principle, the legislature and the courts should check the practice. That is what separation of powers and the concept of checks and balances means. By not checking this practice, the other two organs are also abducting their responsibility to the Constitution. Pardoning power of the President and Governor. Articles 72 and 161 of the Constitution empower the President of India and the governors of states to grant pardon or suspend, remit, or commute sentences in certain cases. The pardoning power of the President-Governor is independent of the judiciary. It is an executive power conferred to keep the door open for correcting any judicial errors in the operation of law and to afford relief from a sentence which the President-Governor regards as unduly harsh. In the Maru Ram v. Union of India in 1980 and Dhananjoy Chatterjee v. State of West Bengal in 1994, the SC has ruled that the President has to act on the advice of the Council of Ministers while deciding mercy pleas. Apuru Sudhakar and another v. Andhra Pradesh, 2006. Powers of the President or Governor under Articles 72 and 161 are subject to judicial review. Their decision can be challenged on the ground that it was passed without application of mind, it is mollified, it was passed on extraneous or wholly irrelevant considerations, relevant materials were kept out of consideration, it suffers from arbitrariness. Pardoning power of the President. Pardon whenever a convict is granted pardon by the President of India under Article 72. He is completely absolved from the punishment imposed on him, as also from all penal consequences. Commutation. The President may change a punishment to one of a different sort than that originally awarded by the court. Remission. It means the reduction of the sentence without changing the nature or the character of the punishment awarded by the court. Respite. This order results in temporary suspension of a sentence in special circumstances, such as the pregnancy of a woman sentenced with death penalty or insanity of a convict. In other words, it is a postponement of execution of the sentence to the future. Reprieve. It simply stays the execution for a temporary period, or postpone a capital sentence, or take back, or withdraw a sentence for a time. Difference between pardoning powers of President and Governor. President-Governor. He can pardon, reprieve, respite, remit, suspend, or commute the punishment sentence of any person convicted of any offense against a central law. He can pardon, reprieve, respite, remit, suspend, or commute the punishment sentence of any person convicted of any offense against a state law. He can pardon, reprieve, respite, remit, suspend, or commute a death sentence. Governor can suspend, remit, or commute, but he cannot pardon a death sentence. He has pardoning power in respect to punishment or sentence by a court-martial. He doesn't possess any such power. Discretionary powers of the President and Governor. The Governor has both situational and constitutional discretion, but the President has only situational discretion. After the 42nd Constitutional Amendment, 1976, ministerial advice has been made binding on the President, but no such provision has been made with respect to the Governor. President-Governor. Appointment of Prime Minister when no party has a clear majority in the Lok Sabha, or when the Prime Minister in office dies suddenly, and there is no obvious successor. Appointment of a Chief Minister in situations where no party has a clear majority in the State Legislative Assembly, or when an incumbent Chief Minister passes away unexpectedly and no obvious candidate can take his place. Dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. Dismissal of the Council of Ministers when it cannot prove the confidence of the State Legislative Assembly. Dissolution of the Lok Sabha if the Council of Ministers has lost its majority. Dissolution of the State Legislative Assembly if the Council of Ministers has lost its majority. Discretionary powers of Governor. Governor has constitutional discretion in the following cases. Reservation of a bill for the consideration of the President. Recommendation for the imposition of the President's rule in the state. While exercising his functions as the administrator of an adjoining union territory, in case of additional charge, determines the amount payable by the government of Assam, Meghalaya, Tripura, and Mizoram to an autonomous tribal district council. Seeking information from the Chief Minister with regard to the administrative and legislative matters of the state. Issues related to Governor. Arbitrary removal. The arbitrary removal of the Governor before the expiration of his tenure has also been an important issue in the recent past. Rehabilitative appointments. The position has been reduced to becoming a retirement package for politicians for being politically faithful to the government of the day. Abuse opposition. There are various examples of the Governor's position being abused, usually by the ruling party at the center. Misuse of discretionary powers. Governor's discretionary powers to invite the leader of the largest party alliance to form the government has often been misused. Partisanship role. Recently, the Governor of Rajasthan has been charged with the violation of the Model Code of Conduct. His support of the ruling party is against the spirit of non-partisanship that is expected from the person sitting on constitutional posts. Misuse of power under Art. 356. The imposition of President's rule, Art. 356. In case of breakdown of constitutional machinery in a state has been frequently misused by the central government. Mere rubber stamp or puppet, governor is bound by the aid and advice of his council of ministers. Recent examples. The governor refused to read some parts of the governor's address, which was prepared by the state government in Tamil Nadu. In Maharashtra, the governor removed the governor's rule and administered oath to a CM who did not have majority support in the House. The WB Assembly passed a bill for replacing the governor from the position and making the chief minister the chancellor of state universities. Dispute with state government over the approval of various bills in Kerala. Similar issue is in Telangana as well. Recommendations of Sarkaria Commission. Related to Article 356. Art. 356 should be used in very rare cases when it becomes unavoidable to restore the breakdown of constitutional machinery in the state. It should be used as a matter of last resort. Before taking action under Art. 356, a warning should be issued to the state government that it is not functioning according to the Constitution. Related to Governor. Governors should be appointed in consultation with the Chief Minister of the state, Vice President of India, and the Speaker of the Lok Sabha. His tenure of office must be guaranteed and should not be disturbed except for extremely compelling reasons. Criteria for selection of governor. I. He should be eminent in some walk of life. 2. He should be a person from outside the state. 3. He should be a detached figure and not too intimately connected with the local politics of the state. 4. He should be a person who has not taken too great a part in politics generally, and particularly in the recent past. Related to appointment of CM. If there is a single party having an absolute majority in the assembly, the leader of the party should automatically be asked to become the chief minister. In the absence of such a party, the governor shall choose a CM by holding hearings with each of the following parties or groups of parties in the order of preference listed below, an alliance of parties that was formed prior to the elections. The largest single party staking a claim to form the government with the support of others, including independents. A post-electoral coalition with all partners joining the government. A post-electoral alliance with some parties joining the government and the remaining supporting from outside, others. When the president withholds his assent to the state bills, the reasons should be communicated to the state government. The procedure of consulting the chief minister in the appointment of the state governor should be prescribed in the Constitution itself. The governor cannot dismiss the Council of Ministers so long as it commands a majority in the Assembly. Keywords: Council of Ministers, absolute majority, constitutional right, discretionary powers, rehabilitative appointments, abuse of position, pardon, respite, promulgation of ordinance. CSATC content. 9.2. STJ. UPSQUAD. Quantitative aptitude. Logical reasoning. 092***. UPSQUALI. SAT. CSAT Wallah. Reading comprehension and verbal reasoning. CSAT Patara. G. Gamified practice approach for flow. B. as learning. Information nuggets followed by practice questions. Includes 10 years PYQs and 1200 practice questions. 25 Prime Minister and Chief Minister. The President Governor is the nominal executive authority, de jure executive, and Prime Minister Chief Minister is the real executive authority, de facto executive. In other words, the President Governor is the head of the state, while the Prime Minister Chief Minister is the head of the government. Constitutional provisions. Article Prime Minister. Subject matter Article Chief Minister. Subject matter 74 Council of Ministers to aid and advise President 163 Council of Ministers to aid and advise Governor. 75 other provisions as to minister 164 other provisions as to ministers. 77 Conduct of business of the Government of India 166 Conduct of business of the Government of a State. 78 Duties of Prime Minister as respects the furnishing of information to the President, etc. 167 Duties of the Chief Minister as respects the furnishing of information to the Governor, etc. Important judgments. Delhi HC, 1980. The requirement that a candidate for Prime Minister demonstrate his or her majority in the Lok Sabha is not mandated by the Constitution. The President may first name him as Prime Minister before requesting that he demonstrate his majority in the Lok Sabha within a reasonable amount of time. Same applies for the CM in the states. The Supreme Court, 1997. A person who is not a member of either House of Parliament may be chosen Prime Minister for a period of 6 months, during which time he must join either House of Parliament in order to retain his position. Also true of CM. Powers and functions of PM and CM. Power and functions of PMWRT Parliament. Power and functions of CMW. RT State Legislature. The PM is the leader of the lower house, Lok Sabha. The CM is the leader of the State Legislative Assembly. He advises the President with regard to summoning and proroguing of the sessions of the Parliament. He advises the governor with regard to summoning and proroguing of the sessions of the state legislature. He can recommend dissolution of the Lok Sabha to the president at any time. He can recommend dissolution of the Legislative Assembly to the governor at any time. He announces government policies on the floor of the House. He announces government policies on the floor of the House. Power and functions of PMWRT President. Power and functions of CMW. RT Governor. PM is the principal channel of communication. Art. 78. Between the President and the COM. CM is the principal channel of communication. Art. 167. Between the Governor and COM. It is the duty of the PM to communicate to the President all decisions. Art. 78. Of the COM. To furnish information relating to the administration and proposal for legislation as the President may call for. If the President so requires, to submit for the consideration of the COM matter on which a. It is the duty of the CM to communicate to the Governor all decisions. Art. 167. Of the COM, to furnish such information relating to the administration as the Governor may call for, and, if the Governor so requires, to submit for the consideration of the company matter on which a decision has been taken by a minister but which has not been considered by the Council. Decision has been taken by a minister but which has not been considered by the Council. Regarding the appointment of significant authorities like the chairperson and members of the UPSC, Attorney General of India, Comptroller and Auditor General of India, and so on, the PM recommends the President. Regarding the appointment of significant authorities like the Advocate General, the Chairman and members of the State Public Service Commission, the State Election Commissioner, and others, CM provides advice to the Governor. In relation to Council of Ministers, OPMCM recommends persons who can be appointed as ministers by the President-Governor. The President-Governor can appoint only those persons as ministers who are recommended by the PMCM. He allocates and reshuffles various portfolios among the ministers. He can ask a minister to resign or advise the President-Governor to dismiss him in case of difference of opinion. He presides over the meeting of COM and influences its decisions. He guides, directs, controls, and coordinates the activities of all the ministers. His death or resignation from office can bring the collapse of the COM. Other power and functions of PM. Power and functions of PM, WRT the Cabinet. The PM constitutes the Cabinet and allocates portfolios. He summons Cabinet meetings and also decides the agenda of the meeting. It is the PM's privilege to consult any person on any matter he deems fit, and it is his discretion to act occasionally without any consultation. Power and functions of PM, WRT the Planning. He is the crisis manager-in-chief at the political level during emergencies. He is chairperson of National Disaster Management Authority. Power and functions of PM, WRT the Cabinet Committees. The PM sets up cabinet committees and are headed by him when he is a member. Cabinet Committee on Political Affairs, known as Super Cabinet. PM. Cabinet Committee on Economic Affairs. PM. Cabinet Committee on Appointments. PM. Power and functions of PM, WRT the External Affairs. This domain has been personally directed by the PM. If the PM is respected by international communities, it can help him acquire greater respect domestically as well. He plays a significant role in shaping the foreign policy of the country. Other power and functions of CM. Power and functions of CMW.R.T. Cabinet. CM constitutes the Cabinet and allocates portfolios. He summons Cabinet meetings and also decides the agenda of the meeting. Other powers and functions of CM. He is a member of the Interstate Council and the Governing Council of NITI Aayog, both headed by the PM. CM is chairman of the State Planning Board. CM is vice chairman of the concerned zonal council by rotation, holding office for a period of 1 year at a time. He is the crisis manager-in-chief at the political level during emergencies. CM is chairperson of State Disaster Management Authority, SDMA. Keywords: O's of office, conduct of business, real executive authority, de facto executive, loss of confidence, coalition, State Disaster Management Authority, SDMA, 26 Council of Ministers. The principles of the parliamentary system of government are not provided in detail in the Constitution. However, Articles I, 74 and 75 deal with the Central Council of Ministers, and 163 and 164 deal with the State Council of Ministers in a broad, sketchy, and general manner. Constitutional provisions. Central Council of Ministers, COM, Art. 74. There shall be a COM with the PM at the head to aid and advise the President in the exercise of his functions. The 42nd and 44th Constitutional Amendment Acts have made the advice binding on the President. SC Judgment, 1971. Even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold office. SC Judgment, 1974. Wherever the Constitution requires the satisfaction of the President, the satisfaction is not the personal satisfaction of the President, but it is the satisfaction of the Council of Ministers. Art. 75. The Governor shall appoint the CM and other ministers on the advice of the CM. 91st Amendment Act of 2003. The total strength of COM, including PM, shall not exceed 15% of the total strength of the Lok Sabha. 91 SD Amendment Act of 2003. A member of LSRS disqualified on the ground of defection shall also be disqualified to be appointed as a minister. Term. The ministers shall hold office during pleasure of the President. Collective responsibility. The Council of Ministers shall be collectively responsible to the Lok Sabha. Oath. The President shall administer the oaths of office and secrecy to a minister. Disqualification. A minister who is not a member of the Parliament, either House, for any period of 6 consecutive months shall cease to be a minister. The salaries and allowances of ministers shall be determined by the Parliament. Art. 88. Every minister has the right to speak and take part in the proceedings of either House, any joint sitting of the Houses, and any committee of Parliament of which he is a member. But he can vote only in the House of which he is a member. State Council of Ministers, COM, Art. 163. There shall be a COM with the CM as the head to aid and advise the governor in the exercise of his functions, except governor's discretionary power. SC Judgment, 1971. A council of ministers must always exist to advise the governor, even after the dissolution of the state legislative assembly or resignation of a council of ministers. Hence, the existing ministry may continue in the office until its successor assumes charge. SC Judgment, 1974. Wherever the Constitution requires the satisfaction of the governor, the satisfaction is not the personal satisfaction of the governor, but it is the satisfaction of the Council of Ministers. Art. 164. The governor shall appoint the CM and other ministers on the advice of the CM. 91st Amendment Act of 2003. The total strength of COM, including CM, shall not exceed 15% of the total strength of the Legislative Assembly and shall not be less than 12. 91st Amendment Act of 2003. A member of either House of State Legislature disqualified on the ground of defection shall also be disqualified to be appointed as a minister. Term. The ministers shall hold office during the pleasure of the governor. Collective responsibility. The Council of Ministers shall be collectively responsible to the State Legislative Assembly. Oath. The governor shall administer the oaths of office and secrecy to a minister. Disqualification. A minister who is not a member of the state legislature for any period of 6 consecutive months shall cease to be a minister. The salaries and allowances of ministers shall be determined by the state legislature. Art. 177. Every minister has the right to speak and take part in the proceedings of the Assembly Council and any committee of the state legislature of which he is a member. But he can vote only in the House of which he is a member. Responsibility of ministers. Individual collective. Article 75 and Article 164 also contain the principle of individual responsibility. It states that the ministers hold office during the pleasure of the President. However, the President-Governor removes a minister only on the advice of the PMCM. In case of a difference of opinion or dissatisfaction with the performance of a minister, the PMCM can ask him to resign or advise the President to dismiss him. The principle of collective responsibility is the fundamental principle underlying the working of the parliamentary system of government. They work as a team and swim or sink together. When the Legislative Assembly passes a no-confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Legislative Council. Article 75 clearly states that the Council of Ministers is collectively responsible to the Lok Sabha, whereas Article 164 clearly states that the Council of Ministers is collectively responsible to the Legislative Assembly of the state. Alternatively, the Council of Ministers can advise the President-Governor to dissolve the Lok Sabha Legislative Assembly on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The principle of collective responsibility also means that the Cabinet decisions bind all Cabinet ministers and other ministers, even if they deferred in the Cabinet meeting. If any minister disagrees with a Cabinet decision and is not prepared to defend it, he must resign. For example, Dr. B.R. Ambedkar resigned because of his differences with his colleagues on the Hindu Code Bill in 1953. Keywords: swim or sink together, collective responsibility, parliamentary system, Hindu Code Bill in 1953, 91st Amendment Act, 2003. MONLYS-B% by Physics Wallah. IROFTI Foundation UR I courses 5 live recorded GS classes BC SAT classes OM DE AIILNYSMQCUQESSD plus ION S REESGS and RS out. Songkalp 2026 Prahar 2025 Titan 2025. English W English A T English. Starts from coupon code 59 for 99. For extra discount 27 Cabinet system in India, a smaller body called Cabinet is the nucleus of the Council of Ministers. It consists of only the Cabinet ministers. It is the real center of authority in the center-state government. Role of Cabinet: it is the highest decision-making authority in our politico-administrative system. It is the chief policy formulating body of the central state government. It is the supreme executive authority of the central state government. It is the chief coordinator of central state administration. It is an advisory body to the President-Governor, and its advice is binding on him. It is the chief crisis manager and thus deals with all emergency situations. It deals with all major legislative and financial matters. It exercises control over higher appointments like constitutional authorities and senior secretariat administrators. It deals with all foreign policies and foreign affairs. Central Cabinet. Kitchen Cabinet. It is an informal body consisting of the Prime Minister and 2 to 4 influential colleagues in whom he has faith and with whom he can discuss every problem. It advises the Prime Minister on important political and administrative issues and assists him in making crucial decisions. It is composed of not only cabinet ministers but also outsiders like friends and family members of the Prime Minister. Cabinet Committees. Merits of Kitchen Cabinet. Demerits of Kitchen Cabinet. Due to the small unit, a much more efficient decision-making body than a large cabinet. Reduces the authority and status of the cabinet as the highest decision-making body. Members can meet more often and deal with business much more expeditiously. Circumvents the legal process by allowing outside persons to play an influential role. Helps in maintaining secrecy and making decisions on important political issues. Could induce a sense of mistrust among other members of the cabinet. The cabinet works through various committees called cabinet committees. They are set up by the PMCM according to the exigencies of the time and requirements of the situation. Hence, their number, nomenclature, and composition vary from time to time. They not only sort out issues and formulate proposals for the consideration of the cabinet but also take decisions. However, the cabinet can review their decisions. Features OF Cabinet Committees. They are extra-constitutional, i.e., not mentioned in the Constitution. The rules of business provide for their establishment. They are oft types standing and ad hoc. The former is of a permanent nature while the latter are of a temporary nature. Advantages, disadvantages. They are an organizational device to reduce the enormous workload of the cabinet. They also facilitate in-depth examination of policy issues and effective coordination. Committees facilitate efficient utilization of time and human resources. They do not cover all important areas of governmental functioning. They can take up a matter only when it is referred to by the minister concerned or by the cabinet. Saves the valuable time of the cabinet. More effective deliberation due to smaller size. It checks arbitrary actions by ministers. They help in safeguarding the principle of collective responsibility. It helps in facilitation of utilization of ministerial expertise. They do not meet regularly, which is absolutely necessary if sustained attention is to be given to complex problems and the progress and implementation of important policies and programs is to be kept under constant review. Previous year questions. 1. Discuss the role of the Vice Presidents of India as the Chairman of the Rajya Sabha. 2022. 2. Discuss the essential conditions for exercise of the legislative powers by the Governor. Discuss the legality of promulgation of ordinances by the Governor without placing them before the legislature. 2022. 3. Instances of the President's delay in commuting death sentences has come under public debate as denial of justice. Should there be a time limit specified for the President to reject such petitions? Analyze. 2014. 4. The size of the cabinet should be as big as governmental work justifies and as big as the Prime Minister can manage as a team. How far the efficacy of a government then is inversely related to the size of the cabinet. Discuss. 2014. Keywords: Kitchen Cabinet, Supreme Executive Authority, Chief Coordinator, Governmental Functioning, Effective Deliberation, Politico-Administrative System. UPSC LCURC 2025 English *A*L. Adjust. 38999. For extra discount. 992-061-3613 PW. Live 28 Ministries of Government. The Constitution provides for a parliamentary form of government modeled on the British model. The Council of Ministers, headed by the Prime Minister, is the real executive authority in our politico-administrative system. Constitutional provisions. Article 74 Council of Ministers to aid and advise the President. This advice shall not be inquired in any court of law. Article 75 The Council of Ministers shall be collectively responsible to the Lok Sabha. Total number of ministers, maximum 15% of the total strength of LS. 91st Amendment Act of 2003, individual responsibility of the minister to the President. Article 77 The President shall make rules for convenient transactions of the business of the GOL. Hierarchy of ministers in India. The Council of Ministers consists of 3 categories of ministers, namely, cabinet ministers, ministers of state, and deputy ministers. The difference between them lies in their respective ranks, emoluments, and political importance. Cabinet Minister. Other ministers. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Thus, their responsibilities extend over the entire gamut of the central government. They used to have responsibility for important portfolios like the Home Ministry, etc. These are ministers other than cabinet ministries. These ministries are headed by the Minister of State. Parliamentary secretaries. He is a parliamentarian who helps a senior minister with duties. They usually have the rank of Minister of State, enjoy the same privileges, and are tasked with working for a government agency. Reasons for appointment. Criticism. Article 75 and 164. According to Articles 75 and 164, parliamentary secretaries are not ministers because they are not appointed either by the President or Governor nor given the oath of office in secrecy. Increased workload. They assist ministers to discharge functions successfully despite the increased workload, something that many states and the parliament have done, and the SC supported this in the UC Raman case. Constitutional power. The legislature has the authority to enact legislation exempting any officeholder. No independent charge, they are simply tied to ministers in order to carry out their duties. They are not given any further authority. Against separation of powers, if a legislator becomes executive, then Husha cannot function independently. Misuse of Article 102. This allows Parliament to exclude offices from the provision of office of profit. The exclusion of parliamentary secretaries results in a drain of public money due to oversized cabinet and political opportunism due to arbitrary use of amendments, violation of constitutional spirit. By excluding it from the definition of ministers, the office of the parliamentary secretary is misused to circumvent the 15% ceiling strength of the Council of Ministers. 10% in the case of Delhi. Political motive. They are misused to fulfill the political aspirations of MPs who couldn't get a ministerial position. Conclusion. The debate of parliamentary secretaries is centered on the office of profit concern. Rather than each state following a different provision, it is high time that the Supreme Court makes one judgment, and the same shall be applicable to all states in the central government. 29. Parliamentary committees introduction. It means a committee that is elected by the House or nominated by Speaker Chairman, works under and submits reports to the Speaker Chairman, and has a secretariat provided by the Lok Sabha Rajya Sabha. Role of parliamentary committees. Specialized jobs. Standing committee performs specialized jobs, and ad hoc committees are constituted to perform specific tasks and cease to exist upon their completion. Financial prudence. Review of budgetary allocations enable it to ensure economy and efficiency in public expenditure. Engaging stakeholders. During the review of subjects, these committees seek feedback from NGOs, experts, citizens, etc. E.g., Finance Committee summoned the RBI governor on the demonetization subject. In-depth scrutiny. Working beyond parliamentary sessions enables in-depth scrutiny of bills which MPs can't do due to increased workload. Resolving issues in bills. Multi-layered pre-legislative scrutiny results in significant issues in the bill getting addressed. E.g., redressal of significant issues in the Prevention of Corruption Amendment Bill after examination by 2 parliamentary committees. Forum for consensus building. Anti-defection law does not apply to these committees. This enables impartial functioning beyond party lines to build consensus on important issues. Issues faced by committees. Dip in the number of bills referred. RTI Amendment Act 2019 and UPA Amendment Act 2019 were passed without referring them to the parliamentary committee. Absenteeism of members. The attendance of about 50% since 2014 to 15 in committee meetings is a cause for concern. Lack of expertise. Committee members lack the technical expertise required for detailed analysis of topics such as accounting and administrative principles. The politicization of meetings. Members have started taking strict party lines in meetings on issues that are getting public attention. Short tenure. 1-year tenure of these committees is very little time for specializations as well as finishing a detailed review of complex topics. X. The IT panel could not complete deliberations on safeguarding citizens' rights and prevention of misuse of social online news media platforms, including special emphasis on women's security in the digital space. Non-binding recommendations. Only certain debates make reference to some reports, and most of these reports are not taken for discussion in the Parliament session. Way forward. The NCRWC has recommended the following steps to improve the effectiveness of parliamentary committees. Increase in tenure. Recently, Rajya Sabha Secretariat is considering a 2 years tenure for DRSC so that the panels get enough time to work on the subjects selected by them. Adopt best practices. Practices like a concerned minister appearing before the committee to elaborate and defend the policies of the government, objective criteria for referring bills to a committee, etc. shall be adopted. Institutional research support. This will allow committees to examine technical and complex policy issues holistically. Periodic review. Objective criteria for a regular assessment of the committee's performance and making a required course correction. Conclusion. Considering the steadily declining sittings of Parliament from 100 to 150, 1950s, to 60 to 70 in 2021 to 22. Strengthening the committee system can go a long way in improving the quality of laws drafted and minimizing potential implementation challenges. 30. Representation of Peoples ACT Introduction. The Representation of Peoples Act 1950 was enacted by the Provisional Parliament of India before the first general elections in the country under Article 327 of the Constitution. It provides for the allocation of seats and the delimitation of constituencies for the purpose of Lok Sabha and state legislature elections, the qualifications of voters, electoral rolls, and filling up seats in Rajya Sabha by the representatives of union territories. The Representation of Peoples Act 1951 provides for the actual conduct of elections of the Houses of the Parliament and to the House or Houses of the legislature of each state. Key features. OFTCT. It regulates how elections and by-elections are held. It provides the administrative infrastructure for holding elections. It deals with political party registration. It defines the requirements and disqualifications for House membership. It consists of laws to combat corruption and other offenses. It outlines the procedure for resolving problems and controversies resulting from elections. Significance challenges. Implementation of democracy. The Act provides for the implementation of the provisions of the Constitution and ensures that democracy materializes in the country and fills voids, such as the term of Rajya Sabha members, etc. Ensuring equality. The provisions of one electoral roll for Lok Sabha and Assembly elections, prohibiting registration in more than one constituency, ensures equality of citizens. Decriminalization. The provisions regarding disqualification from membership of Parliament and state legislature ensure decriminalization of politics. Transparency. The provisions regarding the declaration of assets and liabilities, right to information of electors, etc. Ensure transparency regarding the candidates in the elections. Free and fair elections. The provisions regarding corrupt practices and electoral officers provide for the decriminalization of politics. Ruling party advantage. The RPAs do not contain clear provisions and guidelines on reducing the advantage to the ruling party in terms of misuse of official machinery and electoral funding. E.g., BJP has received around 95% of its funding through electoral bonds. Stopping criminal elements. Even after provisions in RPAs, around 43% of MPs in the present Lok Sabha have criminal cases pending against them. Social media. Social media has blurred the silence period of election campaigning and also enables micro-level targeting of voters. Power to deregister parties. ECI does not have the power to deregister political parties that do not contest elections and are merely for receiving funds. Bureaucratization of politics. ECI does not have its own official machinery and has to depend on the government, which is not conducive to free and fair elections. Provisions regarding disqualifications. INRPA, 1951. Section 8 addresses the disqualification of representatives for specific offenses. Among the different subclauses are 8. When a person convicted of an offense punishable under certain acts of the Indian Penal Code, Protection of Civil Rights Act 1955, Unlawful Activities Prevention Act 1967, Prevention of Corruption Act 1988, Prevention of Terrorism Act 2002, etc., shall be disqualified if sentenced to only fine for a period of 6 years from the date of such conviction. Other offenses. If a person is convicted of any crime and sentenced to 2 or more years in jail, he or she is disqualified. If a person has engaged in corrupt practices. If a person is dismissed from a government position due to corruption or disloyalty. Imprisonment, for a period of 6 years from the date of such conviction and shall continue. 8.2. A person guilty of violating any law prohibiting stockpiling or profiteering, or any law prohibiting the adulteration of food or medications, or any provisions of the Dowry Prohibition Act, 1961. 8.3. A person convicted of any offense and sentenced to imprisonment for not less than 2 years, other than any offense referred to in subsection 1 or 2, is disqualified from the date of such conviction and remains disqualified for a period of 6 years after his release. If a person has a contract with the government in the course of commerce or business or supplies goods to the government. If a person is a managing agent, manager, or secretary of any company or corporation other than a cooperative society in which the government owns at least 25%. If a person fails to file an account of his election expenses on time. Remedies available for disqualified persons. Approach to ECI under Section 11. The disqualified person can approach the Election Commission for removal of disqualification under Section 11 of the Act, except disqualification on the ground of corrupt practices. Approach to SC under Section 116A. If the disqualification has resulted due to an election petition filed in High Court, then the person can approach Supreme Court for appeal under Section 116A. Disqualifications for voting. A person is disqualified from voting at any election for a period of 6 years if he is convicted of IPC 1860, offense of bribery and undue influence or personation at an election. RPA 1951, offense of promoting enmity between classes in connection with the election. Removal of ballot papers from polling stations. Fraudulently defacing or fraudulently destroying any nomination paper. Judgments. The Supreme Court overturned a 4th subsection 8.4 in 2013 Lily Thomas case. This section allowed convicted legislators to keep their seats if they filed an appeal within 3 months of their conviction. The Supreme Court in Lily Thomas v. Union of India case, 2013 held the provision that disqualification of a member of Parliament and state legislature shall not take place until 3 months from the date of conviction, as unconstitutional and provided for immediate disqualification on conviction. In 2013, the Patna High Court forbade anybody in judicial or police detention from contesting an election. The recommendations of the 244th report of the Law Commission should be implemented, i.e. disqualification at the stage of framing of charges along with other legal safeguards to curb criminalization of politics. Registration of political parties. Registration of political parties with the Election Commission of India. The Election Commission lists political parties also National Party, O State Party, or O Registered Unrecognized Party. The election symbols, reservation and allotment, Order, 1968 specifies the requirements for being classified as a national or state party. For recognition as a national or state party, a political party has fulfilled any of the following conditions. National party state party 6% valid votes in Lok Sabha or Legislative Assembly election in 4 or more states plus 4 Lok Sabha seats. 6% valid votes in Legislative Assembly elections in state plus 2 Assembly seats. 6% valid votes in Lok Sabha elections in state plus 1 Lok Sabha seat. 2% Lok Sabha seats from 3 states 3% or 3 Legislative Assembly seats, whichever is more. 125 Lok Sabha seats state party in 4 states 8% valid votes in Lok Sabha or Legislative Assembly elections in a state. The following political parties registered with the Election Commission are considered register unrecognized parties. Unrecognized parties are newly registered parties. Parties that have not received a sufficient percentage of votes in assembly or general elections to become state parties, and parties that have never contested elections since being registered. Benefits to recognized political parties. Exemptions from proposers. Candidates of recognized political parties do not require a subscription from 10 proposers at the time of filing of nomination. Allocation of an equitable share of time. On the basis of past performance, registered recognized political parties get broadcast telecast facilities over Akashvani Doordarshan during general elections. Travel expenses of star campaigners. Star campaigners' travel expenses are not accounted for in the election expense records of their party's candidates. Free supply of copies of electoral rolls to the candidates of recognized political parties. Reserved symbols. Candidates of registered recognized political parties get reserved symbols. Adjournment of polls. On the death of a candidate of registered recognized political parties, the returning officer adjourns the polls to a later date. Keywords. Equitable share of time. Section 62 of the Representation of People Act, 1951, the Law Commission, ensuring equality, decriminalization, free and fair elections. Right to know right to information. A candidate has to furnish information about the following in his nomination paper: whether he is accused of any offense punishable with imprisonment for 2 years or more, where charges are framed by a competent court. He is convicted of any offense and sentenced to imprisonment for 1 year or more. Supreme Court ruling on right to information of electors. Declaration of assets and liabilities. Section 75A of RPA 1951 requires every elected candidate for a House of Parliament to provide the Chairman Speaker with the following information within 90 days of taking the oath. Case Supreme Court ruling. Association for Democratic Reforms v. Union of India, 2002. Candidate has to furnish information regarding any criminal antecedent, educational qualification and assets. People's Union for Civil Liberties v. Union of India, 2003. Voters have a fundamental right to know the relevant qualifications of candidates for office, including information about their income and assets. Accordingly, Section 33B of the RPA, 1951, which stated that candidates could not be compelled to disclose any information about themselves other than their criminal records, was held unconstitutional. Resurgence India case, 2013. Made it compulsory for returning officers to reject those nomination papers which are accompanied by incomplete blank affidavits. Krishnamurti v. Shivakumar and Ors, 2015. The Supreme Court ruled that a candidate's criminal antecedents, particularly egregious crimes, must be disclosed at the time of filing the nomination paper, as required by law. Lok Prahari v. Election Commission, 2018. The Supreme Court directed that the Center alter the guidelines as well as the disclosure form presented by candidates along with their nomination papers to include a source of income for themselves as well as their spouses and dependents, or the movable and immovable property of which he, his spouse, and his dependent children are jointly or severally owners or beneficiaries. Owe his liabilities to any public financial institution, central or state government. Speaker and Chairman have the power to make rules. The Chairman Speaker can make rules in this regard, and willful contravention of the rules can be considered as a breach of privilege. Account of election expenses. Section 77 of RPA 1951 requires each candidate to keep a separate and correct account of all expenses incurred in connection with the election from the date of nomination to the date of result declaration. This account must be given to the district election officer within 30 days of any candidate's election. Travel expenses incurred by star campaigners of a political party by air or other methods are not considered expenditures by the candidate in this regard. Corrupt practices. Provisions regarding corrupt practices in RPA 1951. Section 123 of the Act defines corrupt practices: promotion of enmity or hatred, the encouragement of hostility or hatred amongst different classes of Indian citizens on the basis of religion, race, caste, community, or language. Commission of suttee or its glorification, the propagation of the practice or the commission of suttee or its glorification. Bribery, any gift, offer, or promise by a candidate or his agent to any person to stand or not to stand, or to withdraw or not to withdraw from being a candidate, or to vote or refrain from voting. Undue influence, direct or indirect interference with the free exercise of any electoral right. It includes threatening any election candidate or elector. Religious appeal, the appeal based on his religion, race, caste, community, or language, or the appeal to religious or national symbols, such as the national flag or the national emblem. Obtaining assistance from any government official, obtaining aid, other than voting, from gazetted officers, stipendiary judges and magistrates, members of the armed forces, excise officers, revenue officers, and so on. Booth capturing. In the 2019 general elections, a polling agent in Faridabad was arrested over video of booth capture. False publication. The publication of any false statement of fact in relation to the personal character or conduct of any candidate. Contravention of authorizing expenditure. The incurring or authorizing of expenditure in contravention of the account of election expenses and maximum limit prescribed under Section 77 of RPA, 1951. Use of any vehicle or vessel for the free conveyance of any elector, other than the candidate himself, the members of his family or his agent, to or from any polling station. The Supreme Court in Abhiram Singh's case, 2017 held that election is a secular exercise and an appeal for votes during elections on the basis of religion, caste, race, community, or language amounts to a corrupt practice. Keywords: booth capturing, false publication, religious appeal, undue influence, election expenses, promotion of enmity. Electoral offenses listed in RPA, 1951. Chapter 3 of RPA, 1951 provide the following electoral offenses: disturbances at public meetings. For the purpose of preventing the transaction of the business. Publication of results of exit polls, publication and dissemination of results of exit polls, etc. from the beginning of the election to half an hour after the polls, printing material, printing of pamphlets, posters, etc. without the names and addresses of the printer and the publisher. Promoting hatred between classes, promoting class enmity in connection with elections based on religion, race, caste, community, or language. Providing false information, concealing information in his nomination paper or affidavit, holding public meetings exceeding authorized time, during the period of 48 hours ending with an hour fixed for the conclusion of the poll. Booth capturing is a crime. Defacing, damaging, or removing any list, notice, or other document affixed by or under the authority of a returning officer, etc. Failure to maintain voting secrecy. Officers, etc. are not allowed to campaign for candidates or influence votes. The removal of ballot papers from voting places. Other offenses: canvassing in or around a voting place on election day. On the day of the election, disorderly conduct at or near voting places. Misconduct at the polling booth. Failure to follow the voting procedure. Breach of official duty in relation to an election. Election agents, polling agents, and counting agents are government employees. Bringing a firearm to or near a polling place. Employees are not given paid time off on election day. On election day, no one may sell, give, or distribute liquor. Paid news, any news or analysis appearing in media, print, and electronic, for a price in cash or kind as consideration. Press Council of India. Negative impacts of paid news, reflection of money power. The payment is mostly made in cash or kind and violates income tax and election expenditure laws. Hits the bottom of democracy. Such news has a big impact on voter voting behavior since the viewer does not obtain a clear picture of the candidate's personality or performance and hence cannot determine who to vote for. This undermines the basic foundations of democracy. Affects people's thinking and opinion by not letting them know that the news is in fact an advertisement and denies them the right to information. Affects free and fair elections by spreading political agenda and giving an edge to people with connections with news channels. Affects independence of media. This is the fourth pillar of democracy and brings the faith of people in media down. Implications of paid news not being an electoral offense. Lacunian paid news. Contestants who use paid news can only be hauled up for failing to include the expenses involved in their campaign accounts. Does not require the candidate to distance himself or herself from paid news on relevant time and not post facto. Bias and false news. The public does not get a correct picture of the political party or the candidate, as the news published regarding their work is biased and false. Way forward. According to the department-related Parliamentary Standing Committee on Information Technology, subjecting the financial accounts of media houses, especially revenue sources, for suspected paid news. Establishing a single regulatory authority for both print and electronic media. Formulating stringent guidelines for news media on poll coverage by the Press Council of India. Naming and shaming of media houses involved in paid news. Define paid political news so that the Press Council of India can issue suitable guidelines. It is necessary to modify the Representation of the People Act of 1951 to make paid news an electoral offense. Political parties and candidates must closely adhere to the Election Commission's expenditure ceilings. The people should be sensitized by creating awareness among themselves and seeking partnerships with all stakeholders, including political parties and media. The Law Commission recommended that paid news be made an electoral offense in its 255th report on electoral reforms, which was given to the government in March 2015. The issue of paid news poses a new challenge, especially in the digital age. Therefore, it is vital that the issue of paid news is tackled to ensure elections are free and fair. Keywords: stringent guidelines, lacunae paid news, hits the bottom of democracy, money power, false information, exit polls, bias, and false news. Voting rights to non-resident Indians through postal ballot, EDBS, electronically transmitted postal ballot system, EDBS, is the Election Commission of India's flagship IT program. It is a type of postal voting in which ballot papers are distributed electronically to voters and returned by post. These registered voters are referred to as service voters. For the first time, it is possible to register as a service voter online through a dedicated portal. It is a fully secured system with 2 security layers. The use of OTP and PIN ensures the confidentiality of voting. It has a unique QR code in the portal that prevents duplication of casted ETP. Following the 2014 Lok Sabha elections, a 12-member committee was formed to investigate NRI voting through 3 channels: voting by post, voting at an Indian mission abroad, and internet voting. Finally, in 2015, the panel suggested that NRIs be offered additional alternative options of the e-postal ballot and proxy voting in addition to voting in person. Existing process for NRIs: voting rights introduced in 2011. Voting rights for NRIs were introduced only in 2011 through an amendment to the Representation of the People Act 1950. NRI can vote in his constituency, and NRI can vote in the constituency located in his place of residence, as mentioned in the passport. Can vote only in person. Hisha can only vote in person and will have to produce her passport in original at the polling station for establishing identity. Challenges: identification of voters. Questions regarding the identity of voters can be raised as representatives of political parties may not be present at the venue of voting. Policing and security. The EC will have to come up with ways to ensure how these venues can be policed and secured. Model code of conduct. Foreign governments are not bound to maintain a silence period before polling, so it will have to be discussed how MCC is not breached. Way forward. Need to address logistical challenges. As per the Ministry of External Affairs, huge logistical challenges need to be addressed and a realistic assessment of requirements needs to be made before the proposal is implemented. Voting facilitation at embassies are insufficient. Actual voting facilitation, voter identification, and voting locations in the event that embassies and consulates are insufficient to accommodate all voters. Previous year questions. 1. Discuss the procedures to decide the disputes arising out of the election of a member of the Parliament or state legislature under the Representation of the People Act, 1951. What are the grounds on which the election of any returned candidate may be declared void? What remedy is available to the aggrieved party against the decision? Refer to the case laws. 2022. 2. There is a need for simplification of procedure for disqualification of persons found guilty of corrupt practices under the Representation of People's Act. Comment. Answer in 150 words. 2020. 3. On what grounds a people's representative can be disqualified under the Representation of People's Act, 1951? Also, mention the remedies available to such a person against his disqualification. 250 words, 15 marks. 2019. Keywords: vernacular languages, facilitate feedback mechanism, electronically transmitted postal ballot system, false publication, booth capturing, bureaucratization of politic, free, and fair elections. 31 comparison of the Indian constitutional scheme with other countries. India and USA. Attributes: USA, India. Nature of the Constitution. The United States Constitution is the first drafted and shortest constitution in history. With only 7 articles and 27 amendments, the United States Constitution is a highly restrictive instrument. India's constitution is the world's longest written constitution. It consists of 470 articles and 25 parts, 12 schedules, and 5 appendices. Nature of federalism. The USA is an unbreakable union of unbreakable nations. Because the federal government and the states each have their own constitutions and do not interfere with each other's operations. Symmetrical federalism, equal representation for all states in the Senate under symmetrical federalism. The legislative federation is heavily influenced by the states. For residual subjects, there is no elaborate mechanism provided. India is an indestructible union of destructible states. There is only one constitution in India, and it forbids the central government from interfering with state government operations. For example, reserving state bills for the president's approval, appointing governors, and imposing the president's rule in the states. Asymmetrical federalism. States have been given representation in Rajya Sabha in accordance with their population. The 7th schedule of the Indian Constitution divides legislative power between the federal and state governments. There are residual rights for the legislature. Government structure. A presidential system of government in which the electorate chooses the head of state. The president has great authority and is not subject to the House of Congress. The American president's term is 4 years long, and he is only permitted to serve in that capacity twice. The president has a valid veto. India now has a parliamentary system of government. The executive branch of the Indian government is led by the President of India. He is indirectly chosen by the state and federal legislatures and is not answerable to the parliament. The term of office for the Indian president is 5 years. He is eligible to be elected any number of times. There is no qualified veto available to the president. In contrast to the U.S., the Indian Constitution does not provide a deadline for the president to sign a bill. Impeachment of the president. Treason, bribery, and high crimes of a misdemeanor are the reasons. In the Indian Constitution, there is a system of impeachment for constitutional violations. Office of the Vice President. A vice president may become a president because of a vacancy in the office of the president. He is the ex officio chairperson of the Senate and has a casting vote. The office of the Indian vice president is modeled on the U.S. office with some differences. For example, he can hold the office of president in case of a vacancy only till the new president is not elected. Citizenship. People in the United States have two citizenship, one as a citizen of the United States and the other as a citizen of their respective state. India, on the other hand, has a constitution and the principal citizenship for all of its people. Legislature. It consists of two houses, House of Representatives and the Senate. House of Representatives, one of the weakest lower houses in the world. It consists of 435 members. Representation of people may differ in number from different states. Senate. The body is permanent. The world's most powerful upper house. Ordinary bills, amendment bills, and money bills all fall under its jurisdiction. Senators serve 6-year terms. Every 2 years, 1/3 of the member senators leave. The terms of the legislature and the executive are both fixed and independent of one another. A member of the executive cannot be a member of the legislature. The House of Representatives and Senate are very much similar to the Lok Sabha and Rajya Sabha of India, respectively. In India, the executive comes from the legislature and falls under its ambit. The president is a member of the Union Executive. However, since the president must act with the support and counsel of the Council of Ministers, the Prime Minister and the latter constitute the genuine executive. Fundamental rights. No one's life or freedom can be taken away in the United States without due process of law. Due process refers to the requirement that the substance and practice of the law be just, equal, and equitable, as determined by the judiciary. The legislative power to take away a person's liberty is restricted, and the judiciary scrutinizes and evaluates it. A person's life and liberty can be taken away in India according to the procedure established by law. The phrase procedure defined by statute gives the legislature broad discretionary power to limit liberty. Checks and balances. The doctrine of separation of powers is enshrined in the U.S. Constitution. Through judicial oversight of executive and legislative actions, the judiciary keeps an eye on the other branches of government. In India, the executive and legislature are tightly interwoven, and the judiciary is acting somewhat independently. Emergency. The American Constitution does not use the term emergency, but it does state that the writ of habeas corpus may be suspended in the event of rebellion and invasion of public safety. An emergency may be declared in India if there is a war or armed rebellion. All fundamental rights, with the exception of the right to life, Article 21, may be suspended in an emergency. Judiciary. Judges are appointed by the President and confirmed by the Senate, and they are removed by the Congress and the President by impeachment. The President controls their salaries and emoluments. Judges of the Supreme Court are appointed without regard to any qualifications. India, on the other hand, employs a collegium method for appointing judges to the higher judiciary. Amendment of the Constitution. There are 2 ways to amend the Constitution. 1. Proposed by the Congress and ratified by the states. Amendment to be passed by 1/23 majority of both the houses. To be ratified by the state legislatures of at least 1/34 of the states. 2. Proposed by states and ratified by the states. 1/23 of the states should pass a resolution to this effect. They will communicate with the Congress. The Congress will call the convention. In the convention, it has to be ratified by 1/34 of the states. India's amendment process is simple and flexible. In India, only the parliament has the authority to recommend constitutional amendments, and the states have no say in the matter. Although some of the articles may be amended with a simple majority, others require a special majority, and some articles require ratification by more than half of the states. India and Britain. Nature. In the UK, there is no formal written constitution. There is no formal or codified version of the British Constitution. It was never framed by a constituent assembly. The British Constitution is a flexible constitutional structure. Since there is no distinction between a constitutional legislation and an ordinary law, it can be passed, changed, or repealed by a simple majority, 50% of the members present and voting, of the Parliament. The Indian Constitution is codified into various parts and schedules. The Indian Constitution, in contrast, is both flexible as well as rigid. Federal or unitary constitutions are the 2 types. In a unitary system, the center of power wields all of the government's authority, with the states acting as its adjuncts. The federal constitution establishes a split of authority between the states and the federal government, each of which is sovereign in its own area. Thus, the Indian constitution is federal with unitary aspects, unitary with federal elements, and quasi-federal in nature. Nature of state. The British Parliament, a sovereign body, has all of the government's powers. Federal nature. Powers are shared by the national and state governments. Sovereignty of Parliament. The only legislative body in the nation having limitless legislative authority is the British Parliament. Any statute may be passed, amended, or repealed by it. The legitimacy of legislation enacted by the British Parliament cannot be decided by the courts. Despite the fact that state legislatures exist, the Indian Parliament's legislative power approximately compares to that of the British Parliament. Judiciary effectively controls Parliament, and a complete mechanism of separation of power exists in India. Executive. It is made up of the civil servants' Privy Council, the permanent executive of the Council of Ministers, COM, the King, and the Prime Minister. The executive has individual legal responsibility. An executive is similar except in India, there is no individual legal responsibility. The executive is made up of ministers and bureaucrats. Nature of head of the state. A constitutional monarchy which is not incompatible with democracy. The king does not have any discretionary authority. Pasha is referred to as Golden Zero. King is said to have complete immunity and is unable to commit any wrongdoing. The president is the ceremonial head of the state and acts according to the aid and advice of the Council of Ministers. The president can be impeached if he or she violates the Constitution. Judiciary. The rule of law is protected by the fact that judges can only be dismissed from office for serious misbehavior and in accordance with a protocol that has been developed. For removal, it is necessary to obtain the approval of both houses of Parliament. The idea of basic structure has given the judiciary a powerful instrument with which to stifle any executive or legislative activity that it considers to be contrary to the Constitution's basic spirit. Other provisions like appointment and removal are very much similar to the UK's model. Legislature. The British Parliament is divided into two chambers, the House of Lords, whose authority is unfixed, and the House of Commons, whose membership is set at 650. Amendments, it may be proposed by the House of Lords and approved by them. But it only has limited authority. If it rejects a piece of law, it can only delay passage for up to a year. Bicameral legislature with fixed seats in both houses. The House of Lords is very much similar to the Rajya Sabha and the House of Commons is similar to the Lok Sabha. Speaker. Once a speaker, always a speaker is the rule in the United Kingdom. It denotes that a speaker's local constituency is uncontested. When a person is appointed speaker, he formally resigns from his political party. No such provisions conventions in India. It is not necessary for the speaker to resign from his party. Prime Minister in Britain, it is customary for the Prime Minister to solely be a member of the House of Commons. The PM can be a member of either House of Parliament. Shadow Cabinet. Shadow Cabinet members from the opposition party hold a similar portfolio as the minister. No provision for a shadow cabinet. India and France. Attributes France-India. Nature, it has a unitary form of government and a semi-presidential government. India is a parliamentary form of democracy with the president as its nominal head. Lawmaking power. The French parliament lacks dominant law-making. The legislature has a list of subjects on which it should pass legislation, while the president makes the law on the rest of the issues. With respect to lawmaking on the central list, as per the 7th schedule where the president has ordinance-making power only. Parliament. The French parliament is bicameral, consisting of two houses, National Assembly and the Senate. The National Assembly's significantly greater powers than the Senate's make the French bicameral system an unequal one. The Senate cannot be dissolved. Rajya Sabha has limited power as compared to Lok Sabha. Only in the case of constitutional amendment Rajya Sabha is on an equal footing with Lok Sabha in India. Secularism. Follows the rigid principle of secularism. The state does not support religious activities but also does not interfere in private religious practices. It prohibits any visible religious symbols in public spaces. This model leaves no scope for the idea of the state-supported religious reforms. Indian secularism respects all religions equally and is the best example of positive secularism. Amendment. Both the Houses of Parliament have to pass a resolution by a 35th majority. So rigid in nature, the president may also choose to refer to the amendment to the people by referendum. Blend of flexible and rigid. No provisions like referendums, etc. President. The president is elected for a fixed term, 5 years. The president shall be elected by an absolute majority of votes polled, second ballot system. The High Court of Justice will inquire about the impeachment of the president. No such body in India. President's impeachment follows constitutional provisions and Parliament is a body to do so. Prime Minister. The French Prime Minister is an advisor to the president, concept of cohabitation. Between the two positions, there is a division of functions rather than a division of power. The French president is in charge of foreign affairs and domestic issues. The PM, on the other hand, is in charge of the company's day-to-day operations, local government, and domestic matters. The real head of the government is the Prime Minister. Judiciary. The High Council of Justice nominates the judges. The President and members of the judiciary are in charge of this body. The President is also referred to as the guardian of the judiciary. The higher judiciary employs a collegium method for appointing judges to the higher judiciary. Oath is administered by the President, and the impeachment process completes under the oversight of the Parliament. India and Japan. Attribute Japan, India. Nature. The Constitution ensures a parliamentary form of government and a number of basic liberties. According to its provisions, the Emperor of Japan serves as the symbol of the state and of the unity of the people and performs only ceremonial duties without having any formal authority. Both have a written constitution. India has a flexible and rigid constitution compared to Japan's rigorous one. A unitary state is provided for by the Japanese constitution. Legislature. The Diet, which comprises the House of Representatives and the House of Councillors, has legislative authority. The Parliament is the highest legislative body in both countries. The no-confidence motion caused the House to be dissolved, much like in India. Members of Japan's upper house serve 6-year terms, and each year, half of the members leave the chamber. Executive. The Emperor, under the direction of the Diet, appoints the Prime Minister, who serves as the head of the executive branch. He must be both a civilian and a member of one of the Diet's houses. In Japan, ministers are appointed by the Prime Minister, but in the case of India, it is appointed by the President on the advice of the PM. Judiciary. The Supreme Court and lower courts are given judicial authority. Japan is typically regarded in academic studies as a constitutional monarchy with a civil law system. Japan and India share comparable laws regarding the appointment, removal, and fixed retirement age of judges. The Diet appoints judges. However, there is no function for parliament in India. India and South Africa. Attributes about nature of the South African Constitution. The Republic of South Africa is described as a democratic and independent nation in Section 1 of the South African Constitution. It rests its moral principles on universal adult suffrage, human equality, dignity, non-racism, the advancement of human rights, and non-sexism. It also supports a multi-party system, the rule of law, and fair elections. Borrowed from SA Constitution. The process through which amendments are put into effect after receiving a 2/3 vote in Parliament. Rational representation is used by the state legislatures to choose the Rajya Sabha's members. Similarities. The words, "we the people," are the first words in the preamble of the constitutions of both countries, signifying that the people are sovereign and that the Constitution derives its power from them. Under the Indian and South African constitutions, respectively, the Fundamental Rights and Bill of Rights serve as the cornerstones of the legal system and democracy. Both give the state some latitude in its efforts to improve the lot of the weak and marginalized. Similar to the South African Constitution, a 2/3 majority in Parliament is required to modify some provisions of the Indian Constitution. Differences. In India, the right to vote, which is mentioned in the Bill of Rights, only has the status of a statutory legal right. It is not considered to be one of the fundamental rights. The 44th Constitutional Amendment relocated the right to property, which is included in the Bill of Rights, from Part 3 of the Constitution to Article 300A, reducing it to the status of a legal right. The Bill of Rights' inclusion of the right to information is exclusively a legislative right in India. Previous year questions. 1. Analyze the distinguishing features of the notion of the right to equality in the constitutions of the USA and India. 2021. 2. What can France learn from the Indian Constitution's approach to secularism? 2019, 3. Compare and contrast the British and Indian approaches to parliamentary sovereignty. 2023. Keywords: unbreakable union of unbreakable nations, indestructible union of destructible states, constitutional violations, shadow cabinet, constitutional monarchy, positive secularism, democratic centralism, the Diet, constitutional monarchy with a civil law system. Our content OnlyIAS. UPSC Wallah. Books. OnlyIAS Sni carat O carat Iknianti. Ancient India. Free material. JM, 33M carat U asterisk H greater than 2024 PM 1024. 9 penal asterisk 1 UDN carat OOE3 ENIZD. Free material. Comprehensive coverage. 11-year PYQ solution prelims plus mains. UDN prelims static revision. UDN plus 500 prelims current affairs revision. PNLVUL carat Haynes Wallah. Mains revision. Monthly current affairs magazine. Mobthief 2023. W asterisk monthly editorial. Wallah. You happy face M happy face HHB asterisk asterisk WRSRI? For UPSC Civil Services exam. Current affairs. Monthly editorial compilation. Free material. Quick revision booklets. IB2 asterisk 5 asterisk 1. Prelims wallet test. Copyright ES, L, UPSC PRNR FEL MBH.